Hi everyone, I'm here with the much awaited marathon for June 26, for December 26, and thereafter. Right, so this is basically part one of the marathon where we are covering Companies Act. There will be part two also, wherein we will discuss the remaining chapter, which is going to be uploaded soon. So don't worry on that part. Now, a few things. First of all, if I talk about the marathon, it's absolutely according to CMA Institute syllabus. It is comprehensive, it is detailed, yet concise, and yet quick, right? So, if you go through the marathon, it's in 100% English. We have a separate marathon uploaded for a mix of Hindi and English for the students who are not very well versed or who find it comfortable to study in their native language or Hindi, right? Now, if you go through this particular marathon, you will find that I have not spoken like any irrelevant talks in between the marathon or anything like that. So it's complete, pure, sheer revision, which is going to be very effective. I am saying again, it's a revision which is going to be very effective. It is not the replacement of the main classes. We have a beautifully designed, structured classes where you read the concept. We have a beautiful set of 7 books where you have 2 main books from which we read the concept and we gain that understanding, practical approach, and everything, right? And thereafter we do the questions from the question bank, we revise from the chart book, that is the summary book. Then there is a test series also which is being given to you, which has beautifully structured answers according to the marking scheme and everything, which helps you prepare in entirety. So if you are seeing the classes for the very first time, or if you haven't read law at all, I wouldn't advise you to directly jump to the revision and do it. First, go for the classes, do it in entirety, and that's going to provide you the entire solution. Okay, so that can be found on our website, bookmyvideo.in, or you can always contact our office support number. Now, as regards this marathon, enjoy. Part 2 is going to be uploaded soon. And of course, I have used my chart book in the entire revision. If you see, this is the chart book that I have used. Every student might be comfortable with some material that they have prepared. If you have prepared some short notes, or maybe you can take a book and you can easily revise, that's not a problem. But if you're comfortable with this particular chart book and you find that no ma'am, this helps me revise the core part and the crux of any provision very easily and beautifully, but I'm not able to, or I'm not looking for that physical copy, because undoubtedly we ask the child or the student that okay, you should go for the physical books only because that's more comfortable and good to study with. But if you are not comfortable with that, or for any reason you don't want that, then there is also a digital version which is available on our Android app, Book My Video. So you can check out that and you can go for that, right? So let's begin our marathon. Let's start the revision. So let's now revise the very first chapter of Companies Act, that is Companies Formation and Conversion. Now, this particular chapter, if I talk about, has a lot of content. Content number one, that is chapter 1 of Companies Act 2013, which talks about certain definitions and that preliminary part. Then we have chapter 2, which talks about incorporation, starting from section number 3 to 22, right? That we have some part of conversion of LLP to company and vice versa. And then we also have some portion related to chapter 22 of Companies Act, which talks about companies incorporated outside India. So all this part we have to read in this particular chapter. Okay, so if I start with the very first thing, that is the meaning of company. What do you mean by the company? Company means company which is incorporated under Companies Act or under any previous law. What is previous law? Companies Act 1956, Companies Act 1913, 1882. So there are a lot of previous laws. Now, basics of this particular act are hardly asked, but you should know about it. So the Companies Act 2013 came up with 470 sections and 7 schedules. Now we do not have 470 sections. There are some sections which have been deleted, some have been added, right? So entire act is divided into 29 chapters and it got the assent of the president also on 29th August and notified on 30th August, right? So certain basics you should know. If I start with the very first section, it is all about extend, that it extends to whole of India, then applicability, then it's going to be applicable on all the companies which are incorporated under this act, insurance, electricity, banking. So far their provisions are consistent with the respective acts. Like if Banking Act says do this and Companies Act also says do this, right? Because both the acts are saying something, or maybe Banking Act is silent, but Companies Act is saying you to do something, do that, right? But the problem is Banking Act says that prepare your financials like this, but Companies Act says that prepare your financials like this. You will follow Banking Act. So that is what it means. Wherever there is no harmony, you have to go with the specific act. Fine. That is going to supersede. Okay. Next, we have very basics. Characteristics of features of the company. What are the features of the company? First is independent corporate existence. What do we mean by that? Basically, company, you have a separate identity from your members. Very well established in the case of Salomon and Salomon Company Limited also. I don't think I need to explain you this, right? Next, we have limited liability. Now, when I talk about limited liability, the company may be formed as limited by shares, limited by guarantee, or an unlimited company. Now, when I say this, company's liability is not limited or unlimited, its members' liability is limited or unlimited, right? So it may be limited by shares, limited by guarantee, or an unlimited company. Undoubtedly, nobody would actually want to form an unlimited company, because that's the biggest advantage of forming a company. If you're doing some proprietorship business, anyways, your liability is unlimited, right? You switch to a corporate world. Why? To get benefit of these things, right? Now, limited by shares would mean what? If I have agreed to buy 2 shares of a particular company and each share price is 100, so I have to pay 200 to the company. Now, right now, I have just paid 50% of the amount, that is 100 rupees to the company. So, my liability towards the company is that 100. That is, my liability is limited to the amount unpaid, to the unpaid amount on shares held by me. What is that unpaid amount? It's 100. If I say that my liability, or it is a company limited by guarantee, it may be with share capital or without. If it is limited by guarantee, that means I have agreed to a certain amount, right? That if at all the company is now going to be wound up and the company's assets don't meet the requirement, maybe the assets, if you sell all the assets, the total is coming out to be 1 crores only. So you have sold the assets and you have realized amount of 1 crores only, but you have a liability of 1.5 crores to pay. So now all the members who had given guarantee will be asked to contribute the money. But can I be asked to contribute whatever amount they want, like that 50 lakhs which is pending, or 50 lakhs that is the shortfall? No. My liability in this case would be limited to the guarantee amount plus the unpaid amount on shares if the company is with share capital, right? What is that guarantee amount? Maybe 1 lakh, 5 lakh, 10 lakh, whatever it is. Okay, next we have perpetual succession. What is perpetual succession? It doesn't matter who comes, who goes, the company is going to go on forever and ever, ever, and ever, right? So members may come, members may change, it doesn't matter. Fine. Okay, then you have separate property as separate owner. That is, if the company has a land, I am the shareholder who has started the company. I am the promoter. I am the director. I have invested in the company, but still that property does not belong to me. So I cannot claim myself to be the owner of that property. Fine. So the company becomes the owner of its capital, its assets. The shareholders are not actually the joint owners of that company's property. Fine. Then we have transferability of shares. Now, although In case of private company, the shares are not freely transferable, but in all types of companies, shares can be transferred. So shares are movable property. It can be transferred from one person to another. Then we have common seal, which is obviously not mandatory now, but yes, it is the official signature of a company. But now some companies may have common seal, some companies may not have common seal. Next, we come to the lifting of corporate veil. What is corporate veil? Basically, corporate veil is a kind of curtain, okay, a kind of concept that you are running, you have invested in a company, or maybe you are directing the company or managing the company, but company is responsible for its acts. If company does not do this, then company will be responsible. The persons who are running the company will not be responsible. So these people are actually, these members are actually shielded from the liability which is connected to company's action. Okay, he is my son, but he's responsible for his own actions. That is how it is. Fine. So that is how there's a shield, that he is different, I am different, right? So the company is different and I am different. So I'm shielded. But sometimes maybe he's too small and I am asking him to do something. So I should take that accountability and responsibility also for all the wrongdoings, right? In the same manner, if the company is actually being run by these people and there is a case of fraud or something like that, the court would disregard that you are different, you are different. They would lift the curtain and actually pay attention to these individual members who are actually responsible for all the wrongdoings. So when the court disregards the corporate entity and when law ignores the company and concern themselves directly with the managers or the members, that is actually called as lifting of corporate veil. You will see throughout Companies Act that at a lot of cases, at a lot of times, the corporate veil has been lifted, right? That if you give if there is misstatement in prospectus, the people behind will be punished. So that's lifting of corporate veil only. But where has it been done under judicial interpretations is that what we are going to read now. Fine. Okay. So we have all these cases. What are all these cases? The first one is trading with enemy, right? Now, when I say trading with the enemy, it is basically about determining the enemy character. There was a famous case law of Daimler Company Limited versus Continental Tire and Rubber Company Limited, right? So you have to check whether it is my enemy or it is my friend. So there is a company registered maybe in England and controlled by certain German shareholders, right? Now, prima facie, if you look at that particular company, you'll be like, it is an England based company, right? But when this England is at war with Germany, this company is actually run by those German shareholders, right? So court will look at the real control, that is the shareholders. So this company's nationality would actually depend upon who controls it rather than where it is incorporated, because right now we are trying to determine whether it's an enemy or not. So in that case, the court will lift the corporate veil and look behind the real persons. The next one, we have laws of taxes and duties. That is basically the protection of revenue, the famous case of Dinshaw Menegji Pettit, right? So what happened, that the SSE, the person had formed multiple companies. Why? Because he had too much of income. So he had to transfer. What he did is he formed a lot of companies, he transferred the income just to avoid tax. So the court lifted the corporate veil, said you cannot just form the companies just for the purpose of avoiding or evading tax. Fine. Next is avoidance of welfare legislation. Avoidance of welfare legislation is the basically covered in the case of rubber industry, right? A workman of Associated Rubber Industry versus Associated Rubber Industry. Now, again, it was found that the company had this much profit, and because it had this much profit, it had to adequately pay the bonus also. But just to avoid or reducing the amount of bonus, the person formed another company and transferred certain things to avoid this welfare legislation. You cannot do that. So in that case also, the corporate veil was lifted. Fine. Next, we have to protect public policy, right? To protect public policy is something which is very simple. Many a times it may happen. It also happened in the case of Canoes and Canoes versus Canoes Limited, right? So company, if you're using it for any unjust, unfair purposes, then which is affecting public, the corporate wheel may be lifted, right? Next, you have transfer of shares of company, which was actually sale of land. Now, supposedly I have to transfer my land to you, but there is some restriction by law on me, right? So I cannot transfer my land. Now imagine this to be the companies, right? So if I cannot transfer the land directly, what I did is transferred all the shares. So ultimately the ownership got, and they can use it the way they want to, right? So eventually it is resulting in the sale of land, which should not be happening, right? So the transfer of shares of company which actually was sale of land, and which the original allottee was prohibited to do, but happened. Okay. Then formation of subsidiary to act as agent. Many a times you have a lot of subsidiaries, and that's absolutely allowed. So company, you may have subsidiary, but sometimes when you form a subsidiary just to maybe acquire some license, just to do something, why are you doing that? Because um, you are not getting that, right? So subsidiary is not doing any business, but merely acting as your agent and doing all that you are instructing it to do, right? So if that is happening, we had a beautiful case law also, we have discussed that, but right now I'm just because it's a revision class and we cannot stretch it so much, so I'm just trying to explain you that how it happens. Fine. Next, we have Kasi criminal cases. See, Kasi criminal cases, basically they are like civil cases, but then criminal liability may be inflicted. So undoubtedly, if there's a case of fraud or cheating, the court will undoubtedly lift that corporate wheel to find out who has actually done this fraud, who is responsible for cheating, right? So who has hidden the money and everything, right? So that will be the case. And to avoid legal obligations is again coming down to the same thing, that you might be obliged or you may be obligated by law that okay, you have to do this, but just to avoid that legal obligation or welfare legislation as we have just read, you may be lifting that corporate wheel. Okay. Next, we move to nature of business organization in India. Basically, you can say what do you mean by social sector or the business organization in India, or maybe categorize the sectors on the basis of government ownership, because here we are talking about public sector and joint sector, and then we have an absolute private sector, right? So public sector, it's which is owned by government, which has majority of government stake. Joint sector, where government has invested but not in majority, right? And then we have the private sector. So government sector, government has joint sector, government has invested 26 to 50%. In public sector, we have government companies, which we talk about, where the stake is 51% or more of government. Then we have statutory corporations like RBI. We also have government departments like railways, postal services, etc. Okay. Now, companies are classified according to different types of classification. We have companies which are registered companies, companies on the basis of liability, companies on the basis of incorporation, as I said, registered company and statutory company, what we call. The main and the most important one is companies on the basis of members. Because when you look at section number 3, which talks about the formation of company, you will realize that a company may be formed as a public company with minimum 7 members, as a private company with 2 members minimum, or as OPC with just 1 member, right? So this is what you will see even in section 3. So when we're talking about a government company, or when we're talking about a section 8 company or any other different type of company, eventually they are either private or public. Okay. So prima facie classification is this, and we're going to start with the classification, and let's try to understand what do we mean by a private company. Although of course you have read this before, and that these are very simple concepts that we're revising, so we'll be a little quick. But what is actually private company? So private company is basically a company with the minimum paid up capital as prescribed. That is one thing, right? What has been prescribed as minimum paid up capital? Nothing has been prescribed. The second thing which comes, The second thing which comes is that its articles are going to have restriction, prohibition, and limitation. Now, what type of restriction, prohibition, and limitation? Now, when I talk about restriction, right, restriction on the transferability of shares. Transferability of shares, that means the shares cannot be transferred, but just you said to us in the features that shares can be transferred, right? Transferability of shares, that is one of the features of a company. So yes, we're not talking about prohibition, we're talking about restriction. So, in the articles of a private company, there will be clearly mentioned that the shares cannot be freely transferable. They can be transferred subject to these conditions. So, companies frame their own cases and all of that, that you need to ask other members, etc., etc. Okay. The second one is prohibition. Prohibition to invite public to subscribe to the securities. That means a private company can actually never make a public offer. That means its shares can never be listed. Ideally, no. Its securities can never be listed. Well, they can be listed. I have told this very clearly even in listed company definition that yes, SEBI regulations do allow the listing of debt securities by a private company, but of course there's a platform, right? So things are very different. So ideally, a private company cannot be a listed company, and according to Companies Act, undoubtedly no, because the definition of listed company has been restricted now. Okay. The third one is limitation on number of members. Limitation on number of members means it limits the number of members to 200. So minimum number of members 2 and maximum number of members 200. Now when I am saying about this particular limit, you have to understand one more thing, that whenever there is a joint holder, A and B jointly hold the shares, they are not going to be counted as 2 members, but they are going to be counted as one single member only. First thing. Second thing, if the shares are being issued to the employees, right, in pursuance of their employment, like we have a SOP and all of that, right? So the employees are also not going to be counted in the list limit of 200. So if there are already 190 members in a private company and there are 20 employees to whom a SOP is given and shares are issued, they're not going to be counted in the limit of 200, and it's well in compliance with this particular section. Even if they leave the job and go somewhere other place, but because they had acquired the shares because of their virtue of employment, they will still not be counted in the limit. So present and past employees are not counted. Fine. Okay. When I talk about one person company, it is nothing but a type of private company only. Fine. Okay. Next we come to public company. Now public company is not a private company. Very simple. So articles will not have those 3 clauses of restriction, limitation, prohibition. The shares are freely transferable. There is again no minimum paid up capital requirement, because the definition itself only says 2 things, 3 things prima facie, I should say. Public company means a company which is not a private company and has a minimum paid up capital as prescribed. So nothing has been prescribed. Okay. Minimum number of members 7. Maximum, there's no limit at all. Okay. Then we have one twisting point in this particular definition. That is the only point that you need to understand. What is that point? Subsidiary of a public company is deemed to be a public company. Subsidiary of a public company is deemed to be a public company. Now, what exactly do we mean by this? We all know the concept of subsidiary, although I've not revised it, but you have read it, right? So you know it. When I say that there is a company A Limited and it holds 60% shares of B Limited, so I can very well conclude that this is B Limited is a subsidiary and A Limited, my dear, is holding, correct? Now, A Limited, it's a public company. B Limited, it is also a public company, right? So the case is very simple. If I make this B Private Limited, now what is going to happen is this is a private company which is actually a subsidiary of a public company. Now, although the situation seems to be fine and absolutely okay, but the point is that if this is a public company, maybe it has raised some funds, maybe it is because public companies obviously are exposed to more compliances and they are supposed to be more transparent, right, and accountable. Now this money is actually flowing to a private entity where less disclosures and accountability should be there. No. So ideally, if this is a situation, then this private company will be deemed to be a public company for all the compliances. Not you don't necessarily need to convert yourself and become a public company because you are a subsidiary of a public company. No, even if your articles have those restrictions and everything, the name is a private limited, still you need to comply with all the provisions. That is what the intended meaning is. Okay. Next, we move to one-person company. Now, I know still there is a lot of confusion about one-person company. I don't know why it is, but then you have to understand and you have to forget certain points. Okay, I will start from the very beginning. First of all, there has to be just minimum one member and maximum one member only. Directors, if I talk about, you have read the provisions of directors. We'll be revising directors also. Directors maximum is 15 only in case of all types of companies. However, this can further be increased and we know about it. Okay. Now, when I talk about one-person company, there is again no minimum paid up capital. There's nothing which has been prescribed. What is there is that memorandum of one-person company will have a name. Which name? Name of a nominee. Nominee means in case the sole member dies or becomes incapable to enter into a contract, then this nominee will take place of that sole member. Now, if somebody comes to me and asks me that, will you become my nominee? I have to give my consent. You cannot write my name that, okay, she is competent, I'll write her name. That if something happens, then she will take my place. No, you have to take that consent. So that consent will be taken, it will be filed. Anytime if the person feels, no, I don't want to take this responsibility, you can withdraw the consent. Anytime if you feel, the sole member feels that no, he or she might not be able to take that responsibility, or I don't want to give that to that particular person, you can change the nominee. Okay, so this can be done either ways, right? Now the question is, ma'am, who can? There is just one member which is allowed in case of one-person company. So who will be or who can be that one person? Can it be some company or body corporate? The answer is a big no. Because in case of private company or public company, when I'm talking about, let's say 7 members here, it can be individual, it can be body corporate, not a problem, but not in case of one-person company, because this concept has been introduced to support the budding entrepreneurs, right? Okay, so it is only and only for the individuals. Fine? Okay. So first of all, it has to be a natural person. It cannot be a legal or an artificial person. It has to be a natural person. Secondly, it has to be an Indian citizen. Thirdly, it may or may not be the resident. That is what the provision is now. Okay, so whether resident in India or not, although the definition of resident has been specified, has been given, yet it doesn't matter to us whether a person is resident or not. He can still incorporate OPC or be a nominee of it. So shall be eligible to incorporate OPC and also be eligible to become nominee of OPC. But the question is, but the point is, minor cannot be the member or the nominee. This is something that you have to remember. And then you have to remember 2 more restrictions. OPC cannot be a Section 8 company. It cannot be converted into Section 8 company, and it can be converted into private and public company if you want to. There is no compulsory conversion that you have read before, right? That has been deleted. And OPC cannot carry out NBFC activities or invest in the securities of any body corporate. So if you have incorporated OPC and you want to buy the shares of another company, this company wants to buy the shares of another company, you cannot do that. You cannot invest in the securities of any body corporate, and you cannot even carry out NBFC activities. Okay. At one point of time, you are going to be member of only and only one OPC. You cannot become member of 2 OPCs. Fine. You can be the member of one OPC and nominee of another. That is absolutely fine. Okay. And eventually, if it happens that you are a member of one OPC and you are a nominee of one OPC, and here also the sole member dies and you become the member of this OPC also, so now you are eventually a member of 2 OPCs. Then you have to choose one within 180 days. Got it? Okay. Next, we come on the basis of control. We have holding company, we have subsidiary company, we have associate company. Now, before I talk about holding company, I think it's best to talk about subsidiary company, right? Because once you understand the concept of subsidiary, then it's obviously easier to understand holding, because there's nothing special in the definition of holding company. Now, first of all, it is a relative concept. Secondly, we are not talking about an individual holding 60% shares in a company. So it is holding and it is subsidiary. No, it is in relation to any other company, and a company which holds, right? So we're talking about that only. We also talk about body corporates. There also we have the concept of subsidiary and holding. So company in which the holding company either controls the composition of board of director or has more than half of voting power with or without its subsidiaries, which means that if I say A Limited, you have 50.0002%, this would also mean a subsidiary, because it's more than half. So more than half has not been defined, whatever more than half, right? But if it is only 50%, it cannot be called as subsidiary, right? Okay. So we have a company, you hold more than 50% shares of another company. This is your subsidiary. This you are going to be called as holding. Point number one. Point number two, you may be controlling the composition of board of directors. How do you control that? That's subjective and depends upon case to case. But yes, if you are actually someone who is deciding by virtue of your shareholding, by virtue of any agreement, it doesn't matter, then you can be called as the holding. Okay, now you may not be having the shares directly like this, but maybe through a subsidiary. Here you have just 30.2% shares of this particular company, but then there is another company, C Limited, wherein you hold 70% shares. So C Limited is your subsidiary, direct subsidiary, right? You hold more than half shares of this particular company, and C Limited holds, let's say, 25% shares of B Limited. So your direct shareholding is 30% plus your subsidiary's shareholding is 25%. So you together with your subsidiary would hold 55% shares of B Limited. This makes B Limited your subsidiary. So there can be two cases. Fine. Okay. Now, when I talk about subsidiary, there is a limit on layering. Layering means what? I hold shares of this holds shares of this holds shares of this. That is layering. I hold shares of this. I also hold shares of this. I also hold share of this. These are all layer one only. This is not layering, right? So I can have a number of subsidiaries, but my subsidiary has another subsidiary, has another subsidiary, has another subsidiary. This actually deviates the fund from the source to the use, right? So there is a long gap and it's difficult to trace where the money is actually coming from and where is it flowing, right? So that is why there has been a restriction which is put on. What is that restriction? That you cannot have more than the prescribed number of layers of subsidiaries. And what is that number prescribed to? So no company will have more than 2 layers of subsidiaries. However, it's not applicable in case of banking, insurance, government, and NBFC. Okay. Next, we come back to holding company. Holding company is ideally nothing in relation to another company. If you have any subsidiary, that means you're holding of that particular company. Next, we have the concept of associate company. What is exactly associate company? It is actually a bridge type of, you can say. If you have more than 50% shares, you become a subsidiary, right? Okay. If you have less than 20, that means maybe 19% shares, then you are nothing. As I gave you in the example also, like somebody you are adoring from a far distant is actually nothing, right? So your crush will not hold that much importance, right? But the moment they have some influence, that means maybe you are holding 20% or more shares, but less than 50. So hasn't become your wife yet, but is in the girlfriend phase. So this is actually associate, having significant influence in you. Okay, so in relation to another company in which other company which is not a subsidiary but has a significant influence or is a joint venture, then that would mean to be associate company. Fine. Now we have different types of companies on the basis of share capital also. With share capital, without share capital, I think I've told you this before. We also have on the basis of listing, listed, unlisted. So we'll come to that. Now we have some segregated other types of categories, which the very first one and the most popular one I would say is a small company. Small company, Section 2, Clause 85. I insist you all to remember this. Even private company, Section 2, Clause 68 should be remembered. Even subsidiary, Section 2, Clause 87. It should all, some definitions you should remember the clause numbers also. Okay. Now, small company, what do we mean by that? First of all, it's a private company. That means a public company cannot be a small company. Secondly, if you're a Section 8 company, you cannot be small company. If you're holding a subsidiary, you cannot be small company. If you're governed by some special act like insurance, etc., then again you cannot be small company. Fine. So first thing, get that clear, very clear. If in the question anything of this sort is written, then that particular company can never be classified as a small company. Next, you have to check the threshold. So basically, it's a private company which falls within that prescribed threshold. Now, what is the prescribed threshold? If I talk about the section, it is clearly written that the paid up share capital should not exceed 50 lakh or higher amount as may be prescribed, and turnover should not exceed 2 crores or higher amount as may be prescribed. What is prescribed? What is prescribed for June 26 attempt? That means all those who are going to give their exams in June 26, you have to write this limit only 4 crores and 40 crores. However, this has been further enhanced. Government had the capping. Government had the power to prescribe up to 10 crores, and government has fully utilized that power. Now whenever they want to amend further the definition of small company, they cannot do it by rules. They will have to amend the act. Okay, because right now the current prescribed limit is 10 crores and 100 crores. Okay, got it? So this is for all those who are going to attempt or give examination in December or thereafter. Right, so this is the limit that you have to remember, and for June 26 attempt, this is the limit that you have to remember. Got it? Okay. So that is small company, right? Small company has certain advantages, right? You don't have to hold 4 board meetings, right? You are not supposed to prepare cash flow statements. So all those advantages are there, which eventually you read. Next, we have Section 8 company. What is exactly Section 8 company? See, Section 8 company is formed for charitable purposes. That means you want to promote a religion, you want to promote sports, education, research, protect environment, all of that, right? So that can be done. Now, because you are doing it all charity, you need not use limited, private limited. Point number one. You are getting a lot of benefits and exemptions also. So no minimum number of directors are required. But to do this, you need to obtain license from central government. So when you are incorporating yourself, at that time only you make an application, right? That application of incorporation itself has that imbibed that application for license also. Okay, so you get the license. Fine. Now the question is that, ma'am, it is a charitable company. Fine, we are going to get some donation, we are going to work for certain causes. Maybe I got the donation of 1 crore and then I had spent only 80 lakhs. So 20 lakhs is the profit of this company. Whoever is the member of Section 8 company, we should distribute that profit. Well, it's not a profit making entity, it's not a profit making company. It is meant for charitable purposes, so you can never pay dividend. Such type of companies are absolutely prohibited. You cannot apply any profits for payment of dividend. It has to be used for, it has to be plowed back to the business, and it has to be used for promotion of these charitable objects only. Fine. Okay. Next, we have government company. Now, government company, as we discussed about that public sector also. What is government company? Company in which at least 51% of the capital. See, it is different from subsidiary company. In subsidiary company definition, you will see more than 50%, and here it's at least 51%. So remember that. At least 51% of the capital is either with central government, state government, or jointly by both. And in fact, even when I talk about ONGC, if you have any subsidiary, then the subsidiary is also going to be called as government company. So subsidiary of a government company is also a government company. Often students get confused that, okay, LIC has 60% shares of a company, so this will be a government company. Why? LIC is not a government company. LIC is a PFI. Although LIC has stake of government, that's a different thing. But here we are talking about subsidiary of a government company. LIC is not registered under Companies Act. LIC is not a government company. So get that straight. Don't be confused between government enterprises, PFIs, or all of that. Only if there is a subsidiary of government company, then that's going to be a government company. Otherwise, there's any company. Company means a company registered under Companies Act, in which at least 51% of the capital is with the government. Fine. Okay, foreign company will be doing a little later. Then we come to dormant company. What is dormant company? Section 455. Dormant company, supposedly you just found some very good asset and you friends have decided to do business later. So you just form a company, have that asset, hold that asset in company's name and just leave it. Now, what will happen in this, that ROC will be a little trouble that you have formed the company and you're not doing any business, because we also have section 12 where we have to, we also have section 10A, I would say, the commencement of business, where we have to tell that, okay, we have started with a business and all of that, right? When we can start the business, we need to do certain filing. And if we're not doing the business, ROC has the power that they can remove the name. So the name will be removed. So instead, what we can do is, if we are formed for holding just an asset and we are not doing any significant accounting transaction, or significant accounting transaction would not mean payment of any fees to ROC, or allotment of shares, or just maintaining the office and records, or just making certain payment for the compliance of act. It does not include all that. Apart from this, maybe we are buying some raw material. That's a significant accounting transaction. So if you're not doing any significant accounting transaction and we have been just formed for a future project or to hold an asset, we can make an application to ROC and obtain the status of dormancy. Fine. Apart from this, if there is an inactive company which means has not been carrying on any business during the last 2 financial years, has not made any significant accounting transactions, has not filed financial statements and annual returns during the last 2 financial years, right? So if you do this, you are also an inactive company. So inactive company can also make this application, and this company can also make an application like this. Fine. Okay. Next we come to other types of companies. Statutory and registered, I've already told you. If I talk about limited by shares, limited by guarantee, and unlimited, this also we have discussed when we were discussing about limited liability. Next, we have listed company. What exactly is listed company? See, a company is not listed on stock exchange, its securities are. So a company, which has any of its securities listed on a recognized stock exchange, is going to be called as a listed company. However, because listed companies are being exposed to a lot of compliances, right? Even when we talk about SEBI regulations, they have, and even under Companies Act, at a lot of places you'll see, okay, listed company has to have this, listed company has to have this, right? So for the purposes of Companies Act, they have slightly changed the definition of listed company. So they have incorporated a rule 2A which says that there are certain companies which we will not consider as listed companies only for the purposes of Companies Act. Okay. Now, what are those? If you have a private company who have listed their debt securities on private placement basis, right, which is allowed under SEBI regulations, they're not going to be treated as listed company. Point number 1. Now, if I talk about public companies which do not have their equity shares listed, but they may have their non-convertible debt securities listed or non-convertible preference shares listed, which they had originally issued on private placement basis. Okay. Then even those public companies which have listed their equity shares but not in the recognized stock exchange in India but in some foreign jurisdiction, so they are also not going to be called as listed companies when we are talking about Companies Act. Fine. And then we have unlisted companies. What are unlisted companies? Companies other than listed companies are called as unlisted companies. So they are also called as closely held company, and that is a general name which we have given, right? Okay. Then we have Nidhi companies. What are Nidhi companies? Now, earlier the definition of Nidhi companies was a slightly complex, which had the habit of promoting the habit of savings, etc., etc. But now it's very simple and very clear, although the intention is still the same. The companies which have or which promote the habit of savings amongst its members, right? But what they do is different, and what is the definition is different. So it is a mutual benefit society or a Nidhi company, right? What do we mean by that? Which central government may declare in the official gazette by a notification as a Nidhi or mutual benefit society company. Okay. They're formed with the object of promoting savings. That is one different thing. But as declared as Nidhi in the official gazette, that is the definition. So earlier there were a lot of Nidhi companies, unregulated, not exactly unregulated, I would say, but then people would get conned by it, right? So government has clearly said that if you want to be a Nidhi company, you have to make an application to us, and we will actually by notification in official gazette declare you to be a Nidhi company, and then only you can be doing that Nidhi company functions. Okay, otherwise you will not be called as a Nidhi company. Fine. So that is one thing. Then we have public financial institutions. Now you have to learn LIC, IDFCL, UTI, the institutions which were notified under Companies Act 1956, right? Any other institution which may be notified. Which institutions can be notified? Then any establishment, entity which is established under Central State Act, like we have LIC, right? Or 51% or more capital is with CG or SG or both, right? So that is the criteria. There are more criteria based on which government actually classifies some financial institution as public financial institution. Okay, next we have the joint venture company. Very simple. Two parties have joint control over the arrangement, everything, right? And there's an agreement that is called as joint venture company. Then we have sectoral companies. Again, we all know, and that's something which is very simple. Sectoral companies means you fall into a particular specialized sector. Like we talk about insurance companies, they are the companies which fall in the insurance sector. We have banking companies, they fall in the banking sector, right? So they fall into, or they come under some specialized particular sector, right, which is regulated by government. Okay. So likewise, we have this NBFC banking companies, they all come under the banking sector only, right? NBFC is slightly different from banking companies because NBFC is also registered under Companies Act. It is also regulated, right? But it does not do the core business, core banking activities. Okay, so companies registered under the act, it is providing financial services to people. It is similar to banks, but they do not have the banking license. They cannot even accept demand deposits, right? So we have read about it, we have discussed about it. Banking company, you cannot commence your banking operations unless you obtain license from RBI. Likewise, insurance companies, you cannot commence your insurance business unless you obtain that license from IRDA. Okay. Next, we have section 464, which talks about illegal association. Now, if two people want to work, they have different ways of business organization, right? Like one person, they can go for sole proprietor, then maybe you can go for partnership. You also have AOPs, right? You have BOIs, right? They can work like this. But if it goes beyond a certain limit, in the section it says consisting of not more than 100, but the limit is set at 50. So if you have any partnership of more than 50, then it is not allowed unless it is registered as a company. That means we cannot have partnership of more than 50. Yes, you cannot have partnership of more than 50. Ma'am, I know a CMA firm or a CA firm which have a partners, which they have 60 partners in a firm. Well, the exception is HUF and the partnership which is formed by professionals which are governed by some special acts, like you have these CA members or etc. Right? So that is not allowed. If it exists, then there are going to be consequences. Body corporate will have no legal existence, right? The member would not be able to sue it, right? And they will be personally liable, right? Of course, you'll be getting that punishment and penalty. That's a different thing, right? So this is illegal. This will be treated as a legal association, and there will be consequences. Fine. Okay. Next, we move to ideally chapter 2, where we are going to talk about the incorporation of companies, starting with what is actually promoters agreement, and who the promoter is. Now, when I talk about promotion are basically those preliminary steps which a promoter takes to bring a company into existence, right? Because we just have a vision, and anyone who has that vision, who takes that effort, who brings in or arranges the funds, who does that feasibility study, right, who gather the people and prepare the documents, etc., that particular company person is going to be called as promoter. So promoter need not necessarily be an individual, it could be a company, it could be a firm and association. Fine. Okay. Now, when I'm talking about promoter, there is something also called as promoter's agreement. Fine. Or we may call it as memorandum of understanding. Now, what exactly do we mean by this? There could be one promoter, there could be many promoters, right? We have a prospective company. The company, you cannot enter into any contracts because you have not been formed yet, right? You are a prospective company, you will be formed in future. So promoters undertake a lot of decisions on behalf of the company, right? So they decide on various issues. Now, we know one thing for a fact that the promoters, if you do not have any agreement with the company after the company is incorporated for your remuneration as well, you will be not entitled, legally entitled to one, right? You can get it, great, but you if you don't get it, if the company denies, you cannot claim it actually, right? So the ones who are doing all these things for the company and deciding upon various issues, right, might want to note down certain things for their memory purposes. That is actually memorandum of understanding. It is not legal, it does not give you any right, it is not mandatory. It is only meant that okay, we are dealing with various issues, let's make a memorandum of understanding, right? And they can prepare it voluntarily if they want to. Fine. Once the company is formed, the promoter is going to disclose all the contracts. They are called as pre-incorporation contracts, and accordingly, the company may ratify it, the company may not ratify it. That you have read before, right? So, memorandum of understanding is simply an agreement which mentions various rights. And liabilities, and is not actually enforceable under law. So you might make a fool out of yourself if it is denied, but ultimately promoters form the company, they are eventually going to run the company, so whatever they want they can extract from the company. Fine. Okay, now we start with the process of incorporation of a company. Now when I'm saying process of incorporation, undoubtedly promoter is going to take that initial steps, but how do we identify somebody who is a promoter or not? Even under SEBI regulations, you will see at a lot of places the promoter groups, they might be liable for a lot of things, right? So SEBI ensures that okay, you tell who is your promoter, who is the included in the promoter group and everything. So promoter, how do we come to know? Promoter is somebody whose name you will find in the prospectus in the annual return, who may be controlling the company as a shareholder or director. The board may be acting on whose directions. So you can identify that this particular company, entity, person is actually a promoter. Right. Promoter can be changed during the lifetime of the company also. Right now, this particular person may be the promoter, he has died. Eventually, somebody else takes in that position. Why? Because he has gained a lot of shareholding, right? So eventually he is the one who is arranging funds for the company, right? Etc. etc. So maybe. So the promoters can change also. So promoter generates the idea of incorporating a company. When I talk about formation of a company, you already know that a company may be formed as a public company, private, or one-person company by subscribing the names to the memorandum and complying with the requirements of the act, right? So company may be limited by shares, it may be limited by guarantee, or it may be unlimited company, right? So all you have to do is first of all gather the people, right? Decide which type of company you have to form, accordingly gather the people, reserve the name of the company, obtain DSC, then whatever you have to, then draft the documents, draft other documents. You may also take help of the professional, right? File all the incorporation documents along with the necessary attachments and fees, and then obtain your certificate of incorporation. Once you've obtained your certificate of incorporation, thereafter, you have to comply with the section 10A, which talks about commencement of business, and then you're free to start the business. Fine. Okay, so these are all the steps. Now, there is one beautiful form which is going to be used in this process of incorporation, and that form is Spice Plus, right? It is an integrated one web form which offers prima facie 11 services by central government as well as state government, because in certain states there are certain things which are mandatory, like we have professional tax registration, and there are certain state registrations that needs to be done. So if you're starting a business and company is the form of business organization that you have decided upon, still, because you're starting a business, you'll be needing a bank account, you may be needing GST registration, right? You obviously, all the company formalities you have to do. So you have to reserve a name, you have to incorporate the company, you also need to get DIN, you also need PAN, TAN, right? So you need so many things. So undoubtedly, those things are already available. Apart from that, EPFO registration, ESIC registration, GST, right? Opening a bank account, shops and establishment registration, right? So there are a lot of other things also which might be needed, because you have to eventually do the business, and that can be done through a single window or a single form. Okay, so you have this form. This is accompanied by Agile Pro S, and it can be filled and filed. Now, this particular form is actually divided into two parts. We have part A and we have part B. It is always advisable that fill part A first, then part B, unless you are very sure that you're going to get the name allotted. Part A is for reservation of name. Once you reserve the name, it's going to be reserved for a certain tenure, and thereafter, within that tenure, you can fill this form and the company will be incorporated. Okay. CG has also established a CSC as well as CRC. CRC is the Central Registration Center. It is initiative of MCA, where for speedy registrations or incorporation of companies, you can say. And CSC is for scrutinizing the forms that are filed by the companies. Just like we also have CPC under Income Tax Act, Central Processing Center, where all the returns are centrally processed, right? So likewise, we also have this for carrying out incorporation, for speeding incorporation processes, and also for CSC for scrutinizing the forms. Clear? Okay. Now, let's proceed with the flow of the charts only, because you have already studied the chapter, so you probably know this. So what I can see on my screen is section 3A. Undoubtedly, it has been introduced after section 3, so it has a meaning over here. Now, it talks about the member's liability in certain cases. You very well know that a company may be formed with 7, 2, or 1 member, right? Public, private, or OPC likewise. Now, is it the minimum number of members only at the time of incorporation? The answer is no. It is needed at all times thereafter also. So once the company is incorporated with 7 members in case of a public company, let's say, but one of the member later on dies. So what will happen? The company is now running with only 6 members. Is it allowed? No, it is not allowed. So what should be done? You should try to find out and add any other member, or maybe convert it into private, because now your minimum number of members have reduced, right? So you can take any of the measures, and you have been given a time frame of 6 months. So if at any time after incorporation the number of members is reduced below 7 in case of public company, or below 2 in case of private company, then if the business is carried on after 6 months, till 6 months, it's absolutely fine. But after 6 months also with reduced members, then every member who knew this fact that yes, we are running this business with reduced number of members is going to be severally liable for the debts of the company contracted during that time. That means after expiry of 6 months. Okay. So that particular person is going to become personally liable. Fine. Okay. Now we talk about 2 basic documents, and then we will come to the process of incorporation, the actual process of incorporation, right? So 2 basic documents. which you should know about. First of all, we have Memorandum of Association, which is in Section 4. Or actually, it is defined in Section 2, Clause 56, but the definition does not speak volumes about what actually MOA is, because it only tells us Memorandum of Association means memorandum as originally framed or as altered from time to time. Now, what exactly it is? It is the most fundamental charter document of a company. It has been divided into different clauses. The first one is name clause, where we get to know that what is the name of the company. If it's public company, it's going to be with a suffix limited, private company, private limited, likewise. Situation clause, you don't write the full address of the company over here. All you write is the state in which it is registered. Fine. Object clause, the purpose for which it is incorporated. Purpose for which it is incorporated means what? It actually also relates to the doctrine of ultra vires. It defines the scope, what a company can do, what a company can't do. Right? So all that can be done by the company is stated over here. Then we have liability clause. Liability clause means what? The liability of the company is limited. Its members is limited, unlimited, limited by guarantee, limited by share capital, right? So what it is, amount undertaken to contribute, whatever it is. Then capital clause will again not have the actual paid up capital, but the registered share capital along with its division. And then succession clause, which exists only in case of OPC, because you write the name of the nominee, right? Many students also understand one more clause, that is subscription clause. Basically, these are the clauses, and thereafter you have the page where the members actually subscribe, they sign that okay, these are my details, and this is the shares which I undertake, which I agree to take, etc. And then there is signature and everything, right? Witness signature and all that. That is also there. Then we come to Articles of Association. What is Articles of Association? Articles of Association, we basically have Section 5, internal rules. Undoubtedly, we have Schedule 1 in Companies Act, which also gives us the model Memorandum of Association, and it also gives us the ideal Articles of Association for each type of company. Like we have company limited by shares, right? Accordingly, every company needs to have this, right? Articles of Association, you may have it as it is, you may alter it, you may adopt it, you may say that this clause is not going to be applicable on me. Okay, that is how it is, right? It also has to be prepared by every company. It is required at the time of registration, and both memorandum as well as articles can be altered later on also. That means that can be changed. You can change the name of the company, you can change the address of the company, you can change some clause in the articles, like for example, we have calls on shares, we have forfeiture, we have voting, we have so many things, right? So if I talk about, let's say, forfeiture, if I say, maybe in the articles of a company, it is clearly stated that if a shareholder does not pay its call money by even after 3 repeated reminders with a gap of 1 month each, then the shares will be forfeited. So this is the internal rule which is written in the articles of a company. It has to be within the provisions of the act. It cannot contravene or override the provisions of the act. That is for sure. Okay, so if that is written, can it be changed? Yes, it can be changed. It can be changed. How it can be changed? By passing SR. We'll talk about the alteration a little later, right? But I have told you this for a reason. Articles of Association, any clause can be altered by passing SR. SR is special resolution. Special resolution means having 3/4 majority. So if there are 100 members who are present and voting, out of this 100, at least 75 members vote in favor, it's going to be called as SR is passed. Fine. So we also have an entrenchment provision in articles. What is entrenchment? It may be added, it may never be added, right? It only makes changing a clause more difficult. Right now, changing a clause of articles would mean passing of SR. But maybe if entrenchment is added to a clause, if entrenchment is added to something, which means if you want to change this, it's going to be more difficult than right now. How it is going to be more difficult? Supposedly in the articles it is written that Shivangi is going to be MD for life. Now I know any day somebody can come up, if I lose my shares or if I don't have that much shareholding, any day anyone can come up, the members with just 75% or 3/4 majority, they can pass any resolution against me and can alter this particular clause. So I say that, okay, you add this clause because you want me on board, but I also want an entrenchment to be added over here that to change this, you would be needing 90% shareholding or 90% consent of the shareholders, right? Maybe something like that. It's just an example. It's not actual entrenchment, right? Adding any condition which would make the change more difficult. Now entrenchment can be added at the time of formation and later on by amendment also. So if you're adding it at the time of formation, of course all the members who agree to this would subscribe, so there's no question of asking people. But if it is added later on by amendment, then in private company it has to be agreed by all members, and in public company SR has to be passed, then only entrenchment can be added. Fine. Okay. Now we come to the process of incorporation. Step 1 is name reservation. So you need to check whether the name is available or not. You have to add proper suffix. Okay, government company, you're exempted from suffix. Section 8 company, you don't have to add that suffix, but then your name should have words like different, foundation, board, etc. Right? Public company, private company, we've already discussed, right? Now, at the time of incorporation, undoubtedly by using SPICE plus Part A, you can file it with ROC subject to the name restrictions given under Section 4, and you can file the form and reserve the name. If an existing company wants to change its name, then using RUN, that is reserve unique name, you can also reserve the name, file whatever other things are needed, and thereafter get your name changed. Fine. So you can also do that. Whatever name you keep, you have to ensure that it is not disregarding the provisions which are stated in Section 4. Now, what exactly is stated in Section 4? Well, there are name restrictions. Whatever name you choose, it should not be identical with an existing company. Ma'am, you told us very clearly that whenever we want to apply for reserving a name, there is an auto check option kind of given, and it tells that, okay, your name is resembling this. Correct. But then there can be errors, right? Back then there were more errors. Now everything is refining, right? So if at all this happens, that yes, they will check and they will not allow. First thing. But if at all it happens, then we also have a section which talks about change of name. Forcefully change of name, because we have chosen a name which is maybe identical. So prima facie, we should not choose a name which is identical to an existing company, which constitutes an offense or is undesirable in accordance to the to CG. Fine. Okay. Now we also have something that there are certain words which would give an impression that this belongs to government. As I just said, board. Now, if I say Shivangi board of this, it creates an impression that does it belong to the government, central board, right? All of that, right? So if I'm using board type of words, board, panchayat, etc., if I'm using this type of word, I have to obtain CG's approval. So this is prohibited. For this, I need CG's approval. Fine. Okay. Now, I have filed this particular form. If there is no defect, it will be approved. If there is defect, I get a chance to rectify the defect within 15 days, and then it is approved. Once it is approved, it's going to be reserved. In case of new company for 20 days, in case of an existing company for 60 days, right? But maybe later on it is found, see, this can be extended also by paying fees, right? So it can be like 20 plus 20 plus 20, or it can be 20 plus 40 also. So ultimately this can also be reserved up to 60 days. Fine, but you have to pay additional fees. Okay. Now, if later on it is found that, okay, you had taken this name, you wanted the name Shivangi Board Limited, something like that, right? And you submitted a false document that government has approved you. That means you have reserved your name by furnishing incorrect particulars. If the company is also formed, then ROC will give you an opportunity of being heard and maybe ask you to change your name or strike off your name or maybe close down the company, right? If the company is not yet formed, the reserve name will be cancelled and you will get a penalty of 1 lakh. Fine? Okay. Now, once your name is reserved, that was step 1. So step 1 is reservation of name. Then step 2 is what? Preparation of all the documents. You have already understood the documents about MOA, AOA, right? So we have prepared those documents. Then we talk about preparation of other documents also. All those who are a little confused, ma'am, how do we write such big process of incorporation? I will tell you in the writing practice session whenever we take. My registered students have already made you write that, right? So it's very simple and keep it simple. A company may be formed as a private company, public company, OPC with this, right? By subscribing their names to the memorandum. Thereafter, the company needs to prepare the following documents and submit it to ROC. Then ROC will issue a certificate of incorporation. So you can keep it very simple in stages, right? You don't need to elaborate so much, right? Every point can be written in crisp and short manner. Fine. Okay. Now, what are the other documents? First of all, the declaration by CA or CMA or CS, right? Whoever is in practice, as well as your first directors. Fine, that you have complied with all the requirements of the act. So that is a declaration of compliance. Fine. Then you have declaration of no offense. What is the declaration of no offense? It is filed or given by the subscribers as well as the first directors that they have never been convicted for offense involving fraud, involving promotion or formation of the company. Secondly, they should not also be guilty of fraud during preceding 5 years, right? And all the documents that they are filing are true to the best of their knowledge and belief. Fine. Okay. Then we have the particulars of office, that is the correspondence address. If you don't have finalized the office of the company, if you have, then the registered office. The details of the subscribers, the details of the first directors, that is their name, surname, nationality, right, qualification, occupation, PAN, email ID, phone number. If I talk about directors, it also has to be the DIN. Fine. So all these details are going to be there. If I talk about the director, the consent of director will also be there. So all these documents are going to be attached, and then you file it with ROC. Whatever documents you're giving, you have to preserve it till dissolution. ROC will give you a certificate of incorporation in INC 11 and will allot a SIN. The consequences, the subscribers become members, the company becomes body corporate, it can sue, it can get property in its own name, and all of that. Just like it was found that you reserved the name with incorrect particulars, in the same manner, you may have incorporated the company with incorrect particulars. So if you have done that, promoters, first directors, subscribers, you're going to be liable for fraud, and there will be additional orders if application is made to the tribunal, like closing down the company, winding up, etc., etc. But if the company is not yet formed, the company will not be formed, and still the persons who are responsible will be liable for fraud for formation of company. Fine. Okay. These points with respect to OPC, I have already told you when we were discussing about OPC, right? Next, we talk about the commencement of business. What is commencement of business? Section 10A. Now, if you are a company with share capital, then you cannot immediately start the business unless you file INC 22, that is about giving the details of your registered office of a company, because according to section 12, every company after it is formed, from the 30th day, right, after 30 days, you must have a registered office. And at all times thereafter, you must have it. So you have to file the detail with the ROC. You also have to file one more thing, that is INC 20 20A. Within 180 days of incorporation. So what is INC 20A? It is nothing but basically a declaration that, okay, these are the subscribers, they agreed to take these many shares of the company. For these shares they have to pay this much amount, and the director gives a declaration that every subscriber has actually paid the agreed amount, right? So this is a declaration which is given, which has to be given within 180 days. If you do not comply with it, you have penalty. And if you start the business without filing the declaration, maybe ROC believes of no business, they can initiate action for removal of name also. So we have read all of those things, right? Next, we come to section number 12. Section number 12 is publication of name and registered office. So once the company is incorporated, it has to have a registered office, right? It can be different from your head office or corporate office, but it is important. There is an obligation that you must have it, right? And you must furnish it to ROC within 30 days of incorporation. Fine. So that is also very well clear. Now, outside every office, every branch of a company, there has to be affixed the name and address of the registered office. So you have to keep it outside of every office in proper legible letters, and in English language, and also in the local languages if it is prevalent. That has to be there. And this I have already told you before only, that if registrar has reasonable cause to believe that you're not doing any business, then they may physically verify the registered office, and if there is default which is found, they can initiate action for removal also. Okay. Next, we have already spoken about Memorandum of Association and Articles of Association. Now is the time to talk about alteration of memorandum and alteration of articles. The alteration would mean any addition, any omission, any deletion, any substitution, right? It would mean all of these things. Company, if you want to alter your memorandum, probably you might be wanting to change the name, change the registered address, change some capital, liability, object, right? All of these. So company, you may alter your memorandum after passing SR and filing this SR with ROC. That is the simple rule, right? But one by one, we are going to talk about all the cases of alteration. So case number 1 is you're changing your name. Now, alteration is this. Section 13, alteration to memorandum. When you want to change the name, you cannot change the name if there was default in filing annual returns or repayment of deposits. First thing. Otherwise, you can change your name. So how do you change your name? You have to pass SR in general meeting, and you need to obtain approval of central government. So approval of central government has to be obtained, although the power is delegated to ROC, but you have to obtain the approval of central government. That is exactly what you'll be telling, right? That is exactly what you'll be writing. Fine. Now, once you have got that approval, you will be intimating the same to ROC, and ROC will register the new name and give you certificate of incorporation. Now, one thing that you have to keep in mind is that approval is not necessary if you are just converting your company from private to public or public to private. Your name is ABC Private Limited. Now, since you are not going to be a private company, it is going to be changed to ABC Limited. So this change does not require approval of CG. Okay. Now, when I have spoken about change of name, let me also discuss a case where there is compulsorily change of name. Compulsory change of name. Compulsorily, you have to change your name. And that is given in section number 16, where we talk about the rectification of name because of government's order. Okay, so this also ultimately results in alteration of memorandum clause, but it is not something that you're doing voluntarily or you want to do it, right? So company, when you're registered, maybe you are registered with an identical name with an existing company, then central government can direct you that change your name within 3 months by passing ordinary resolution. Once you change your name within 15 days, intimate it to ROC along with CG's order, and ROC is going to give you a new certificate of incorporation. This is one case. The next case, maybe there is some proprietor and has a registered trademark, like maybe I have a let's say there is Book My Video. It is not a company which is registered, but I may have it as trademark. Right now, if somebody in future wants to form a company as Book My Video Private Limited, well, I can make an application to central government and ask this particular CG will direct this company to change their name in the same manner. But I can do it only within 3 years of incorporation of the company or name change, whatever the case be. Fine. So this is one thing that you have to understand. Now, next, we come to alteration of situation clause. Situation clause alteration, see, in the memorandum only state is written. So ultimately, when the state is changed, that would only amount to alteration of memorandum. However, there could be change of office in a lot of cases. The change of office within same city would just need a board resolution, no alteration. Change from one city to another city within the same ROC would eventually need SR. When you change it from one state to another. See, there are prima facie 4 cases within city, board resolution, one city to another, it is special resolution, one city to another, within the state, but the ROC changes, then also you need permission of regional director, and from one state to another, then of course SR plus central government approval is needed. So this is what you have to remember from exam perspective. Of course, the powers have been delegated. There are things which have been simplified. Okay, but this is what you have to remember. So this wouldn't amount to alteration. This wouldn't amount to alteration. This is what you have to remember, that you need to file SR. There will be advertisement, there will be receipt of objections and everything, and application will be made to CG for approval of change of office from one state to another. Okay, and confirmation has to be obtained, and thereafter, when CG grants the approval, you will intimate it to ROC, file that confirmation with ROC, and then it's going to be done. Fine. But CG, before it disposes of your application, it will also satisfy itself and ensure that, okay, you are making this change, but it has the consent of the creditors or the persons who are concerned with the company, or maybe sufficient provision has been made to discharge their debts, or maybe security has been provided to them, right? Because ultimately they are the ones who could suffer, because your office is now going to be shifted to another state. There might be certain change of laws also in another state, right? So the jurisdiction, everything is going to change, right? So they might get affected. So CG will ensure that these things are done before granting you the approval. Next comes alteration to object clause. Now, object clause can be altered simply by passing SR. That's not a problem. But object clause is what? You said that, okay, I am going to invest money in this particular venture. Maybe you have raised funds from people by issuing prospectus, and in the prospectus you wrote that, okay, I'm raising funds for this particular project. Maybe I will invest in real estate. But you raised money by saying real estate amount of maybe 10 crores. You have utilized 1 crores by far and 9 crores are still left, and then you change the object and say that I'm going to invest in jewelry business. Now, many investors might not be willing to continue with that, right? So you cannot change the object just like that when you have unutilized money raised through prospectus. In that case, you have to go for an advertisement also. So it's going to be published in newspaper in both the languages, English and vernacular, posted on the website of the company also, and the dissenting shareholders are going to get an opportunity to exit. Okay, an exit opportunity. Fine. Next, we have this effect on memorandum and articles. Basically, we have to understand that whenever we are making any change in the memorandum or alteration, it has to be filed, the special resolution, and that has to be filed with ROC. Fine, then only alteration is going to have effect. It is not going to have any effect unless it is registered with the authority. Okay, that is one thing you have to remember. Fine. Ma'am, in the same manner, just like we have read about alteration of memorandum, can articles also be altered? Undoubtedly, articles can also be altered, and articles alteration is very simple thing. We'll come to that. But before that, because I can see this particular provision, a very short one, very simple. Effect of memorandum and articles. So once you have incorporated the company, you have made this MOA and AOA, and you have given it to ROC along with other incorporation documents, or maybe later on when you have altered this, then also you file it with ROC. So ROC has it, right? It is registered. So once it is registered, it creates a binding type of contract between the company and its members. So members are bound to the company is bound to the members, and whatever is written in it, members are not bound inter se, but members are bound through the company. Like one shareholder is not paying the call money, you cannot sue that shareholder for not paying the call money, but you can ask the company to get that. And the company is not bound to outsiders. This is even more important. So if I have written in my articles that I'm going to make somebody MD, based on this article which I have with my members, right? You cannot file a suit that why didn't you make me an MD? Make me MD, right? Because I have not entered into any separate contract with you. This is not binding me to do anything for you. So no outsider can sue to enforce that articles. Fine. Now we come to alteration of articles. Again, articles can be altered simply by passing special resolution. One thing that you have to understand is when you're converting private to public, then also you need to alter the articles. Why you need to alter the articles? Because private company will have that restriction, prohibition, limitation, and you need to remove it. So you need to alter the articles. Likewise, when you're converting public company to private company, you need to add these restrictions. So again, alteration of articles would be needed. So in both these cases, you need alteration of articles. So in both these cases, SR will be passed. Fine. Here, you just submit this SR plus copy of altered AOA to ROC, and that is it. But when you're converting public company to private company, you would also need approval from CG. Why you would need approval from CG? For the simple reason, because now you will no more be subject to those compliances, disclosures, transparency, maybe, right? So CG needs to approve that, okay, fine, you are allowed to convert yourself into a private company. All the alterations that you have made are going to be noted in every copy, and thereafter only they are going to be circulated. Fine. So that you have to understand. We also have a very small section called as section 6, which talks about that whatever provisions of the act are, act is going to override. I think I already told you this, right? Act is going to override memorandum and articles and everything. Fine. So now we come to the doctrines. The doctrine of ultra wise, as I told you before also, ultra wise is beyond the powers of, right? So anything which is not permitted by Companies Act or which is outside MOA, right, is going to be void. It cannot be ratified even if all the shareholders agree to it, right? Something which is within the act or within the powers of company but beyond the powers of directors, and directors have done something, that can be still ratified. But anything which is actually beyond Companies Act or beyond MOA, it can never be ratified, right? So ratified means accepted. Next, we have doctrine of constructive notice. Now, constructive notice would basically mean implied knowledge. Constructive is implied, notice is knowledge, right? So one thing you have to understand, that whenever we have filed the memorandum or the articles of association with ROC, that means they are now public documents. You cannot just, if the curfew is announced, you cannot just roam on the road and say that I didn't know there's a curfew. Well, you have been intimated through the official public channel, right? Likewise, when the documents are filed, they are public documents, and it is implied that you know about it. Even if you don't, you cannot come and plead that I didn't know about it, right? So every person who is dealing with the company is presumed to know, presumed that they know about MOA and AOA after registration. Fine. Okay. But They're not supposed to know what internal irregularities are there in the company. So this somehow operates in favor of the outsiders. Anyone who is going to contract with the company, they read the articles of association, they come to know, okay, the company will have the power to enter into such contract provided MD has approved it. So we believe that MD must have approved it. We are not supposed to inquire into your internal proceedings that show the approval of MD, show this, do that, right? However, we have to be a little cautious. If I know that yes, MD hasn't approved it. So if I know about the irregularity, how can I go and plead in the court that I am not supposed to know about their internal things? I did this, so I have full right to enter into this particular contract, or I should be given some compensation, etc., etc. No, I cannot. If I knew about the irregularity, I cannot plead this doctrine of indoor management that if I am dealing with a company, I'm not supposed to inquire into internal proceedings. I am an innocent outsider, right? So there are exceptions to doctrine of indoor management, which are knowledge of irregularity, negligence. I could have figured out and I could have found out if there is an internal regularity or not, but I decided not to. Well, you are entering into a contract, you should do that, right? And third is forgery. Forgery is complete nullity in case of any law because it's absolute absence of consent, right? So forgery, I hope you know, that is the fourth signature. Next we come to section 8 company. Section 8 company, I've already told you about it. So eligible objects, you know the use of profits. Now let's talk about the process of incorporation, how section 8 company will be incorporated. Section 8 company, you will be needing license from central government. That is the first thing. How do you get that license? You file the same form, and the additional things that you file is this: estimated annual and income expenditure for the next 3 years. That is needed for the grant of license, right? So you get the license along with the certificate of incorporation. Now when you have got the license, it can be revoked also. Because you've got the license, it can be revoked also, it can be taken back also. When it can be taken back? Point number 1, you do not comply with the requirements of Section 8. Point number 2, you do not comply with the condition on which license was granted. Maybe the condition was placed that you have to do some quarterly reporting or something like that. So you did not comply with it. Then you have fraudulent conduct. So you're doing some fraud. You are conducting in the manner which is violative of objects. So your objects clearly say that you are not entitled to do any business but only charity. Maybe you're doing some sort of things like that. Or maybe you're conducting affairs against public interest. Maybe you have opened a religious, you're promoting some religion, but you're demeaning other religion. So it is against the public interest. Why? Because it's creating a lot of spark and riots, maybe, right? So in all these cases, the license can be revoked also. Special point to know that a firm may also be a member of such company. Firm cannot be a member of any other company, but it can be a member of Section 8 company. Fine, so you have to remember that. Now, once the license is revoked, what is going to happen? You have to restore your status of private company or public company, whatever it is, right? But if CG is satisfied, it may also pass additional orders like what? Like wind up the company, and whatever excess assets are there, they are going to be transferred to a similar company registered under Section 8, right? It may be sold and transferred to the fund. It may be amalgamated with some other company doing the same things, right? And Section 8 company are also being exposed, and they get a lot of benefits. Fine. Like you can call your general meeting by just giving 14 days notice, right? You do not have any requirement of minimum number of directors, as I already told you. Fine. Okay. Next, we have conversion of Section 8 company. Very simple, that if you want to convert Section 8 company into any other company, you just have to pass SR at general meeting, then file application to regional director for approval, and you can do that. If any other company wants to get converted into Section 8 company, you have to apply for license. Fine. Once license is granted, then the things can take shape. If I talk about other types of conversion, I've already told you private to public, public to private also I've told you, which is ideally covered in Section 18. Whenever there is any conversion of company from one form to another, you have to understand that it's not going to affect the debts, liability, contracts, obligations, nothing. Okay. Then we have some other conversions also, that is conversion of LLP to company and company to LLP. Now, when I talk about LLP to company, it is not given under LLP Act, it is given under Companies Act. It is read with Companies Act section 366 along with Companies Authorized to Register Rules 2014. Fine. So if you are LLP, you may be converted into private or public company as the case be. You are LLP, you are going to be converted into company, right? So you would be needing a name for sure. So you can get a name reserved. Fine. So hold a meeting. Because you are an LLP and you are going to be converted into company, you have to understand one basic idea in mind. You should keep that, right? Unless you keep that basic idea, it's going to be a troublesome thing to understand this way. You are converting. You have another option. You can shut down the entire LLP, you can go for that winding up, and then you can open a company. But that's going to be a very tedious process if you want to continue as a company, right? So here the partners are going to become the members. Fine? Okay. So you need to get the approval from the partners. These are the generic things. There will also be advertisement in newspaper seeking objection, NOC from ROC where the LLP is registered, and then you fill the name and get it reserved. Fine. So these are some generic things. Now, what do you file? What do you file? What are the things that you need to file? So there is form URC1, and along with this URC1 there will be a lot of attachments. What attachments will be there? The names, addresses, occupation of all the persons who are going to hold the shares, right? So the member details or the shareholder details, right? And along with a lot of other details, you can say. Then the list which is going to tell about the first directors along with their DIN, their consent to act as directors, and their interest. Fine. Okay. Then we also have LLP agreement and certificate of registration. So because now you're going to be converted, so what was your original constitution and everything? Written consent of partners, NOC from creditors, NOC from ROC, copy of newspaper advertisement, right? All these things I've already told you. So this is going to be filed and filed with ROC, and thereafter the things shall take shape. Next, we come to conversion of company into LLP. Now, this is actually given in LLP Act. So we have in fact, before also you have read about LLP Act, so you know about Schedule 3, 4, all of that, right? So we have sections and then we have schedules, corresponding schedules where we talk about the conversion. So now we are going to convert the company into LLP. There will be a board meeting, there will be passing of board resolution, then you take the consent of your shareholders, right? You file the name for you file the form for name availability, and then you file the necessary documents which might be needed. What are those necessary documents which might be needed? See, you have E-Form 18, statement of the shareholders, statement of assets and liabilities. Then you also have the verified by auditor, that's fine. The list of the creditors with their consent, the director details, right? All of that. Now, you should also actually give LLP agreement because you are a company and you are going to be now converted into an LLP, right? So you should also have LLP agreement. But because even at the time of incorporation, LLP agreement is not required immediately, and you have a time frame of 30 days. Within 30 days of incorporation, you can file this LLP agreement. So here also it's not a mandatory document. However, to avoid any dispute, it should be filed immediately. Fine. Okay. Now let's revise all about foreign companies. Where's it coming from? See, ideally it is a part of our very first chapter, company formation and conversion. But if we look at it technically, it is the provisions are contained in chapter 22 of Companies Act, right? So chapter 22, which essentially or originally has section number 379 to 393A, those are the provisions which relate to foreign companies or which are made applicable for foreign companies. But prima facie, at the very first place, we need to understand what is foreign company. So we have some companies which are incorporated in India under Companies Act or previous company law. They are all Indian companies, right? Or they are just company under Companies Act. However, There are certain companies which maybe are incorporated outside India. So how are we concerned about the companies which are not incorporated under Indian laws? How can Indian laws be applicable on those type of companies? Yes, of course, they won't be applicable. Now, these companies which are incorporated outside India, if they are not concerned with India, if they're doing business outside India only, we are not concerned of them unless they come here. But if such companies come here, they open another Indian company, and through that Indian subsidiary they are doing business. That Indian subsidiary is an Indian company, so all the laws will be applicable. Again, the concept of foreign company does not step in. The concept of foreign company steps in when we have a company incorporated outside India which comes to India through physical opening of office or through electronic mode and conducts business activity in India. Not by opening another company, but just maybe by establishing a place of business, by opening some branch office or whatever. So company incorporated outside India, it has a place of business in India. This place of business could be direct, it could be through agent, it could be physical, it could be through electronic mode, and is conducting business activity in India. So such company which is incorporated outside India, which has a place of business in India and does business activity in India, that will be known as foreign company. This branch of that company incorporated outside India will be known as foreign company. So this here we are referring to that foreign company, its Indian operations, and here we are concerned of making Indian laws applicable on such a branch, because it is doing business with Indian people. They are all involved, Indian stakeholders are involved. So of course government is concerned and steps in and makes a beautiful chapter 22, which is made applicable to foreign companies. Now, it could have a place of business in India electronically also. So for that, we have a rule too. And we have to remember some keywords for electronic mode. Keywords like there could be B2B transactions, there could be B2C transactions, there could be telemedicine, telemarketing, cloud computing, right? It could be digital supply, there could be acceptance of deposits, a lot of things. It could be whether by email or by any social media, the server is India or outside India, we're not concerned, right? So all of that you have to keep in mind when we look at the definition of foreign company. So the definition of foreign company is contained in section 2 clause 42. Now we have two types of entities, or three types of entities. One is the companies which are incorporated in India. On that, entire Companies Act is applicable. Second is companies incorporated outside India. They're not doing any business in India. And the third is the companies incorporated outside India which are doing business in India. So they are foreign companies, right? Now, this chapter 22 is applicable on foreign companies. So all the provisions like that is start from section 379 to 393A, everything is applicable on foreign companies. However, sections starting from 387 to 391, these are the sections which actually relate to prospectus and all. They are also applicable on companies which are incorporated outside India. They're not doing any business activity in India. Ma'am, how can we make our Indian laws applicable on some entity which is incorporated outside India and is not even concerned in doing business in India? But if that company comes and raises fund by showing prospectus over here, then the provisions with respect to prospectus will be applicable. Okay, so these are the provisions with respect to prospectus which are applicable on all companies incorporated outside India, and the other provisions are applicable on all foreign companies. Okay. Now, this was section 379. 379 has another part of deemed Indian company. Now, let's say, for example, we have a company incorporated outside India. It has established a place of business in India and does business activity in India. So now on, we are going to refer it as a foreign company. So this foreign company, 50% shares of that foreign company or more, 50% of paid up capital of such foreign company is held by either Indian citizens or Indian company or a combination of them. In such a case, it is a foreign company. So obviously entire chapter 22 will be applicable. Moreover, there will be some additional prescribed provisions which will also be applicable on this company as if it was an Indian company. Okay, as if it were an Indian company with respect to its Indian business operations only, right? So this is something that you have to remember. And when we are talking about paid up capital over here, we have to keep in mind we're talking about preference plus equity. So specifically, you have to remember this for this particular point. Moving to the next section, section 380. Section 380. Now, whenever this company incorporated outside India establishes a place of business in India, that means it is opening a branch office. Once it has opened whatever place of business, or electronically it has established a place of business in India, within 30 days, you will furnish FC1 along with these following documents to ROC New Delhi. Now, what are the documents? The very first thing, just like we have Memorandum of Association for our Indian companies, likewise, you must be having some instrument which constitutes or which defines the constitution of the company. So whatever that charter document, whatever that fundamental document you have, that you have to furnish. Supposedly it is in some other language, so translate it into English and certified translated copy should be furnished. Second, the address, registered address of your principal office that you have in your own country. Third, your directors, your secretary and their particulars, their prescribed details. Fourth, what is going to be the person and their address in India. That means you have to find some resident in India who is going to be your authorized representative, who is going to accept documents on your behalf. 5. Whatever your address of principal place of business over here is, whatever principal place of business you have opened, the address of that. In past, it may so happen that you have opened a place of business and you have shut it down. So whatever past place of businesses were there, that also you will be giving the detail. And thereafter, you will also give a declaration. What type of declaration? That my director, secretary, and the authorized representative that I have hired in India, they're not convicted. That means they have not been found guilty of any fraud in the formation of company, or they have not been debarred from formation of the company. So they are genuine people. All of the things are allowed, right? So you will give a declaration like that also, and other prescribed information. If there is any change in such type of information, then there is another form for alteration, FC2. So within 30 days you will furnish that particular form for alteration and you will give it to registrar for registration. Section 381. Just like Indian companies have to maintain a lot of accounts, they have to prepare financial statements for every financial year. In the same manner, what foreign companies have to do? See, foreign company, that means you are a company and you have established a place of business in India. So what you have to do is you also have to prepare financial statements of your Indian business that you're doing. And you have to prepare it for every financial year. Ma'am, the financial year of such foreign company and that Indian company, is it the same? That means they also have the same financial year, 1st April to 31st March? No, it may be different, right? Subject to necessary approval. So you may have a different financial year, right? Now, according to your financial year, you will prepare, of course, whatever financial year is permitted, they will prepare according to their own financial year only. However, it has to be according to Schedule 3 with prescribed annexures and all of that. And within 6 months of your close of financial year, you will submit it to a registrar. It may also grant you extension. That is, this information is not so important for you, for your exam perspective. However, what you have to remember and what you have to keep in mind is that supposedly the financial year is the same. So 1st April to 31st March is the same financial year that such foreign companies also following. That means 1st April to 31st March, and thereafter you get 6 months to do that. That means you are somewhere submitting your financial statements maybe in August or maybe in September. You're doing it. So every year in September you are going to do it, or I should say every calendar year you are doing it, right? Fine. But it may so happen sometimes that your financial year is say of 18 months. So what happens is, it may so happen that in 2 years there is no financial statement which is coming. So Indian people will be concerned. So for that reason, you get this type of confusion, financial year and calendar year. Now students get confused that, ma'am, what we have to do? Every foreign company will prepare its financial statement for financial year only. but they have to deliver it to registrar and ensure that every calendar year they are delivering one financial statements. Okay. Now, display of name of foreign company, section 382. So what you have to display, just like Indian companies also, if you look at section number 12, you should remember that every company has to put a board outside every office that, okay, fine, this is the name of the company, this is the registered office of the company, and like things, right? Outside every office, you have to put a board. Likewise, if there is a foreign company, so outside every place of business, they are going to put a board. Outside every place of business that you have in India, on that board, name, country of incorporation, and the fact that the liability of such a company is limited. That has to be displayed. And that has to be displayed in two languages, one English in proper legible characters, and second in local language. You will print these three things on all the letterheads, bills, and notices also, but that you have to print only in simple English language, not in the local language. That is not required. Okay. Then comes your service of documents, that is section number 383. Now, if ROC wants to send a notice to this foreign company, how can they send it? Well, this foreign company has provided them with the address of principal place of business in India. They have also provided the details of authorized representative who is the resident in India. So if ROC, or as of that any matter, if any notice or document has to be delivered on foreign company, they will serve it and send it by hand delivery, post, or electronic media to person resident in India, whoever is authorized at the address which is furnished by such foreign company. And if you follow this process, the foreign company cannot deny, oh my God, notice was not received by me. I did not get the notice. Well, it was sufficiently given to your authorized representative. And if they have received it, it is deemed that you have also received it. So it has been served on you. That is going to be deemed, right? Now, when we talk about the chapter of company incorporated outside India, in our syllabus, only this many sections are covered. However, you have another section that you should keep in mind, that is section number 376, which actually relates to the chapter of winding up. Now, what happens? There is a company incorporated outside India. It has opened a branch. Now, that company incorporated outside India dissolves. Let's say, for example, it closes its operations and is shut down according to the laws of their own country. So what will happen? This will also get dissolved. The answer is no. According to Companies Act, the provisions of winding up, the Indian business, this particular thing, is going to be wound up as an unregistered company. So in the chapter of winding up, we have the provisions that how an unregistered company is going to wind up, because this is not registered under Companies Act. This is an unregistered company only, right? This is an unregistered thing, right? So just like unregistered companies are wound up, this is also going to wound up like that only. So this is a small section. We don't have to read the entire thing. Body corporate incorporated outside India. That means a company which is incorporated outside India, which is carrying on business in India. It ceases to carry on business in India. So now it is not going to do business in India. Now, even if that original body corporate has ceased to exist, that means it has dissolved according to the laws of its own country. Yet, this particular Indian business or Indian operations, it is going to be wound up as an unregistered company according to the laws of Companies Act 2013. This is the only thing that you have to keep in mind. Remember the section number, because often in your examination, a short note or some part is being asked on this particular topic of winding up as unregistered company, right? Let's now revise the chapter of investment and loans. Now, this is basically divided into two parts, I would say, because we have two sections, section number 186 and 187, which talks about the loans and investments by company and all that. They are basically covered under the chapter of board meetings according to Companies Act classification, and it's too early for us to combine with this particular chapter. So basically here we are revising chapter 5 of Companies Act 2013, which is deposits, right? So, because after we read about board's power, which is given in section 179, thereafter companies get the borrowing powers. You read about making investments and all that in section 186, 187. So, that we'll revise later along with that particular chapter. But right now, we are discussing over here acceptance of deposits, its renewal, default, remedies, and all of that, which is covered in chapter 5 of Companies Act 2013, which contains section 73 to section number 76A, right? Okay. So the very first thing, ma'am, what do we mean by deposit, right? So deposit is what? Received of money by company. So company is receiving certain money. How company is receiving certain money? Company could receive certain money, or company could receive money in ample of ways, by way of deposit or loan or any other form. That means in whatever form you call it a deposit, you call it a loan, company is receiving money, that receipt of money is called as deposit. Is it that simple? No, the answer is not. We go to a bank and we want to take a bank loan. We receive money from the bank in the way of a loan. Is it deposit? The answer is no. Why is it not deposit? Because the purpose of this particular chapter, the intent of this particular chapter has to be understood. The purpose of deposits is basically to cater to the short term needs, right? A company is running, it has to put in certain amount of money, and it will be blocked for a span of only 7 months, and thereafter your money will be released, or you're expecting money flow from somewhere, but for a span of 7 months supposedly you need certain money. Now what do? You have some short term credit facilities also, but then maybe they are not available, right? And maybe if you want to take money from your own members who have already invested in you, who know about the company, they're very happy and satisfied, you can take money from them also. But what do you give them in exchange? Are you going to issue them some securities? Now, again, issuance of securities is a long, tedious process. We have read about issue of shares, public offer, private placement, issue of debentures, and all of that, right? Before. Now, all of this takes time, all of this has regulations. Now, this is a short term need which is of the company, and that has to be catered. So, you go to the member and ask them, are you ready to give me money for 7 months? After 7 months, I'll repay it to you. They said, fine, you take it. Now, the problem is this particular receipt of money, what do we call it? We don't call it share, we don't call it debentures, we don't call it bank loan, right? We cannot call it any of it. So how it is going to be regulated by Companies Act? Supposedly, company defaults in repayment of deposit as promised. What will happen? There is no penalty which has been stated. There are no rules which have been made. So for this leftover category of receipt of money, actually deposit provisions have been introduced. It helps regulate this particular sector also. Right. So because companies were what? They were taking deposits, but they were also incurring defaults. So for that reason, this particular chapter is there. So it clearly says that deposit means receipt of money in the form of loan or in the form of deposit, or you call it any, you give it any name. It doesn't matter. It will be called as deposit, but there are certain prescribed categories of receipt of money which will not be treated as deposits. What are the prescribed categories by CG in consultation with RBI? Ma'am, what are those receipts and are we supposed to learn it? The answer is you're not supposed to learn it. They are given in Rule 21C, and here we have also given it for reference, just for your knowledge, just for reading. You're not supposed to learn it. On these particular receipts of money, no question should be asked in examination, as it is not incorporated in the syllabus completely, right? Okay, so if you receive, like if you're taking a loan from bank, it is not a deposit. If you're taking loan from PFI, it is not a deposit. If you're receiving some amount from government, it is not a deposit, because all these sectors somewhere have their specific regulations and are being regulated, they're being managed, they're allowed, right? Apart from that, if you're receiving deposits. Now, can you receive deposit? The answer is yes, you can receive deposit, and any company can receive deposit, whether it's a private company or a public company. Private company, you can receive deposits only from your members. And public company, can you receive deposits from general public also? The answer is yes, provided you satisfy certain conditions and become an eligible company. So eligible public company, we have now three category of companies. We have private company, we have eligible public companies, and non-eligible public companies. All these three can accept deposits from members. However, only eligible public company can accept deposits from public. How? There should be some procedure which has been specified. There should be some conditions which have been imposed. The answer is yes. All of it, that we are going to read in this particular chapter. So we begin with section number 73. We begin with section number 73. I also have this. If you want to take a screenshot, you can definitely take a screenshot. Now, these are the points that I have written as you should write in examination, because often a direct question is asked in examination, like, how can a company accept deposits from its members? Right? So if this type of question, or you frame any language, the content of section 73 is being asked, how will you write it? The first thing, no company can accept deposits from public. Ma'am, you said eligible company can. Yes, except as provided under this chapter. So first general rule, that any company is not allowed to accept deposits, to invite deposits, to renew those deposits from general public, except as provided under this chapter. In this chapter, we have these provisions contained in section number 76. So according to section number 76, if you follow that, you can accept deposits from public. Apart from that, no company can accept deposits from public. Ma'am, if we talk about banking companies, if we talk about NBFCs, it is their ordinary course of business, and they are bound to accept deposits from public in day-to-day business. So that is an exception. So banking company, NBFC, HFC, or any other company which CG may specify after consulting RBI, those companies will be exempted from this particular clause. Now, if any company wants to accept deposits from members, what is the procedure that they follow? First thing is passing of ordinary resolution, right? I think it is somewhere written SR, so that is the incorrect thing. You have to rectify it. Other than that, the first thing is passing of ordinary resolution. Now, after ordinary resolution is passed, that means you have taken shareholders' permission. What is next is preparing of circular. Preparing of circular, ma'am, what type of circular? Circular containing the details like what is the financial position of the company, credit rating, if any, the total number of depositors, right? If there are previous deposits, what amount is due in that previous deposits, and other particulars as may be prescribed, right? So this is a circular which is being prepared. First, the circular is filed with ROC. And once it is filed with ROC, within 30 days, you issue the circular to member also. That means if I take you through law language, we read it like that. We file the circular with ROC within 30 days before the date of issue of circular. So here you are issuing circular within the span of 30 days. Within the span of 30 days. That means once you file it within 30 days, you have to issue it. You can understand it like this or like this, right? But you write it like this, you get more marks. Okay. Fine. After that, next is, let me take you from here also. So company, whether you're public or private, you may accept deposits from its members by complying with such rules as prescribed by CG. Procedure steps are as under: call general meeting and pass OR, prepare circular. The circular will contain these details. Then you have to file the circular with ROC. You have to issue the circular to members, and thereafter what you do. Let's read the other points also. You have to prepare a DRR. Now, what is a DRR? Deposit Repayment Reserve Account. You go to a scheduled bank, you open a separate account like an escrow account, a temporary account which is going to serve the purpose, and then shut it down. So that is an account which has been created. Now, what you're doing is you have to repay the deposits for which you're creating a reserve. That means setting aside certain sum of money. Ma'am, what sum of money? When you stand at the beginning of the financial year, you assess before 30th April that what are the deposits which will mature in this year. Supposedly it comes out to be 1 lakh. So 20% of 1 lakh comes out to be 20,000. So at least 20,000 sum I will set aside and shift it to DRR. That means I'll transfer it to that particular account, and that I will use only for repayment. Okay. Then there comes certification of no default. Now, if there is a company which has never incurred any default in repayment of deposits, you will certify that, okay, there has never been any default in repayment of deposits. But supposedly there is a company which has in past done some default. That means the deposits were due on 5th September 2020, but or let's say 2010, but 2010 will again be too early. 2015, let's keep it like that. Okay, so the deposits were due on or September end 2015, but the company did not pay it. Company paid it 1 year later. That means in 2016, September 2016, the company paid it. Now, the date, 30th September 2016, you rectified the default. You made the default. Now, from there, for 5 years, you're disqualified. You cannot accept deposits. And once those 5 years have lapsed, you can always provide a certificate that yes, the company defaulted in these provisions, but the company made good the default, and 5 years have elapsed since then. So you have to give either of the certificate that there has been no default or there has been a default, but the default has been remedied and 5 years have elapsed. Okay, so this is the certificate that has to be provided. Then you will also provide security. See, our deposits can be secured or they can be unsecured also. You cannot say they are partially secured. Partially secured means unsecured only. And whenever they are partially or unsecured, you have to state this fact on every circular, every advertisement, everything, that these are unsecured deposits. Right? And if they're secure deposits, you will provide adequate security by creating a charge on the assets of the company. Okay. Fine. So this is clear. This is clear. This is clear. This is clear. When you accept the deposits, you issue the depository receipts within 21 days of receipt of money. You transfer to DRR. You also file return of deposits DPT3 before 30th June with ROC. And there is one more thing. Execution of deposit trust deed to appoint trustee. What is that, ma'am? We will read about deposit trustee, and in that, of course, you have to enter into a deed with them, and that has to be done before issuing a circular, right? Within 7 days. So that I'll do that later. Once the deposits have been accepted, they have to be repaid. Their interest has to be repaid in whatever time that has been promised. Supposedly you fail to do so, the depositor can make an application to NCLT, and NCLT is going to pass an order for payment of damages, for payment of deposits, for immediate, forthwith, whatever it is. Okay. So this was about section number 73. Now we move further, right? Section number 76, it tells us only an eligible public company can accept deposits from public. So what is an eligible public company? A public company whose either net worth is 100 crores or more or turnover is 500 crores or more. So you satisfy any one condition and you obtain the consent of your members and file the same with ROC. Ma'am, how do we obtain the consent of our members? Through SR. Through SR. Okay. So you are a public company, you satisfy any of the criteria and you pass SR and file it with ROC, you become an eligible public company, or you become a public company eligible to accept deposits from public. But there is one more thing. So obviously when you're revising, or when you will get to know about section 180 later, but right now you have to understand that section 180 is about power of board to borrow. There is a company has given certain powers to the board of directors, right? The board of directors can borrow up to a certain amount, and if they are borrowing up to this amount only, they do not need special resolution. So this much borrowing is within that limit. So here also it is said that if you're borrowing or if you're accepting deposits within the limit which has been specified in section number 180, which you're going to read later, right? So if you're accepting deposits, accepting of deposits means what? You're borrowing money from your members or you're borrowing money from general public, but you're not giving them any securities. You're just issuing receipts to them, which are deposit receipts, that we have taken the sum of money and will return it at a particular date, right? So if you're accepting deposits within this limit, then you don't need to pass SR. OR is going to be sufficient. Okay. What is the procedure, ma'am? The procedure is exactly the same as we read for acceptance of deposits from members. That means we need to prepare circular, we need to file circular with ROC, we need to issue circular, certificate of no default, all of that, right? There is one additional thing, or you can say simply two additional things that you need to keep in mind. One is that you need to obtain credit rating credit rating from credit rating agencies. What is credit rating, ma'am? Everything has been rated just for us to know how it is or how it is performing, right? If we go to buy a car, we have safety standards, we have safety ratings. So if it is 5-star, we get to know, okay, this car is safe for us. Likewise, if you're making an investment, we also want to know, is it safe for us? How do we know that? By looking at the rating. And how is it being rated? The credit rating agencies evaluate the parameters and thereafter they rate a particular. So at the time of acceptance of deposits, you need to obtain this credit rating, and every year thereafter, you need to obtain the credit rating, because maybe during the year you have done so many defaults, your credit rating, your credit worthiness has actually declined. So people might not be willing to continue, right? So every year this has to be done. Point number one. Secondly, the circular that you prepare, it is not issued to members. Here it is being issued to general public. So it is prepared in the form of an advertisement. There are more detailed provisions to that, but you don't have to get into that. Okay. Fine. Now, you create a charge if the assets are secured within 30 days of acceptance, and the charge is going to be created on tangible assets of the company only, maybe on movable assets or immovable assets. Fine. Okay, ma'am. Now, there is a register of deposits which has to be maintained. And in that register of deposits, what will be the contents which will be there? First of all, the details of the depositor, ma'am. What details? The name, the PAN, address, right? Then there are more things like what, ma'am? Like the nominee details, right? The deposit receipt number, what is the amount that has been accepted, the date and amount of deposit, when are you going to repay, that means date of repayment, what is the interest which is going to be carried, for what duration the deposit is going to be there, right? Then other instructions for TDS, if you have provided security, if they are secured assets, what is the security that he's been provided. And then there is something also called as deposit insurance. What is deposit insurance? Deposit insurance, again, if the company fails to repay, we have got it insured, so the insurance company will pay. So to what extent have we the deposit insurance? So all those details, everything is going to be there in the register of deposits. Now this register has to be preserved for a period of 8 years from the last entry. So whenever you make the last entry, you preserve it for 8 years. The entries are going to be made within 7 days. It is going to be kept at the registered office, right? And authenticated by director or secretary of the company. Fine. Okay, ma'am. Now, some more conditions with respect to deposits. First of all, we talk about the tenure of deposits. What is the tenure of deposits, ma'am? See, you cannot accept deposits for a period of 5 years or for a period of 1 month. No. For a period of 6 to 36 months is what we have in general. More than 36 months, you cannot accept deposits, you cannot renew it, you cannot do it. It's very simple. Whether it's secured, whether it's unsecured, it doesn't matter, it cannot be done. But for certain short-term needs, if you want to meet out your short-term needs, then if your deposit amount does not exceed 10% of paid up capital plus free reserves plus securities premium, then you can accept deposits for less than 6 months also, but not for less than 3 months. That means they can be repayable in 4 months, 5 months, 3.5, whatever it is. So in that tenure, if you justify this, this is something which is allowed. Then we come to the limit on deposits. There are broadly 1, 2, 3, 4 and 5. 5 limits that you should remember from examination perspective. First, if you are a public company could be an eligible company, it could be a non-eligible company. So if it is a non-eligible company, it can accept deposits only from its members up to 35% of paid up capital plus free reserves plus securities premium. Fine. Okay, ma'am. If it is an eligible company, it can accept deposits from members also and from general public also. So from members up to 10%, from general public up to 25%. If it is a private company, then up to 100% is allowed. Up to 100% is allowed. Okay. So these are broadly the 3 things that you should remember. And of course, for government company also, if eligible government company is there, then there is no bifurcation. Eligible government company, you can accept 35% from members or 35% from general public. It does not matter. Okay? It does not matter. Clear? Fine. Now, your rate of interest, your rate of brokerage, everything is not supposed to exceed the maximum rate which RBI has specified for NBFC. RBI regulates non-banking financial companies. Now they have specified, okay, this is the maximum rate, because what happens, sometimes the companies make the offer so lucrative that people will fall for it and they might become prey to it, right? So in such a situation, there has been put a maximum limit that this can be the maximum rate of interest that you can provide in this particular case. Okay. Now, the deposits can be accepted in joint name, but it cannot exceed 3. So, maximum in the name of 3. Fine? Not exceeding 3. Now, we come to the deposit trustee. Deposit trustee. Who can be the deposit trustee? We still have few sections left. We have to discuss about section 74, 75, 76, 76A. So, we have all these sections left. But before that, we will actually talk about deposit trustee. So first of all, who is a deposit trustee? Deposit trustee could be any person. Could be any person, but he should not be disqualified. That means he should not be a depositor in the company himself. He should not be a director, KMP, or employee of company, of its holding company, of subsidiary, of associate. Okay. He should not be indebted to company, its subsidiary, its holding, its associate, or subsidiary of holding. Ma'am, do we need to learn this? Undoubtedly, you have to learn this. A lot of times this question has been asked in past in examination, that who can become a deposit trustee or who can't become a deposit trustee. So you need to learn this. And it's very simple, trust me, it's not very complicated. As you see, a lot of places disqualifications are. Then, he should not have a material pecuniary relationship with the company. No, material pecuniary relationship has not been defined. Pecuniary relationship means what? Monetary relationship. Material means something which really can affect your decisions, or which can actually make you biased, or which can take away your independence, right? So this has not been specified that this much percentage or this is going to be. So it's in general and no question will be asked on this particular point. Next, who has actually given guarantee of the deposits? Wow. He is the person who has given guarantee of the deposits and he is going to speak on behalf of depositor. No. He will always suppress them, right? So he cannot be, or he cannot be the relative of these people. Okay. So these persons are not allowed to become deposit trustee. Apart from that, there could be any person. Person means he need not be an individual only. There can be other person also. So they can become a deposit trustee. How do you become a deposit trustee? Your consent is being obtained. Just you are a professional, you are rendering services, you can become a deposit trustee. We enter into a written agreement with you, and that written agreement is what? Deposit trust deed in DPT 2. Now, as I told you, it is being executed at least 7 days before you issue the circular to members, or before you give the circular in the form of advertisement in case of eligible public company, in case of public offer. Okay, so 7 days prior. And once he is appointed, can he be removed? The answer is yes, he can be removed. But he can be removed only with the consent of all the directors present at a board meeting. And in case the company is required to appoint independent director also, then in such a case, that board meeting must have one independent director. Okay. So all directors present plus one independent director must give his consent. This removal is possible only in such a case. Okay, ma'am. Now, once this deposit trustee is being appointed, what does he do? What are his duties? There is Rule 8. What does Rule 8 say? First, whatever assets or whatever security you are getting, see, he has to basically protect the interest of depositors. He has to protect the interest of depositors. In doing so, he has to first ensure, okay, the deposit amount is 1 crore. What is the security that they have got? Maybe they have got a security of 50 lakhs plus there is an insurance cover of 50 lakhs. So if we combine the insurance, if we combine the security, is it sufficient to cover the principal amount plus the interest amount? Is it sufficient to cover that? Ma'am, of course, then only we call them secure deposits. No, it may so happen that later on this security's value is declining. So the deposit trustee will be concerned and he has to ensure that at all times there should be sufficient security. He has to ensure that whatever circular you are issuing or advertisement you are giving should have all the information which is consistent with the trust deed. There is no contravention, there is no or there is all the times harmony between the provisions, right? There should be no breach of conditions. Whatever the company has promised, is it doing the same, right? If there is breach of conditions, then you take necessary steps to coordinate with the company. If supposedly the interest is not paid, or there is a delay, or there is a reduction in the rate of interest, what was promised, what has been given, so you take reasonable steps to procure a remedy, right? Whenever necessary, call the meeting of depositors, okay, and try to resolve all the grievances, whatever is necessary. Apart from that, when do you call the meeting of depositors? When at least 1/10 of the depositors give you or a requisition in writing. So there are, let's say, 100 depositors, which have given 1 rupee each, or let's say 100 crores. So 1 crore each, or whatever it be, right? So we have to understand that 1/10 of the depositors in value. That means any number of depositors holding at least 10 crores. Because 100 crores, if we are talking about the deposits, at least 10 crores. If they give a requisition in writing, then the deposit trustee will call the meeting. And he will also call the meeting whenever there is any default, right? So that is something that I already told you. Now, section number 74, although has become obsolete, but still we'll quickly decide that. Now, this is the time when there were deposits pre-hand. And now the deposits, Companies Act 2013 came and put a restriction that, okay, you cannot accept deposits for more than 36 months. So if there is any unpaid deposit as at the time of commencement of the act, or it becomes due thereafter, within 3 months, first of all, you'll prepare a statement and give it to ROC. That these are the deposits that we have as on date, and these are the repayment dates, and etc. etc. And then you have to repay them within 3 years of commencement. Supposedly your due date falls after 1 year only, you repay it. But supposedly the act has commenced and 3 years have elapsed and still your due date is far ahead. No. This is the maximum tenure, maximum transition phase that you have been given. So within 3 years, you have to repay it. Supposedly you cannot, your funds are blocked. Make an application to tribunal. The tribunal is going to consider your financial position and grant you extension if that is possible. Okay. Thereafter, we have the penalty. Penalty damages for fraud, section number 75, which talks about liability under section 447. We have section number 76A, which talks about the penalty or the contravention, which of course you will do it. And thereafter, this is something that I've already done. Thereafter, we have debt instruments. What are debt instruments? What are debt instruments? See, if I talk about the debentures definition, according to Companies Act classification, it has been defined in section 2 clause 30, which says debenture includes bonds also, and it includes any instrument which evidences a debt. It could be secured, it could be unsecured. It includes stock also, debenture stock, just like we have common stock, equity stock, like we have debenture stock. So it includes that. It is an inclusive definition which has been given. Now we have different types of debentures. You could be asked in examination, elaborate all the types of debentures, one, or you could be asked a question specifically that what are the debentures or what could be the debentures on the basis of interest rate. So you have fixed, you have floating, you have also zero coupon. So you can write like that, or you can be specifically asked any objective type of question within this, right? Okay, so first, redeemable debentures. What are redeemable debentures? When you get a debenture certificate, there is a specific date of redemption which has been written, and the company is obliged to pay you back the amount, the principal amount, on that particular date, on or before that date, right? Now, irredeemable, they do not have any date of redemption. That means when will it be repaid, ma'am? When the company will wind up, right? So when the company winds up, at that particular time, it will be repaid. Okay, it will be repaid at the time of liquidation. Or it may so happen in rare cases that you reduce the company chooses to reduce the liability, and at that particular point of time they repay it. Otherwise, they're like perpetual, going on and on and on and on, right? Then we have convertible and non-convertible. Now, in convertible, you have to understand convertible means your debt is going to be converted into equity after a certain period of time. Right? It could be fully convertible, it could be partly convertible. Fully means, ma'am, the entire debt is going to be converted into equity. Partly convertible means what? There will be some convertible portion and some non-convertible portion. Non-convertible portion will go ahead and be redeemed according to the terms of issue. It will be repaid, and convertible portion will be changed into equity according to the conversion rate. Now, everything is pre-decided. So at the time of issue of debentures, you know whether your debentures are convertible, they are non-convertible, they're partly convertible, they're fully convertible. Is it mandatory conversion, or do I have the option to convert? Optionally convertible means what? The option is given to the investor. You want to convert it into shares, you can. You don't want to convert, you don't convert. And non-convertible, where at all you don't get the option, they're not fully, partly, nothing converted. Issued for a tenure of 10 years, for 10 years, they will be remaining as debentures only, and after expiry of 10 years, they will be redeemed according to the terms of issue. Okay. Then we have secured and unsecured debentures, which I've already told you. Just one more thing I want to add over here. Secured debentures, which are secured by some assets. So by creating a charge on certain asset of the property, you get it secured. Unsecured. Why will anyone take unsecured debentures? Just like I have told you about deposits, like we have unsecured debentures also. See, unsecured debentures, usually you get high rate of interest. Of course, risk is involved, so people might be willing to take that. But more than that, you invest in that according to on the basis of credibility of the person, because they are naked debentures. Their unsecured debentures are also called as naked debentures. It's just the credibility of the issuer. Oh, he is asking for money, he'll not take my money and go away, right? No problem. Even if he's not providing the security, I'm getting a good return, so I can definitely go ahead and invest in that, right? Now there are SEBI guidelines that if you're making a public issue of debentures where the maturity period is more than 18 months, it has to be secured only. It cannot be unsecured. Debenture trustee has to be appointed in that case, right? Then we come according to the rate of interest. Fixed rate debentures, that means you have 10% debentures throughout the tenure, you'll get a rate of interest of 10% only. Floating rate, which is changing according to the market conditions, and it's based on some benchmark rate, maybe RBI rate plus 4%. So that is the rate of interest you're getting on your debentures. If the benchmark rate is reducing, your rate of interest is also reducing. So it is dependent upon the market conditions. And then we have zero coupon debentures. What are zero coupon debentures? They do not have any interest rate. They do not have any interest rate. So, ma'am, why will anyone again invest in zero coupon debentures? Because usually you get them at a discount. They're also called as discounted bonds. Why? You get them at 80 rupees and they'll be redeemed at 100. So you take it and they'll be redeemed at 100, so that the interest which you have foregone actually is compensated by the price difference or by the discount that they're offering, right? So usually this happens. There could also be a chance of getting some shares at discount. That means you could get a warranty like that. Okay, so that's it. Let's now revise the chapter of dividend, right? This particular chapter, if we look at the Companies Act classifications, it is chapter number 8, which contains section 123 to 127. Now, basically, first we have to understand what is the meaning of dividend, because if we go by the definition of dividend states that dividend includes interim dividend, so you won't find the real meaning. But when we look at the meaning, supposedly I am an investor and I purchase a share of 100 rupees. I would definitely want this to grow. I would definitely want my investment to grow. If I've invested 100 rupees, maybe today I am buying the share at 100. Tomorrow, if I want to sell it, it is being sold at 120. That means 20 by rupees 20. This investment has appreciated, right? This is basically nothing but a capital appreciation or increase in the value of shares, right? Now, how does it increase? Because the company is growing, the company is making more profits, there is more demand for the shares of that particular company and all of it, right? So that is the growth that you get in the value of shares. There is something more to it. Wherever a company is earning profits, it has a choice to make. It can either retain those profits, and if it has good reinvestment opportunities, and invest it or ploy it back to the business and make more profits, and likewise, or distribute it to the shareholders. Now, that part which is retained by the company of the profits, it is retained earnings. However, that portion of profits which is not retained in the business but is distributed to the shareholders, the dividend is distributed in proportion to the amount paid up on shares held by them, right? This is something that you already know. Now, if distributed, that is known as dividend. Now, a lot of times this might be a real attraction for the investors. Oh, this company pays dividend. I want to invest in this particular company, right? So, before we go further, I want to actually take you through this topic. This topic means what, ma'am? Financial parameters of declaring dividend. Listen to me very carefully. There are many companies which pay a large chunk of dividend, a large chunk of their profit as dividend. They are called as good payout companies. So whatever you are investing, you will soon get the payout also. And some companies which are very conservative in terms of dividend, they retain the profit as reserves and they're plowing it back, or whatever they're doing, they're called as bad payout companies. It doesn't mean that the company is bad. It just means that the payout is bad. Okay, it may be doing wonders by retaining, and maybe there is immense share growth or whatever, but it is a bad payout company. So that is something that you have to keep in mind from objective question perspective. Now, before we go on to check out the provisions, because any company can declare dividend except for section 8 company. That company is prohibited to declare dividend, so such a company cannot declare dividend. Apart from that, any company can declare dividend. How do you declare dividend? How do you pay it? What if you declare and don't pay? What if you do this? What if you do that? So there are a lot of provisions which we read over these sections. However, there is one in general thing, that if there is any company, why do you think the company will declare dividend, or why do you think the company will not declare dividend? So there are certain financial parameters or grounds or factors which need to be considered, which you need to see that, okay, if I want to declare dividend, I have to check my profitability. If the company is not making profits, because you all know that dividend can be declared from current year profits also and from past year profits also. It has to be declared from profits only because it is an appropriation of profit. It is distributing profits. It is not an expense that it has to be a charged and it can be booked even in case of loss. No. So maybe current year profits or past year profits or whatever be, you are declaring dividend out of that only. You are paying dividend out of your profits only. But supposedly earlier you were making very good profits and that's why you were declaring dividend. But in the past 2 years, the company has been declining. The profitability has been declining. If you continue to pay out the same dividend, well, don't you think the company might come in trouble? So, first thing that you must consider is the profitability. Second thing, what is the cash component that you have? Because if you have limited cash, you need cash. Dividend cannot be paid in kind, and dividend is not something which is like bonus shares. That means there is no outflow of cash involved, and you're only capitalizing the profits and issuing equity shares. So, dividend is not like bonus. Here you need proper cash. If you want to give away 2 crore of your profits to the investors, you need to have 2 crore cash. So what is your cash availability? Right? What is the cash flow? And is there any some future requirement of the fund? Maybe you have 2 crore cash and you have paid the entire 2 crore cash. Now what will you do? If you have immediate some outflow, cash outflow or fund requirement, then what will you do? How will you manage it? So these are the financial parameters which must be considered. Okay. Apart from that, operation of any other law. What does it mean, ma'am? Maybe you have been restricted that you cannot pay dividend because there is some law which has come into picture, right? Or there is some law which is prohibiting you to do that. So because of any law, you're not allowed to give away dividend as of now, maybe. So you cannot give dividend. So you have to not just see Companies Act, but you have to see all other laws also. It could be simply a court order also. Okay, or it could be some maybe under IBC or under any other law, you have been prohibited. No, you cannot declare dividend right now, so you cannot. You have to consider the losses which have been incurred, and it is advisable that if you have continuous losses, the board should not declare dividend. Next is restrictions in agreements with lenders or covenants. Covenants means conditions. Now it might happen that you go to a bank and you take a bank loan. The bank tells you that unless you pay 50% of the principal amount, you are not supposed to give dividends because of genuine reasons, of course. So, in such a situation, there is a restriction which has been imposed on the company by the lender that you cannot pay dividend. So, you cannot pay dividend. You have to consider that factor also. Unavailability or uncertainty of earnings of the company. We are not very sure about the financial results of the company, that what it will be, because if you're a salaried employee, you know that okay, on 5th of the next month my salary will be credited or whatever the date is, right? But if you're a businessman, then you have to assess everything. What am I expecting? What are the financial results which I'm expecting, right? Because there might be sales, there might be no sales, there might be a lot of sales, right? So what is it happening? We have to assess that. Availability of opportunities for reinvestment. Now, if I have, or if the company has generated a profit of 5 crores and all of it is available in cash, now the company thinks, what will I do of this 5 crore? They don't have any plan. The way their business is going on, they're fine with it. Even if they decide that, okay, let's put this 5 crore more into production, they don't have the customers to sell it. So whatever pace it is fine. They don't have any other growth opportunity in mind. They don't have any reinvestment. So they don't know where to use these surplus funds. So distribute it as dividend. On the contrary, if you have immense opportunities available, you should rethink and try to invest in those opportunities, right? And lastly, any cash outflow. Now, dividend distribution policy we'll do later. We'll come back. right? So company, you earn profit, you have a choice whether you can retain it or distribute it to shareholders. If you distribute it to shareholders, you can give it away as dividend, or there can be just capitalization of profits, and it is being said to the shareholders that okay, you hold one share, you get one more share of the company free of cost. You don't need to pay anything, you don't need to buy this share, you're getting it free of cost, right? How they're using it, they're using the profits to give bonus shares, right? They don't need to give any cash, but it's just like you're getting a bonus share. Fine. So that is being covered in the chapter of share capital, section 73. Here we are talking about dividend. Dividend basically are of two types, final and interim, which we read in this chapter. But before that, you also need to have a conceptual clarity on equity and preference dividend. Preference dividend is what? The dividend which is fixed, paid to the preference shareholders in priority over the equity shareholders. So supposedly the company makes a profit of 2 crores. First of all, it will give dividend to preference shareholders, and whatever is left will be used for paying dividend of equity shareholders if it is declared. Preference shareholders is obviously given every year because the rate is fixed. Ma'am, is it given even in case of losses? The answer is no. It is at the discretion of the company because it is appropriation of profit. So they cannot make it a charge, right? Now, one more thing. Supposedly, ma'am, there is heavy loss in a particular financial year, and the board of directors of the company decides that we don't want to pay preference dividend this particular year to preference shareholders. What will happen? It depends how the preference shares are being issued. Are they cumulative? Are they non-cumulative? If they are cumulative, then the preference dividend gets accumulated and it is going to be paid next year. If it is non-cumulative, then it's waived off, right? So they have to let it go. Right? Equity dividend is not fixed. Now we come to the main two dividends which we read about in this particular chapter, which is final dividend and interim dividend. Of course, we're talking about equity. Now, final dividend and interim dividend, what it is all about. Interim dividend is declared by the board between two annual general meetings. What is annual general meeting? The annual meet of the shareholders, right? So they meet once annually. That is known as annual general meeting. Now, supposedly, I'm talking about a financial year 24-25, which begins from 1st April 24 and ends on 31st March 25, right? Then the next financial year begins 1st April 2025, and then maybe here 25th September 2025 is AGM of 24-25. Now listen to me very carefully because these are dates I'm taking a bit of time to explain. Final dividend and interim dividend. Now, final dividend for financial year 24-25 will be declared only on 25th September 2025. That is the date of AGM. However, when we are talking about interim dividend for financial year 24-25, it can be declared during this financial year or after the end of financial year till AGM is declared. Okay. Yes, ma'am. Now, usually or practically what happens is once the financials are prepared, somewhere here, that means maybe 25th July. 25th July, the board decides that, okay, I know that in the last financial year we have made good profits and we don't need to wait till annual general meeting to declare dividends. We have the power to give away an interim dividend. So we declare interim dividend of 10% and we are going to give it to the shareholders. You can do that. The board of directors have the power to declare interim dividend. Clear? Okay, ma'am. Now, interim dividend can be declared in this period or in this period, right? The only difference between interim dividend and final dividend is that it is being declared by the board. However, final dividend is being declared by the shareholders and the sources are different. Sources are different. So these are the two differences that you have to keep in mind. Otherwise, by going by the definition of section 2 clause 35, dividend includes interim dividend. So if an interim dividend is declared, it has to be paid within 30 days. So the same provisions goes for dividend also and interim dividend also. Final dividend is declared at an annual general meeting, but again, it is proposed by board. It is declared by shareholders by passing ordinary resolution, as it is a matter of ordinary business at annual general meeting, right? Okay, ma'am. Equity shareholders will not get any dividend if there is a default of section 73 or 74, which is the chapter of deposits. You already very well know that. Now, once the dividend is declared, whether it is interim or it is final, it has to be transferred to a separate bank account in a scheduled bank within 5 days. Okay, when it is declared, from the date of declaration within 30 days, it has to be paid also. So you declare it within 5 days, you keep it aside, and from the date of declaration, that is from the date of passing of board resolution or ordinary resolution, whatever the case be, you have to pay it also. How do we pay it? Ma'am, in cash, not in kind. Dividend cannot be paid in kind. In cash means it could be bank, it could be a warrant, it could be a check. So electronic transfer, warrant, check. To whom do we pay it? We pay it to the registered shareholder or his banker or his order, maybe. He has ordered it, give my dividend to this, so fine, we'll give it to them. So only to that particular person. Fine? Now the point to understand. I told you, interim dividend and final dividend, the sources are different. We're not here to discuss about the accounting. Although in class, I usually tell you that also just to have good clarity, but this is revision. Now, listen to me very carefully. Interim dividend is declared by the board during any financial year or any time from closure of financial year till annual general meeting. The point to remember is the sources. Whatever profits have been earned in this financial year can be used for payment for interim dividend. Yes, ma'am. Whatever profits are there in P&L account can also be used for payment of interim dividend. Whatever profits have been earned over here till preceding quarter, supposedly you are declaring dividend, declaration of interim dividend. So if you're declaring it on 25th July here, from 1st April till 30th June, also the company might have earned certain profits. So these profits can be used, and the balance which lies in P&L account, this can also be used for payment of interim dividend. Now for all other chapters or for all other things, P&L account and general reserve is the same thing, but not for this chapter. General reserve is something or the profits that has been transferred to reserves. However, P&L balance is the profit which has not been distributed yet. It remains undistributed. So that can easily be used. But if you want to use the amount which has been transferred to reserves, then you need to comply with certain additional conditions. And that is something which is not available for payment of dividend or payment of interim dividend. Okay. Fine. So interim dividend, you use these three sources. Now, supposedly, in this quarter, from 1st April to 30th June, there is a loss. In such a situation, you declare interim dividend using these profits. Fine, you can. But then there is a restriction which has been put. What is that restriction? The interim dividend that you declare should not be a rate higher than average rate of preceding 3 financial years. So in last 3 financial years, whatever dividend has been declared, you sum total divided by 3, there comes the average. Not more than that rate can be given as interim dividend. Fine. Now we come to the final dividend. Now final dividend, again, the sources are going to be different. We are reading section number 123. So dividend has to be paid after providing for depreciation out of the profits of that particular year. So if you are declaring dividend for financial year 24-25, whatever profit has been earned after providing for depreciation, whatever you have been left with, you can give away dividend, not a problem. Out of past year profits also you can give. Out of past year profits have been divided into two categories. One is that remains undistributed, that is P&L account. So you provide depreciation and give away profit, not a problem. Give away dividend, not a problem. But the profits of past years which have been transferred to reserves. Supposedly, you want to give away a dividend of 2 crore when you have a profit of 2 crore, you give it, no problem. But supposedly, you want to give away dividend of 2 crore when you have a profit of just 1 crore left. Now, in this is a situation of inadequate profits. So supposedly a company has inadequate profits, they need to check whether I have some profit of past years undistributed lying in P&L account. They don't even have this. So they will see, do I have reserves? Yes, I have reserves. So can I use those reserves to pay dividend? Well, then you have to comply with these 4 conditions. Then you can use it and pay dividend. Condition number 1. The rate of dividend should not exceed average of last 3 financial years. So again, you sum, just like over here, you sum total, you take out the average, and the rate of dividend should not exceed that. Secondly, whatever amount you are drawing, what amount you're drawing in this particular case, you need 1 CR from the reserve. So this 1 CR should not exceed paid up capital plus reserves 1/10. Supposedly the paid up capital is 1 CR plus reserves is 1 CR. So sum total 2 crores, 1/10 of 2 crores, whatever amount comes, that is the maximum amount that you can withdraw for paying dividends. Thirdly, whatever amount you withdraw, you'll first utilize it for setting off losses, and thereafter whatever balance is remaining, that you can use for payment of dividend. And lastly, your balance of reserves, supposedly there was a reserve balance of 1 CR and you have withdrawn 50 lakhs. So what is the remaining? It's only 50 lakhs. Now this 50 lakhs should not be fall below 15% of paid up capital. So supposedly 15% of 1 crores. It comes out to be 15 lakhs. So here it is not satisfying. Your balance of reserves, whatever reserves is left over, should be at least 15% of paid up capital. Should be at least 15% of paid up capital. Now some students say, ma'am, if it is not 15% of paid up capital before that, you cannot withdraw. No, you cannot withdraw. Okay. So these 4 conditions have to be satisfied with, and then only you can use this. There is another source of dividend, which is money provided by government. Ma'am, why will government provide us the money? Maybe there is a company in which government has made investment and government wants general public also to make investment. So government took a guarantee, right? And they said that I will provide you dividend if this company fails to do so. So on the basis of government's guarantee, there are many people who have invested, right? This may be a situation. So in such a case, the government provides money for payment of dividend, and that can be used as payment of dividend, not a problem, right? Okay, ma'am. Now, Section 124, when the dividend is declared, it has to be transferred within 5 days to separate bank account, and from declaration, it has to be paid within 30 days. Now, if it is paid, very good. If it is not paid, consequences of Section 127 are attracted. Apart from that, supposedly there was a person who could not be traced and dividend was not paid to him. So will we keep it back? The company cannot keep it back. You will transfer it to a special account in scheduled bank, which is known as UDA, unpaid dividend account, right? If you don't transfer it, you'll be liable to interest at the rate of 12% per annum. Now, when you transfer it within 90 days, you'll prepare a statement. Okay, these are the last known shareholders who have not taken this particular amount of dividend, their contact details, whatever it is, and you'll put it on the website of the company. Any person who has not taken their dividend, they can apply to the company and take it. If it is taken, paid, great. If it still remains unpaid for 7 consecutive years, it will be transferred to IEPF. Ma'am, can we take it from IEPF? If I don't take my dividend for 7 years from the company and now it is shifted or it is given to IEPF, you can still claim it. You can still claim your money and IEPF will give it to you. Okay. Now, what is IEPF? Investor Education and Protection Fund, covered under Section 125. It is being managed and constituted by central government. There is a chairperson, CEO, and 7 maximum members, right? So they meet and they take decision. They have ample of employees, officers, resources. Everything is being provided by central government to them. They also maintain accounts. Their accounts are audited. Everything is done in this manner. Now, this is a fund. So this is a pool of money. From where do we get money in this particular fund and how do we use that particular fund? So from where do you get money? This unpaid dividend account. Somebody who has not taken their dividend, it comes over here. Government also gives grants or donation. This amount is being invested and whatever income is being generated from that investment, that is also used. There is application money. A company got a lot of applications. Now they allotted the shares and they want to refund certain applications, right? But the people are not to be found. So what do we do? The amount should be kept by the company? No, it should be transferred to IEPF. Likewise, if your deposits have matured, if your debentures have matured, if there is interest, if your preference shares have redeemed, but there is nobody who is claiming it, so you'll transfer it to IEPF, right? How do we utilize this? If the people were not claiming, they can anytime go to IEPF and claim. So unclaimed money, it can be refunded from that particular fund. Apart from that, it is going to be used for promoting investors' education, for educating them, right? For distribution of disgorged amount. There is somebody who has taken undue advantage, right? And that has to be distributed, right? Now, reimbursement of legal expenses. A lot of legal cases keep on happening. So to do that. Now, section number 127. If dividend is declared, it has to be paid within 30 days. If it is not paid, the company has to pay a simple interest at the rate of 18% per annum. Plus, the director is also liable or attracted to imprisonment and fine. But now listen. There is a company and the company had to pay dividend. The company tried to pay dividend to a shareholder whose bank accounts were available with the company, but the money was bounced because of incorrect bank details. The company informed the shareholder that, see, we are unable to remit dividend to you according to your instructions. You please respond and provide us with another bank account. The shareholder did not reply. Is it company's fault? The answer is no. Should the company be liable to interest? The answer is no. Should its directors be liable for imprisonment or fine? The answer is no. So there are these cases or exceptions where there is no offense under this section and the people involved over here will not be liable. How, ma'am? By operation of law. Supposedly there is FEMA in play and FEMA restricts you to pay dividend to your foreign investor. You cannot. Shareholder's direction cannot be complied with. Shareholder gave you an instruction that pay my dividend in this particular bank account only, and that is not you informed the shareholder that your instruction cannot be complied with, so you're not at fault. There is a dispute regarding right to receive dividend. Why? Because there was a transfer deed received by the company. Now we don't know whether to pay dividend to Mr. A or Mr. B. The shares have not been transferred yet. There is a confusion. There's a clarity. There is no clarity. There's a dispute. Dividend lawfully adjusted against the dues. The company has to take 500 rupees from Mr. A as a call money, which is due, and company has to pay 100 rupees to Mr. A as dividend. So they adjusted it. Now they are only going to take 400 from Mr. A. Fine. Non-payment not due to default of the company. So the company is not at fault in any case. So in such situation, these penalty or these liabilities will not be attracted. Okay. Dividend once declared cannot be revoked. And fine, this is the time limit. That's something you already know. Now we come to the last part, dividend distribution policy. SEBI loaded regulations. There was an amendment in 2016 and it came up with 43A, dividend distribution policy. Now, what is it all about? The top 1,000 listed entities based on market cap. You all know market cap. So, based on that, top 1,000 listed entities, it is mandatory for these entities to prepare a dividend distribution policy. Why, ma'am? Because a lot of investors actually have this opinion that from past 3 years this company is paying dividends, so I should invest in this company, and this year also the company will pay dividend. But to make an informed choice and informed decision, we actually must know that on what grounds this company is giving dividend. So what is their dividend distribution policy? So top 1,000 listed entities, you have to formulate and disclose an annual report plus website your dividend distribution policy. What is going to be in your dividend distribution policy? First, in which circumstances can we expect a dividend, or in which circumstances can we not expect dividend? We can be said that if this happens, the dividend will not be given. So we will be mentally prepared. Okay, the shareholders, the investors will be informed. They can accordingly sell their shares. They can accordingly buy and take decisions. Financial parameters which we consider while declaring dividend. I have told you the general financial parameters which should be considered by every company. Now here, in the dividend distribution policy, listed entity has to specify that which parameters are we going to consider, which internal or external factors are we going to consider for declaration of dividend. If at all we don't declare dividend and we retain this earnings, how are we going to utilize this earning? Okay, and supposedly there might be many times that, okay, these are the financial parameters which we thought, but this is something which has happened, and based on this we are taking a decision of not giving away dividend. So if there is a change in some parameter, or if you wish to have an additional parameter, then again you should disclose it along with the reason in annual report and on website. Apart from the top 1,000 listed entities, if any other listed entity wants to prepare dividend distribution policy voluntarily, they definitely can. There's no problem in that. Okay. Let's now revise the chapter of Accounts and Audit. Now, this is basically Unit 4 of our company law module, and it comprises of 3 things, I would say. Chapter 9 according to Companies Act, which is Accounts of Companies, and contains section number 128 to 138. Thereafter, Chapter 10 of Companies Act, which is Audit and Auditors, and contains section number 139 to 148. And thereafter, you have something called as CARO 2020, which ideally is a part of auditors reporting only. Okay, so we have to read about all these 3 in this particular unit of Accounts and Audit. So first we'll begin with Accounts of Companies, right? Chapter 9 according to Companies Act. Now we are talking about accounts of companies, right? So what are accounts? Every company is supposed to maintain certain accounts. What are accounts? Books of accounts. What are books of accounts? Now, books of accounts primarily has been defined in section 2 clause 13, which actually means that the records. Which records, ma'am? Records of sale, purchase. So whatever company is purchasing, whatever company is selling, the company's assets, liabilities, the money it's spending, the money it's receiving. So cash receipts, expenditure, sale, purchase, asset, liability, the record of everything is actually books of accounts, right? Now, not just this books of accounts, but we have something called as books and papers also, which is the supporting documents or the vouchers, the deeds. So all of that is covered in books and vouchers, basically, you can say, right? So books and paper contains all that voucher. Now, books of accounts plus books and paper, that means the record with respect to sale, purchase, asset, liability, receipt, expenditure, everything, plus its supporting documents, the deeds, the vouchers, contracts, everything. They have to be prepared for the entire financial year. Here comes in question, now what do we mean by financial year? Financial year basically means year ending on 31st March, or rather I should say period ending on 31st March of every year, right? So this is financial year. However, when a company is newly incorporated, and if it is incorporated on or after 1st January, then the financial year does not end on the coming 31st March 2000, whatever it is, on the coming 31st March, rather it ends on the 31st March of next year. So ideally what becomes is, supposedly there is a company which has been incorporated on 1st January 2024. So the financial year will not be like from 1st January to 31st March. No. It will be like starting from 1st January to 31st March 2025. 31st March of following year. Moreover, there is another catch. What is that catch? That, ma'am, if there is a company which has a subsidiary, which has an associate, and for some reason the consolidation is required. Now, in India, we follow this particular law and we have this particular financial year, but maybe if there's a foreign subsidiary, associate, or holding, whatever it be, and they follow a different financial year, now their accounts, their books cannot be consolidated. So there will be a problem. So in such a situation, companies over here can make an application to central government and ask to follow a different financial year. Central government may permit the same. So for such type of companies, the financial year may differ, right? Coming back to basics, every company is supposed to prepare the books of accounts plus books and papers, and in certain cases, items of cost. So that we read about it later, that which companies are also required to prepare items of cost. It is not relevant in case of all the companies, just manufacturing entities which come under a prescribed threshold, they have to prepare and maintain cost records also. Okay. So every company has to do this, and this has to be done according to accrual and double entry system. So no single entry recording. Okay, that I have received this much money, so I'll just write cash received 10,000. No, this cannot work. Cash received 10,000 against a particular creditor, whatever. It has to be the dual effect, and it has to be accrual. No cash basis is allowed. Okay, so this is basically about maintenance of books all year round. Now, when the year ends, you know what the financial year is now? When the year ends, you also have to prepare financial statements. Financial statements are basically covered in the section 129, and we are still reading section 128 from where the chapter begins. But I'll still tell you, what are financial statements? Balance sheet, P&L account, or in case of section 8 company, it's like income and expenditure account, receipts, expenditure, right? Receipts, payment, income, expenditure. Cash flow statement, statement of changes in equity, explanatory note, and there is one more thing which you must remember about about financial statements, is that the financial statements of one-person company, small company, dormant company may not include CFS, cash flow statement. So such type of companies are allowed. They are not supposed to prepare CFS. So cash flow statement is exempted for that part, right? Okay. So this has to be prepared at the year end. Okay, this is given in section number 129. Coming back to our very first section, section number 128, you prepare the books of accounts. Where do you maintain this books of accounts? Okay, let me first take you through certain pre-basics, I would say, before we actually go to the main section, section number 128. So every company maintains this for the entire year, which may also be inspected according to the provisions, and prepares financial statement at year end, which is approved by the board, given to auditor. His audit report is obtained, which is circulated to the members, and at annual general meeting, the members adopted by passing ordinary resolution, which is filed with ROC. Now, section 128, every company, you must prepare books of accounts for every financial year on accrual and double entry basis by complying with accounting standards as given in section 123, which must give true and fair view. It is not just for the sake of preparing books that you're preparing. No, the books should actually present a true and fair picture of the company. So what is the position of the company? That should actually come out, right? Now, these books can be maintained in physical form, or it may also be maintained in electronic form. Considering the evolving technology, we would say that gone are the days when actually the books were maintained in physical form. So now in every place you'll find it in electronic mode only. Some people use tally, which is very conventional and traditional now, I would say, but then still it is in use by a a lot of offices. We have a lot of ERP softwares. We have QuickBooks, right? So we have a lot of accounting softwares, but the software, whichever you're using, should have audit trail feature. Now, there are certain things which must be followed. Rule 3 of Companies Accounts Rules 2014 actually tells us that, okay, fine, if a company wants to prepare books in electronic mode, they can. They want to prepare the books, keep its books, relevant papers, they can. But then they have to follow certain conditions. That conditions are being laid down in Rule 3. What are the conditions? First, it should be accessible in India. Accessible in India, of course, it is an Indian company, it is registered in India, so it should definitely be accessible in India no matter where your operations are, right? It should be completely retained in the original format. Often it happens that, okay, fine, this is the information which has been prepared by a particular official, but when we are trying to record it in the electronic form, we have altered its format, and now if there's some error and we want to trace it back, we cannot, right? So it should be retained in the original format in which it was created, or in which it was sent or received, or whatever it be. The information that you receive from the branches also should be kept unaltered. Okay, so that again accountability may be established, right? It should be in legible, proper form. There should be proper storage, there should be proper retrieval, and you should also be able to take the printout of the same. Because everywhere you cannot carry your systems and make decisions. A lot of places you need management information system reports, that is MIS reports. You need to take a lot of decisions, right? So you need printout also. Fine. So it should be capable of being printed. Okay. And then backup should be taken. What is one more thing that you should keep in mind over here is that you might be using a service provider, Indian service provider, outside service provider, whatever it be. You have to provide certain information to ROC on annual basis. The name of your service provider, if you are maintaining your books in electronic form, IP address of the service provider, location of the service provider. Now, if the service provider or you're maintaining it on cloud, then whatever address is provided by the service provider, that address you will give. Okay, so this has to be intimated every year on annual basis to ROC. Okay. The books of accounts that you prepare have to be preserved for a period of 8 years, and there might be longer period if the investigation is ordered. Okay. Now comes your place of maintenance. Where do you maintain it? You don't have to confuse this particular provision with Section 88. Section 88 is something that you have read before, which talks about the register of members and where register of members can be kept. Here we are talking about the books of accounts. Now, books of accounts are basically the concern point for directors. Shareholders are nowhere concerned about it. I mean, I don't know what's happening with the Reliance Industries Limited, and I'm not concerned about it, right? And they'll not even let me see their books of accounts and all that, right? So basically, books of accounts, papers, they're all kept at the registered office, but they may be kept at any other place as the board may decide. They might feel that, okay, no, most of the times we are here only, let's keep it over here only, it will be easier, it will be more convenient, there's more space, there's more facility. Fine, go ahead and keep it. But it is important that you inform ROC that where your books are kept, right? So books of accounts at the registered office of the company, it may be kept at any other place as the board may decide. Wherever you keep it, within 7 days, give a notice in writing in AOC 5 to ROC and inform ROC that, okay, this is the place where we are keeping our books of accounts. Now, there could be a situation that a company has a lot of branches and the records relating to branch, it's convenient to keep it at the branch only. Go ahead and keep it, not a problem, right? But periodical returns must be sent to the registered office or to the place where main books of accounts are prepared. Okay. Now, as I told you, shareholders are not concerned with the books, and hence they do not have any power of inspection. The books of accounts of a company can be inspected by the director. If director does not have much knowledge about the books, then it may be inspected by his agent. He may appoint an agent and it may be inspected by his agent. Because ultimately, according to section 128(6), the managing director, whole-time director who is in charge of finance, CFO, or there could be any other person who is charged by the board, they are responsible for maintenance of proper books of accounts. So in a company, if the books of accounts are not maintained and we have a CFO, the CFO is going to be responsible. We have a whole-time director who is in charge of finance, he's going to be responsible. If we don't have, managing director is going to be responsible, or any person who has been entrusted with the responsibility of doing so will be responsible. So they are the ones who are going to be responsible, and hence they have this responsibility. Okay, I will be penalized if they don't maintain proper books of accounts. So I must constantly check whether books of accounts are being maintained in a proper manner or not. So they want to check it, they want to inspect it. Go ahead and do that inspection. You are allowed to do that. So whatever books are being kept at the registered place or any other place, maybe we have summarized returns of the branch, or maybe there is any information which is outside India, and you want to check that whether it has been incorporated, what has been done, how has it been dealt. So all that can be inspected by the directors or his agent during business hours. With respect to outside financial information, director has to give a request, and thereafter it is being produced within 15 days. It cannot be produced instantly. That is a but obvious thing, right? And this can be done by the director himself only. However, all others can be done by director, his agent during business hours. Now, there's one more thing which you should keep in mind. The officers have to provide complete assistance to the directors who are inspecting. That is completely fine. But if there is a company, ABC Limited, it has a subsidiary, PQR Limited. Now, a director wants to inspect the books of the subsidiary. He cannot do so unless he's authorized by a board resolution. So he will go to his own board of directors, he will seek permission, a board resolution will be passed, and then he can do that. Okay, so a director has the power of inspection of books of accounts of his own company only. Fine. Okay, financial statements, I've already told you what they are. Now, every company has to prepare financial statements, and they have to be prepared according to the format which is given in Schedule 3. We all know that Companies Act has total 7 schedules, out of which Schedule number 3 is the format which is being given for the companies to prepare the financial statements, right? Now, when we talk about the format, we have insurance companies, we have banking companies, we have electricity companies who do not follow this format. Why don't they follow this format? Because they have a specific governing act wherein the formats have been given. So they follow those formats only, right? So this is not applicable to these type of companies. Whatever financial statements you're preparing, they have to be giving a true and fair view and according to the accounting standards. If there is deviation from the accounting standards, then why is there a deviation? You need to disclose certain things. What is the deviation? Why is there a deviation? And what is going to be the effect of this deviation? So this has to be disclosed. Now we have something more called as consolidated financial statements. Now, when consolidated financial statements have to be prepared and by whom? If there is any company which has one or more subsidiary or associate, then it has to prepare its own financial statements plus a consolidated financial statements. Consolidated means the combination of its financial statement plus its subsidiary. So the turnover has to be merged. Okay, I make a turnover of 5 crores. My subsidiary is making a turnover of 2 crores. So consolidatedly, our turnover is of 7 crores. So that's how you consolidate the financial statements. And as I told you before also, that the financial statements are laid to the members for their adoption. So the consolidated financial statements shall also be laid before the members at the annual general meeting. Let me first tell you this. financial statements plus consolidated financial statements plus AOC1. Ma'am, what is this form AOC1? You must remember this form number also. Now, this AOC1 form is about the salient features of financial statements of subsidiary. The financial highlights, or whatever you can say, salient features of the financial statement. So this is also given separately. This is also given separately. Okay, this is clearly written. So this will be prepared. It will be laid at an annual general meeting and filed with ROC. If you do not comply, then non-compliance attracts penalty. Now, there is certain exception or exemption, you can say, which is being given to certain kind of companies which are not required to prepare consolidated financial statements. Ma'am, what are those kind of companies? Supposedly we have a company A Limited. It holds 70% shares in B Limited. B Limited holds 100% shares in C Limited. Okay. C Limited, B Limited, you both have a relationship of holding subsidiary. So when I talk about B Limited is a company which has one subsidiary, and hence it must prepare its standalone financial statements plus its consolidated financial statements and lay at the annual general meeting, right? Yes or no? This is what we have read so far. But. Now we are going to read about the exception. What is the exception? That if you are a wholly owned subsidiary or partially owned subsidiary of another company, B Limited, are you a subsidiary of another company? The answer is yes. You are a partially owned subsidiary of A Limited, right? And all your members, there has been no member which has objected that, okay, fine, don't prepare. You don't want to prepare CFS, it's fine, don't prepare it. So nobody has objected that, oh, you have to prepare CFS. Condition number 1, you are a subsidiary. Yes, you are. Condition number 2, members don't object. Fine. Condition number 3, you're not listed. You're an unlisted company. Fine. Condition number 4, your holding prepares CFS. So if these 4 conditions are met, you are exempted from preparing CFS. So A Limited, which is the ultimate holding company, or there could be an intermediate holding company also, they actually prepare CFS according to accounting standards. So in such a case, B Limited, you are exempted. Right? Okay. So contravention penalty, I'm not discussing in detail. Then moving to the next section, section number 134. We also have section number 133 in our syllabus, but it's actually concerned about the accounting standards, which I've already told you. So we have Institute of Chartered Accountants of India, we have NFRA, we have central government. These are the 3 bodies which play role in prescribing accounting standards. Okay. Now, section number 134, financial statements, signing or authentication, and board's report. So board's report, we'll read about it a little later, but right now we are talking about the signing or authentication of financial statements. The financial statements, CFS, they're approved by the board. Of course, they're prepared by the finance team or the accounting team. They come to the board. They say, okay, fine, this is what we have prepared. Now the board is going to sign it. How does the board sign it? If the chairman is authorized by the board, it is signed by chairperson and CEO, CFO, and CS if appointed. If it is not authorized by the board, then 2 directors, out of which 1 shall be MD, and CEO, CFO, and CS if appointed. So this is how signing is being done. In case of 1-person company, we might have just 1 director, so it is signed by just 1 director. Okay. Now, after it is being approved by the board and signed in this manner, it is given to the auditor for audit. Okay. Now, when the auditor actually audits, He gives a report on different matters, general report, report on internal controls, CARO report, everything is being given. And this particular set means what, ma'am? We have a set that is signed copy of financial statements, notes, auditors reports, and we also have something called as board's report. Okay, this entire set, CFS, everything is circulated. How is it circulated? The members actually have a right to get this before general meeting according to section 136, because if at annual general meeting the entire set somehow goes up to 200 300 pages, and if you ask the members, okay, come on, read this 200 300 pages and tell whether you adopt it or you don't adopt it, right? So it will be very difficult for them to make a decision. So these set, the entire set, audit report, all the annexures of the audit report, that is annexure on report on internal financial control and everything, this is being sent by every company to the members, to debenture trustee, and every other person who is entitled to receive the notice of general meeting. So it is sent to everyone. Okay. It is sent at least 21 days before annual general meeting. So ideally it is sent with the notice only, if not much before, because the notice also has to be sent at least 21 days before. We have 21 clear days, right? So it is usually sent with the notice only, although here they don't exactly write the clear days, but it has to be sent 21 days prior. Now, you sent it and the members will read it, they will be prepared, and they'll come and vote, right? Sometimes it may so happen that the financial statements are not ready and we cannot send it so much prior hand, so they have to obtain the consent from the members to send it a little later. Okay, the consent is being asked properly. Okay, we are going to send it itna days after, whatever it is, right? Consent is obtained from whom? If the company has share capital, you will take consent from members holding at least 95% of paid up capital. If they agree that, okay, fine, you can circulate us these documents for lesser than 21 days, it's fine. You can send for a lesser period than 21 days. If the company is not having share capital, you will take consent from the members holding 95% of voting power. You take the consent in writing. Okay. So this is how you will be sending. Now there is something more. In case of a listed company. Now listed company, it becomes even more difficult. Why? Because there are a huge number of people who are associated with the company, and there is a lot of documents which are being, because you have to comply with a lot of SEBI regulations and everything. So the set is also very huge. Now what should be done in such a manner? So listed company, do this, or better, make your financial statements available for inspection at the registered office 21 days before annual general meeting, and send a statement which is AOC 3. Okay, statement containing salient features of the entire documents in AOC 3 to every member, to every trustee, to everyone, unless they ask for full statements. If they ask for full statements, that particular shareholder can be provided with the full statement. Otherwise, do this and it's going to be sufficient compliance. Yes, apart from that, a listed company also has to place the financial statements on its website. The financial statements of subsidiary also has to be placed on the website. Now, the financial statements of subsidiary must be audited. But supposedly audit is not mandatory in that particular country. Why will they get it audited? So place unaudited financial statements only, not a problem. If they are in some Chinese, Japanese language, you have to translate in English and then you'll place it. Okay. Fine. How do you circulate this, ma'am? How do you circulate this to all the members? Well, you circulate it the way you want to. In case of listed company and in case of public company with net worth more than 1 crore and turnover more than 10 crore, there is a manner of circulation which has been given. Although, again, I would say this has become irrelevant, because gone are the days when we used to have our shareholding in physical form. Now we have the shareholding in demat form only. right? Especially of such companies, it is not even permitted to have shareholding in physical form, but still, because the provision exists, so we are reading it. So, listed company or such companies, you have to see if your shares are in electronic form, you will send the documents by electronic mode only. Now, you will see all the notices that you receive of the companies, all the financial statements or set which is being circulated, you will all receive it via email only as a PDF attachment. This is how you get it. This is the ground level or practical reality, what we are seeing, right? But the provision says that if the shares are not in demat, then ask the members if they consent to receive it electronically, send them in electronic mode. If they don't give consent, then you have to dispatch physical copies to them. Board's report, my dear, is a huge topic, and often it is being asked also. I don't know why, but the entire section 134, which contains a huge list of what should be included, what should not be included, is being asked, and hence you must actually know this and try to remember as many points as you can. So I have shortened those points. See, board's report has to be prepared by whom? By the board of directors. They basically contains the financial summary or the highlights. Okay, the company performed in such a manner, and the board is being entrusted with a lot of responsibilities like you have to meet, you have to check the related party transactions, you have to comment on why auditor found or why auditor has given a qualification remark, right? So director is being entrusted with a lot of responsibility, with a lot of duties under the entire companies act, and here those directors or that particular board of directors is actually preparing a report. Okay, what we did the entire year. So the web address, the number of meetings of by board, how many times we met. There is a director's responsibility statement which actually has a lot in detail to be written. And how did you prepare your annual accounts? What are the accounting standards that you followed? You prepared the accounts on the basis of going concern. What is the accounting, or you took proper care for maintenance of accounting records, right? Internal financial controls that you followed, right? You have maintained proper systems for compliance of laws and all that. So all that part is included in the director's responsibility statement. Thereafter, the details of fraud reported by CAC. When we talk about the fraud which is being reported by the auditor, we have two types of fraud. One is of lesser quantum, which has to be only told to the board. Okay, fine, we tell it to you and you report it in your board's report. The second is of huge quantum, which actually has to be reported to central government. So here we are talking about the fraud which was reported by the auditor to the board of directors, what action they took, and they have to incorporate it in their board's report, right? Okay, so about nomination and remuneration committee, about your explanation, as I already told you, then particulars of loans or contracts with related parties, whatever amount you have transferred to the reserves, right? Section 186, LGSI, what is that you are recommending by way of dividend, right? Then we have something called as conservation of energy, technology, CSR, section 135. There are other prescribed matters like financial summary, the changes in KMP, changes in nature of business, changes in subsidiary, provisions with respect to deposits, right? Then Sexual Harassment Act compliance, cost records, if applicable, of course, then any court or tribunal's order, etc., etc. You can learn as much as you can. There is an abridged report for OPC and small company. So it contains lesser information which needs to be attached to the financial statements. Fine. Okay. This is something that we have already done. Now coming to section number 137. Section number 137 talks about filing of certain documents with the ROC. What are those documents? Your financial statements, of course. And they have to be filed with ROC. So annual general meeting took place In annual general meeting, the financial statements, CFS, auditors reports, boards report, all the annexures, they are going to be placed before the members, and members adopt it by passing ordinary resolution. Once they adopt it, you have to file the same with ROC within 30 days of annual general meeting. This is the general provision or the general rule that we have, right? Now, supposedly, annual general meeting was held, but all these were not adopted. For whatever reason, members suggested some changes and hence the meeting was adjourned. So what you'll do is, you will file it with ROC within 30 days of annual general meeting. Now, ROC takes in record as provisional records. Okay, once your meeting is finalized, once these documents are adopted by the members, again you will do the filing, and then ROC will register it as final documents. But what happens if AGM is not held? Are we not supposed to file our financial statements with ROC? Then also you have to file the financial statements with ROC. Ma'am, how do we do that? Well, whatever financial statements were prepared, you will file with ROC, and you will also furnish the reasons that why AGM could not be held. Okay, why AGM could not be held. Fine. Okay. So this has to be remembered, otherwise there is a penalty. Then we have a section called as CSR. Although when we talk about the syllabus of CMA final, CSR is basically covered in the chapter of corporate governance. Main content we find over there only. However, the governing provisions originates from Companies Act section 135. So here we talk about lesser content. Firstly, which companies are required to do CSR, right? So applicability of CSR, the company which meets any of these three criteria. That means if your net worth is 500 crores or more, or your turnover is 1000 crores or more, or your net profit is 5 crores or more. So in such a case, you are subjected to CSR provision. So you will calculate what is the CSR expenditure that you have to do, how you'll calculate this. 2% of average net profit of 3 immediately preceding years. So 3 immediately preceding years, supposedly the average net profit comes out to be 6 crores. So 2% of 6 crores will be your CSR expenditure which you have to incur. Now, if this expenditure is within 50 lakhs, it does not exceed 50 lakhs, it is 50 lakhs or lesser, then the board can do it. The board can take decisions and they can incur CSR expenditure. If it exceeds 50 lakhs, then you need a separate committee called as a CSR committee. Now, this CSR committee will consist of 3 or more directors, out of which at least one shall be independent director. Okay, so you'll prepare that CSR committee, and CSR committee will actually recommend that, okay, we should do this because you give preference to your local area. CSR is what? Corporate social responsibility. So corporates have a social responsibility to deliver. So they are contributing something towards the society, right? So whatever you're contributing to this towards the society, it can be implemented by itself, or it could be a third party implementation. There are process and everything that we read in corporate governance chapter. Here we have to remember one thing, that there is something called as ongoing project also. What is ongoing project? Ongoing project is like if you are doing CSR expenditure, it may so happen that let's do something good, let's do something meaningful, and it's going to take a span of 2 years, but I have to incur 1 crore in this financial year only. So what do I do? So for that reason, supposedly you're building a school and it's going to take 2 years. This year you have spent 50 lakhs out of 1 crore, which was the minimum CSR expenditure, and you have spent only 50 lakhs. So what you do is the remaining 50 lakhs you transfer within 30 days of end of financial year to unspent account in a scheduled bank, and you can utilize it thereafter within 3 years, right? So that's something that you must remember. And the last section for the chapter of accounts of companies is internal audit, where just one question is being asked every single time, and that is, which companies are required to appoint internal auditor? Firstly, internal auditor could be an individual, it could be a partnership firm, it could be a body corporate. Okay, fine, ma'am. Now, internal auditor can be an employee, or it may not be an employee of the company. It can be chartered accountant, it can be cost accountant, or it can be any other professional which may be decided by the board, right? So the scope of audit is being told by the company, and the internal auditor does the same. Now, which companies are required to appoint internal auditor? Every listed company. If you are an unlisted public company having any of these, paid up share capital of 50 crores or more, turnover of 200 crores or more, outstanding loans or borrowings of 100 crores or more, or outstanding deposits of 25 crores or more, right? 25, 50, 100, 200. So into 2, into 2, into 2. That's how you can learn it, right? Outstanding deposits at any point, loans or borrowings at any point, and these two of course are the balance sheet date. Private company, if you're having your loans or borrowings 100 crores or more at any point in financial year, or turnover of 200 crores or more in the financial year, fine. So such type of companies are required to appoint internal auditor. Okay, the next topic now, audit and auditors. That part is covered in chapter number 10, sections 139 to 148. Now, as I've already told you this, that audit is something which is mandatory for every company. We're talking about stat audit. We're not talking about internal audit, right? So we have a statutory auditor. Sometimes we also have cost auditor, wherein cost audit is compulsory, right? Then we have some other special types of audit also. Now, we begin with section number 139, but actually before that, some background. Some background is very well given in this particular chart, and we'll go through that. Where a company is incorporated, it has to appoint auditors according to section 139. Now, who can be an auditor? An auditor can be an individual also, an individual, or it could be a firm also. It cannot be a body corporate. So auditor can never be a body corporate. The only exception is LLP, right? LLP, even being a body corporate, can be appointed as an auditor. If you are talking about a firm, the majority of the partners should be CA, and only a CA can actually sign the audit report. So we need to have a CA in practice who can be the auditor basically, right? But then the struggle doesn't actually end over here. It is mandatory for every company to appoint auditor according to section 139. But whoever you choose to be the auditor, that particular auditor has to, one, give his written consent that, okay, I agree to be the auditor. Second, we need to obtain a certificate from him. What is the certificate that we need to obtain from him? There are going to be four things. I would say rather five things also you can say that has to be written in that certificate. Number one, that you are eligible for appointment. You're not disqualified according to section 141. So we have a section 141, basically subsection 3, which actually talks about a huge list of disqualifications, that these are the persons who cannot become the auditor of a company, which we'll discuss later, right? So you are eligible for appointment, you're not disqualified. Your appointment is according to the term provided under the act. What is the term? We will talk about the rotation of auditors a little later, which talks that, okay, an auditor can be appointed for one term of 5 years, an individual. And if we talk about the firm, for maximum 2 terms of 5 years. So that is, so whatever term is being provided, your appointment is within that term. Secondly, it is within the limits which have been laid down. So it is not like, okay, you are somebody who has immense capacity, okay, so you do 1,000 audits. No, a person has a capacity, and if we do not restrict, the quality of the audit will be compromised. So a restriction has been placed by the act that, okay, one particular person can do maximum these many audits. So you have to have that audits within the ceiling limit, right? There might be some disciplinary proceedings going against you, during which you're suspended to take audit assignments. So you cannot, if you're not suspended, you have to correctly disclose about the proceedings which are going on against right? So all this has to be given in the certificate, and thereafter you can appoint such particular person as the auditor. Once you appoint them, you will inform the auditors, and you will also file the notice of appointment with ROC, that is ADT 1, within 15 days of appointment. Of course, once an auditor is supposedly appointed for 5 years, during those 5 years he may be removed also, and he may also himself resign, subject to the provisions which are being given under the Act. Okay, so now we come to the part of appointment, how an auditor is being appointed. We have, my dear, two types of companies. One is a government company and one is non-government company. Why are we classifying it this way? Because we have to read the provisions of appointment of auditors separately for these two types of companies. Because when we talk about government companies, the power to appoint the auditor and its governing authority, everything lies with CAG, that is Comptroller and Auditor General. Okay, so first we'll talk about the non-government company. Non-government company, we talk about the appointment of first auditors and the appointment of subsequent auditors. Ma'am, why is it different? Because when the company is being incorporated, supposedly a new company is incorporated on 4th April 2024, right? Now, I told you that auditor is being appointed at annual general meeting. This is something that you already know. It is a matter of ordinary business. Every year at annual general meeting, we look at this and we see about the appointment of auditors, appointment of directors. They are matter of ordinary business, and we appoint them at annual general meeting. Whoever is qualified, whoever fulfills the criteria, whoever gives his consent and certificate and all that, right? Fine. But if we wait till annual general meeting, don't you think it will not serve the purpose? Because the entire financial year is gone. The financial statements have been prepared. Who will do the audit? Because the financial statements, once prepared and approved, are given to the auditor, but the company doesn't have the auditor because it will wait till annual general meeting to appoint the auditors. The first auditor, you cannot wait till AGM for appointment. So the first auditor has to be appointed pre-hand only. But yes, the second auditor or any subsequent auditor can be appointed at annual general meeting. That is not the problem, right? So when we look at the first auditor, it has to be appointed by the board. It has to be appointed by the board, and he is going to hold office till the conclusion of first annual general meeting. So he's appointed from, at whatever date he's appointed, from that particular date till conclusion of first annual general meeting, and thereafter from conclusion of first AGM till conclusion of sixth AGM, and likewise for every next 5 years, second or subsequent auditors are being appointed. Now here I introduce another concept, which is the concept of audit committee. Fine. Because we have a rule 3, companies audit and auditors rules 2014, wherein we talk about the detailed procedure with respect to the audit committee. What is audit committee? First of all, we have a section 177 under Companies Act 2013, which talks about audit committee. Audit committee is nothing but it is a group of that company's directors which are dedicated to the cause of audit. So they are the ones who have good qualification and experience in the field of audit, in the field of finance, and they can actually identify, okay, this auditor can be appropriate for the company, right? So they can think about which auditor should be appointed and how the auditor is doing the work and all perspective related to audit and everything, right? So they only recommend. Their decision is not final. They are the ones who look after this thing. They come up with a lot of recommendations to the board, and the board thereafter decides the same. But in most of the cases, board agrees with the recommendation. Sometimes it may so happen that the board disagrees with the recommendation of audit committee. In such a situation, supposedly audit committee has recommended a name that Mr. A should be appointed as the auditor, and the board says, no, we don't like Mr. A. Then why are they not liking? So they refer back the recommendation to audit committee. Audit committee what thinks, okay, fine, if they don't like it, we'll find some other name. Or they are so adamant that they say, no, Mr. A is the perfect choice. So they decide not to reconsider what board is saying. So they will Again, we stick at our own recommendation. Now it is the board's choice. Board may agree, board may disagree, right? Because you referred back and the audit committee is still intact, right? So now it's your choice. You may agree, you may disagree. So if you disagree, then you have to report the same in the board's report also. Okay. And if you agree, then there's no problem. Okay. So this is how the whole process actually works. Now, let me take you through the appointment. Audit committee is not required to be appointed or to be constituted by every company, right? Because if it is a small company, who has to be the auditor? There are not many functions of audit committee that can be done by the board itself. But if the company is huge, like it's a listed company, then you need to specifically have audit committee. You need to specifically have nomination and remuneration committee, stakeholders relationship committee, and likewise a lot of committees, CSR committee. So you have different committees which actually work on their core areas, right? But otherwise it's not needed. So in certain companies you need audit committee, in certain companies you don't need audit committee. Company which is required to constitute audit committee, in that case audit committee will recommend a name to the board and board is going to appoint. If board appoints, great. If board doesn't appoint, then the members will call EGM, because annual general meeting happens only once in a financial year. EGM, extraordinary general meeting, that is meeting other than AGM is EGM. So they'll call EGM within 90 days and they will appoint the auditor. Now, supposedly there is no requirement of audit committee, then the board directly will appoint the auditor within 30 days of registration. Okay. If they appoint, great. If they don't appoint, the members appoint. So this is how the first auditors are appointed. If we talk about the subsequent auditors, then subsequent auditors again. If there is audit committee will recommend to board. Board will recommend to members. Because now the appointment of auditors is going to be done by the members by passing ordinary resolution at annual general meeting, right? So they recommend to members and they're appointed by members at ordinary general meeting. If there is no audit committee, the board recommends a name to members and they're appointed. Who can be appointed at annual general meeting? Well, the first auditor which was appointed by the board, he may be reappointed, or there might be someone else who is appointed. So both the situations may exist. He may also be reappointed if he is not disqualified, if someone else is not being appointed and there is no resolution passed of his non-appointment. Clear? Okay. Coming to the government company. Government company, if we are talking about the first auditor, now the difference between government and non-government company is that in case of non-government company, the auditors are being appointed for a tenure of 5 years. However, when we talk about the government companies, the auditor is being appointed for a tenure of 1 year only. So he'll be appointed and he'll be appointed till the conclusion of annual general meeting. That's it. His role ends. So the first auditor is appointed by CAG within 60 days. If they do it, great. If they don't it, by board within next 30 days. If they do it, great. If they don't, by members within next 60 days to hold office till the conclusion of annual general meeting. Okay, ma'am. Subsequent auditors, they are appointed by CAG within 180 days from commencement of financial year. From commencement of financial year to hold office till the conclusion of AGM. When does the AGM conclude? 30th September, let's say. And if we begin the financial year, 180 days, again 30th September. So somehow you have the auditor every time, right? Okay. So that's how it works. Next, coming to rotation of auditors, section 139(2). Now, let's eliminate one-person company. Let's eliminate small companies. We have listed companies and we have certain companies which are prescribed. Prescribed like what? Unlisted company, unlisted public company which has a paid up capital of 10 crores or more. Unlisted public companies which has a paid up capital of 10 crores or more. Private limited companies which have a paid up capital of 50 crores or more. You might see at some places this to be 20, that has been long amended, right? So it's 50 only. Or the companies with public borrowings or public deposits of 50 crores or more. So these type of companies plus the listed company, rotation is applicable on you. That means you cannot have one single auditor for life. You need to rotate your auditors. That means you need to change your auditors. Simple. Ma'am, what is the limit? I have already told you. If you appoint an individual as auditor, you can appoint him for maximum one term of 5 consecutive years. So once his term ends, there is going to be a cooling period of 5 years during which he cannot be appointed. After those 5 years end, again he can be reappointed. That's how it works. And if you appoint a firm as an auditor, you can appoint the firm for maximum 2 terms of 5 consecutive years. Again, there will be a cooling period of 5 years, right? Now, during this cooling period, there are certain things that you should remember. During this cooling period, you cannot appoint another audit firm with a common partner. So you appointed this particular audit firm where Mr. A was a partner. Their tenure of 10 years has expired. Now you appoint this particular firm again where Mr. A is also a partner. You cannot do that. So during cooling period, such a firm cannot be appointed. Such a firm cannot be appointed, right? This particular, I'm not revising, this is something which has become redundant or obsolete, right? Members may resolve to provide for internal rotation. Supposedly, there are 5 CAs in a firm. So, members may say that, okay, for these 5 years, every year, a new CA will be doing the audit and will be the signing partner. So, this may so happen. Okay, fine. How this rotation take place? Again, if you have audit committee will recommend the name to board, and board of directors will propose the name to members, and members will actually appoint it considering the fact and everything, right? Okay. Now, casual vacancy. What is casual vacancy? Casual vacancy is a situation where we don't have an auditor before his term has actually ended. So if we appoint an auditor for a tenure of 5 years, we know that after 5 years, we have to appoint another auditor. But what if he dies, or what if he becomes incapable, or what if some disqualification is attracted, or he resigns? Any such thing happens that results in the casual vacancy in the office of auditor. Now, this has to be filled by the board within 30 days. Simple. In case of a non-government company. But supposedly the auditor resigned. Usually when the auditor resigns, there are very high chances that they were somewhere, the management was not so cooperative. So in such a situation, there is additional compliance which is being given over here. What is that? The auditor resigns, no problem. You fill the vacancy within 30 days, but the same is going to be approved by members by holding a general meeting in the next 3 months. However, if you're a government company, the government company casual vacancy shall be filled within 30 days by CAG. If it is filled, great. If it is not filled, then the board is going to fill it within next 30 days, right? Here we come to one of the most important provisions of this particular chapter. So section 139 basically ends. Section 140 talks about removal of auditor, which we'll read a little later. Removal, resignation, and all that notice. So we straight away come to section number 141. 141 basically says that who can be an auditor? Only a chartered accountant can be the auditor. Firm can also be auditor, where majority of the partners are practicing CAs, and only signing partner can be CA. So I've already told you all that, right? Now we come to section 141.3, disqualifications of the auditor. First, body corporate cannot be the auditor. I've already told you that. Secondly, officer or employee of the company. He can be an internal auditor. He cannot be the statutory auditor. Thirdly, a person who is a partner or who is in the employment of an officer or employee of the company. So there is a company, it has an employee,
he cannot be the auditor. The employee has a partner, he can also not be the auditor. Employee has an employee, he can also not be the auditor. Right? So you get it? Next, person who his relative or his partner. Now there is Mr. A who himself holds security of the company, he cannot be the partner. There is Mr. A who is proposed to be appointed as the auditor, but Mrs. A holds security. Then again, Mr. A cannot be the auditor. Mr. A is being proposed to be the auditor, but he is a partner in a firm and his partner holds security in the company. Then again, Mr. A cannot be appointed as the auditor. So that's how you have to understand. Of course, in the revision class, we cannot go into in-depth details, right? But a person who his relative or partner holds security of company, holding, subsidiary, associate, or subsidiary of holding. But the relative is allowed to hold securities up to 1 lakh. In fact, even if this limit exceeds, supposedly the wife of Mrs. A is holding securities in the company of 1 lakh, she buys some additional securities, there will be a time span of 60 days during which you can take a corrective action, and during that 60 days the person will not be disqualified, right? So you can decide, you can sell off those securities, or you can whatever you want to decide, and we're talking about the face value, we're not talking about the market value. Fine. Next, they are indebted to company, subsidiary, holding, associate, or subsidiary of holding cash. Okay, in excess of 5 lakh, in excess of 5 lakh, right? Third, if that particular person or any of these have given guarantee or security of third person to them in excess of 1 lakh, in excess of 1 lakh, right? So the person will not be qualified. Next, any person who has a business relationship with what? Business relationship with company, subsidiary, holding, associate, subsidiary of holding, or subsidiary of associate. So there are so many companies which are being given. So if you have a business relationship with any of these, you cannot do that. Now, business relationship does not mean the commercial transactions that you are undertaking in the name of professional services. Like if I am a chartered accountant and I am rendering some auditing services or some other services and I'm taking fees, so I'm having a business relationship with the company, that means I'm disqualified to be the auditor? No. The commercial transactions or the professional services that you're rendering, that does not mean you have a business relationship. Likewise, there are a lot of commercial transactions which I take place. Supposedly I am an auditor of an airlines and I want to travel somewhere, I buy a ticket of that particular, so I am a customer, right? I am just like a customer in the ordinary course of business. That is not a business relationship that I have with the company. Okay, so that will not be covered. Next, if there is a person whose relative is a director, so I am Mr. A and Mrs. A is a director in the company, I cannot be the auditor, right? So whose relative is a director or is a KMP, basically. Any person who is in employment elsewhere, in full-time employment, you cannot be. And there is a limit of 20 companies, excluding OPC, excluding dormant companies, excluding private companies which have a paid up share capital of less than 100 crores, right? So those you exclude. Otherwise, there is an upper ceiling of 20 companies. You cannot exceed that limit of 20 companies. Fine. Or who has been convicted for fraud for a period of 10 years. Or basically, you can say who has been convicted for fraud and 10 years have not elapsed. So, if you have been ever found guilty of fraud, then you cannot become the auditor of the company unless that conviction has end, and from that date of conviction 10 years have elapsed, right? Okay. And lastly, who renders services under section 144. 144 is what? It is that the auditor is not allowed to render certain services like accounting and all that. We'll read about it later. Okay. Next comes removal of auditor before his term. Section number 140. If you want to remove the auditor, you're not satisfied with the service of the auditor, how can you remove the auditor? Call a board meeting, pass board resolution. Within 30 days, you'll make an application to central government. So you need to obtain the approval of central government, which actually has been delegated to RD. So you make an application to regional director online and you obtain approval. Thereafter, you will call your members and pass SR at general meeting. Auditor will be given a reasonable opportunity of being heard, and then in this manner, auditor may be removed. So auditor cannot be removed so easily. Secondly, resignation by auditor. If the auditor is not satisfied and auditor wants to resign, then you can resign and file the statement indicating reasons within 30 days in ADT3, and you will give this to the company, you'll give this to ROC, and you'll also give to CAG if you are the auditor of a government company. Okay. We also have something called as special notice for not appointing retiring auditor. Usually what happens, there is an auditor which is going to retire, and unless rotation is applicable, he will be reappointed, right? That's how it works, right? Now, there might be a situation where the members don't want this particular auditor to continue. So what they'll do is, eligible members, as we read in section 115, to send special notice. That is, if you're holding at least 1% voting power or 5 lakh paid up share capital, at least 14 days before annual general meeting, you will send that we don't want this retiring auditor to be reappointed, or we want someone else to be appointed. Okay. This you are sending to the company. Company sends a copy of this to retiring auditor. He gets an opportunity to make a representation, and this representation will be circulated amongst the members and will be read out at the meeting, right? Okay. But if the auditor is trying to abuse this right and saying defamatory things about the director and all that, trying to defame the company, then the aggrieved person may make an application to tribunal and say that stop this right of auditor. His statement need not be circulated or read out at the meeting, so tribunal will give accordingly directions, right? Otherwise, he'll be entitled to this representation, and accordingly, the members will hear the auditor and they will take their decisions. Okay. Apart from that, we also have the power being conferred to tribunal to change the auditor. So if there is any person concerned, he can make an application to tribunal. Our tribunal can itself also, if satisfied that no, this auditor is doing some fraud in the company, they're not rendering their professional services correctly, then it can change the auditors. Right? Such auditor will also be liable for an action under section 447. Okay. Now, auditor, if you are being appointed, your remuneration will be fixed in general meeting only. But if you're a first auditor, then your remuneration will be fixed by the board, because you're being appointed by the board only, right? You will be paid remuneration, plus over and above, you will also be paid to the expenses that you incur, or any facility which is being incurred to you, or which is being extended to you. Fine. Then we come to section number 143. What is section 143? Here we talk about the powers of auditors. So auditor has certain rights and he also has certain duties. He has right to check the books. So if there is an auditor and he comes and says that, okay, provide me this particular book, and you say, no, we are not going to provide you that. Oh my God, he has all the power, he has all the right to access those books and at all times. Okay, wherever they are kept, it doesn't matter. If he needs any information, if he needs any explanation, you are bound to provide the same to him, as he has the right to information, explanation, right? And he has the right as well as a duty to make certain inquiries. Certain inquiries like what? If the company has provided any loan, whether you have taken security against it or not. There could be a lot of book entries. The transactions have not actually taken place, but they are just book entries for manipulation. So whether the transactions are just book entries or they're actually taking place, right? Are they not harmful for the interest of the company? right? So sometimes company make a lot of investments. Supposedly I've made an investment and I'm selling that investment at a loss. Now this should not happen. If this is happening in case of investment companies, it is completely allowed because that is their role, right? But otherwise that has to be checked, that has to be inquired by the auditor, right? The loans and advances, if you have made a loan, have they been shown as deposits? Sometimes it may so happen that the director has gone for a Europe trip and it has been written traveling expenses, so where the personal expenses have been charged to revenue, right? And many a times it may so happen that shares have been allotted for cash, so whether you have actually received the cash or not, so how you are recording all that. So it is the right as well as the duty of the auditor to make certain inquiries. He also has the right to receive remuneration. He has the right of lien to retain certain papers till his remuneration is being paid off. He has the right to receive notice. He has the right to access the records of subsidiaries also, as long as consolidation is concerned and all that, right? Then he has a lot of duties duty to give audit report on the financial statements which have been examined by him, right? Duty to make report on internal financial controls, right? Duty to express his opinion in true and fair view, right? Or give his opinion, right? Then there is an auditor's report which also must state a lot of matters which we have dealt in before, with respect to compliance with accounting standards, right? Disqualification of directors, then branch office, right? If you have consolidated and whether the report of the branch was sent to you and how have you dealt in with it, right? So there are a lot of things, other things also, which as an auditor you must incorporate with the audit report. Moreover, it is the duty of every auditor that you must comply with the auditing standards, right? Central government has prescribed the standards and it's his duty to follow the standards, duty to make inquiries, duty to make report, duty to exercise reasonable skill and care, right? Okay, I will first take over here also duty reporting of fraud by auditor, although this is something that I've already explained you before. If the fraud is less than 1 crore, within 2 days, you report it to the board or audit committee and they disclose in board's report. If the fraud is 1 crore or more, then within 2 days, you report it to the board and ask for their reply. They reply within 45 days, great. After they reply, within 15 days of reply, you give your report, reply of the board, as well as comments on your comment on their reply to central government. If they do not reply or they do not give satisfactory reply, whatever it is, then within 15 days of expiry of 45 days, you will give your report, you will give the details that we sent it to the board but they did not reply, you'll give this to CG. So reporting of fraud is also covered in section 143 only, which has to be done, and all the provisions which apply to a normal auditor, they also apply to in case of branch auditor, in case of cost auditor, and likewise, right? Okay, then we have something called as audit of government companies. Slightly different. We all know that we talk about government companies, they are owned or controlled by central government, state government, or a combination of them, right? So, this particular audit report will also include some directions by CAG. Okay. Now, CAG has some additional right because CAG appoints the auditor, auditor does the audit, he makes a report to CAG only, right? So, auditor submits a copy of audit report to CAG. Now, within 60 days from receipt of that audit report, CAG has some additional rights. What they can do is they may order supplementary audit. Supplementary audit means some additional information or some additional investigation on a particular matter, on a certain thing, right? He may also comment upon audit report. Fine, this particular comment is being added by CAG. They can do that, and they can also supplement such audit report, additional, right? So add on something, right? So that can also be done by CAG, right? It is placed there is something called as a test audit also, and which may also be done by CAG. Then we have branch audit, section 143, subsection 8. Company's auditor can go ahead and do that branch audit, or the person who is qualified to be appointed as a statutory auditor, any person may be appointed as a branch auditor also. So just like we have section 139, these people can be the auditor, statutory auditor of a company, they can also be the branch auditor. So you can either tell the statutory auditor that you have to do branch audit also, or you can appoint somebody else as a branch auditor. Fine. If there is a foreign branch, then again the audit can be done by the company's auditor, by the accountant, or any person who's qualified over there to audit. Okay. Fine. They'll have the same rights, same duties, everything. The branch auditor is going to prepare a report, send it to the statutory auditor, and statutory auditor is going to deal with it. And he will also give in his report how he has dealt with it. Right? Okay. We have section 144, which talks that auditor is not supposed to do certain services. What services? The auditor cannot go and carry out accounting and bookkeeping services, internal audit, investment advisory, actuarial services, investment banking, management services, outsourced financial services, design and implementation of financial system, and others as may be prescribed. Okay, fine. So we have small sections like section number 145, which talks about signing of audit reports. So it is the duty of the auditor to sign the audit report, to certify everything, right? If he has qualified the report, or if he has given any adverse remark, whatever it is, right? That is all going to be open for inspection. Secondly, we have section 146, which actually gives auditor a right to attend the general meeting. So he's entitled to get a notice also, and he's entitled to attend the general meeting also. So all the notices, everything is going to be forwarded to the auditor, which I've told you already. We have section 147, which actually talks about the penalty on company if they contravene the provisions. Then we have penalty on the officers if they contravene the provisions, and we also have penalty on auditor if they contravene the provisions wherever they are required to comply with, right? So we have those penalties, and thereafter we have section 148, which talks about the cost audit. Now we don't have to read in detail which companies are required to prepare cost records and all that, but central government has actually prescribed certain companies which are manufacturing entities or are producing certain goods or services that you have to maintain cost records, right? And once you maintain cost records, you have to get apart from that, then certain companies which meet a certain threshold or the criteria, they have to get cost audit also done. We have some regulated sector, we have non-regulated sector, about which you have read before, and now we don't have it in our course, so we are not supposed to read it, right? So cost auditor, who can be the cost auditor? Only a cost accountant can be the cost auditor. Cost accountant in practice is appointed by the board of directors. His remuneration is also fixed by the board of directors. It is ratified by the shareholders. Now he has to prepare a report in CRA 3, submit it to the board, and board within 30 days will furnish to CG with an explanation. CG may ask for additional information. That's it, right? Now after this we have CARO. Okay, now we have to revise CARO. It is not there in the charts. I'll revise it from the main book. First of all, CARO, it is basically divided into 4 paragraphs. So what is it? It is something which is additional reporting requirement for the statutory auditor, right? So if you're doing the audit of a company, of any type of company, you have to prepare this additional report. You report on the financial statements, you report on internal financial controls, right? You report on so many matters. Likewise, this is an additional reporting format which has certain clauses. On these clauses, you have to check and you have to report on the same. This has been decided by CG in consultation with NFRA. Earlier, we had CARO 2016. Now we have CARO 2020, which is divided into 4 paras, and para 3 has basically 21 clauses, right? And we have to read about all these 21 clauses. What you will learn from examination perspective, that I've already highlighted in pink, and for the ones who want to know, they can of course note it down. Now, there is one more thing, although this is not something which is very much important technically, but it is very much important from examination perspective. Why? Because you need to know about the non-applicability. Most of the times, whenever a question about CARO is asked, it is asked on which companies CARO is not applicable. So if you're a statutory auditor of a banking company, then you don't have to prepare this CARO 2020 report as an annexure to your main report. You don't have to add this report to your audit report. Okay. So what are the exemption? Banking, insurance, Section 8, OPC, small company and private company, which meets 4 conditions, right? I repeat, banking, insurance, Section 8 company, that is companies with charitable objects. OPC, you all know, small company, the current limit is 4 crores and 40 crores. So paid up capital not to exceed 4 crore and turnover not to exceed 40 crores, and you should not be a subsidiary, you should not be a holding, you should not be a Section 8 company, you should not be governed by special act, and you should be a private company. So you fulfill the criteria of being a small company. And lastly, private company, which meets 4 conditions. What are the 4 conditions? You should not be a holding or subsidiary of any public company. Second, your paid up capital plus reserves actually I should say not exceed 1 crore. So it can be 1 crore or lesser than 1 crore. Then your borrowings at any point of time in financial year should not exceed 1 crore, and your revenue should not exceed 10 crores. So if you fulfill these criteria, then such private companies are also not required to report on CARO. See, private companies or any company as of that matter does not prepare any report. It is the auditor which is being mandated to do that, right? So if you're auditing such a private company, you have to always check that, okay, I am the auditor of a private company, on this CARO is applicable or not, right? So that is what you have to see. Now, what are the matters which are included in CARO? First clause, property, plant and equipment. Now, there are 2 types of properties basically when we are talking about the fixed assets, tangible and intangible assets. Every company is required to maintain proper records. Records means the quantitative details as well as the situation. That means simply that, okay, at this particular point or at this particular branch, there are so many desktops, or whatever it be, right? So quantitative details and situation, whether the company is maintaining that or not. Secondly, whether the management is physically verifying it or not, that it is just on paper. Physically, they don't know where are the assets gone, right? So physically, they should verify, and if there is material discrepancy which is being noticed, then that has been dealt in the books of accounts or not, right? Secondly comes your inventory. Again, inventory has to be physically verified at time and again, right? So whether it is being verified by the management at reasonable interval or not. Secondly, if it will be verified, then there might be material discrepancy which may be noticed. Material discrepancy of 10% of more, if it has been noticed, how has it been dealt in the books of accounts? And there is one more point. Whether working capital limits, if the company has been sanctioned some working capital limit and it is in excess of 5 crores, that has to be reported. Next is LGSI. Company is giving loan, guarantee or security or investment or loan to directors, right? So investment or loan to directors, you have to comply with section 185 and 186. Now, if you're giving loan, guarantee or security, firstly, auditor will see that this loan, guarantee or security should not be harmful for company's interest, should not be prejudicial to company's interest. Secondly, if you have given loan, then there should be a proper repayment schedule, that okay, on this particular date the principal repayment will come back, or on this particular date interest will come, right? So these are the dates of interest, quarterly interest, monthly interest, whatever it is. So there should be a proper repayment schedule, and the receipts should be regular according to that repayment schedule, right? So that is also something which is very important. So auditor will check that. And auditor will also check something, that if you have given a loan to somebody and that person is not repaying your loan and the amount has been overdue for more than 90 days, what are you doing? What steps have you taken for that recovery? Because you can extend the credit period. Okay, fine, you are unable to pay the installment today, pay it after a week. That is fine. But 90 days overdue, that is not fine, right? So that has to be done. This I have already done. Then comes your deposits. Deposits is what? We have read about the chapter of deposits. So whenever the company is accepting deposits, it has to comply with the sections of Companies Act 73 to 76A, plus it has to comply with RBI directives, right? So whether it has complied with it or not. Next is cost records. For the companies which are required to maintain cost records, are they maintaining it or not? In the manner provided, right? So you have to check that compliance. Next is statutory dues. Income tax, direct tax, indirect tax, income tax, GST, right? And provident fund, employee state insurance. So whatever are the statutory dues which you are obligated to, which you're mandated to, and which has a deadline and a due date, whether the company is regular in paying that or not. If the company is not regular, then you have to report the details, right? And what are the areas which are outstanding? And there is one more thing, if it has been overdue for more than 6 months, then that also has to be reported, right? Then the transactions which are not recorded in the books, you found any transaction which has not been reported, which has not been recorded, right? So that has to be reported over here. Repayment of loan. Now, this particular loan, we are talking about the company has taken loan from bank or from financial institution. Then we have to check whether the company has defaulted in the loan. If yes, what is the amount? What is the period? Right? That loan was company has given loan. Here the company has taken loan. Next is utilization of IPO and FPO. So whenever a public company can raise funds from private placement also and from public offer also. Private company can raise funds only from private placement. Whenever you're doing it from private placement, you have to ensure that you comply with the section 42 and 62 for the issue of shares, right? But when you're doing public offer, then what has to be ensured is that whatever money you are raising, you're raising it for a purpose. You should utilize it for the same purpose. It should not be that, okay, I have raised money for some religious event, spiritual event, and then I'm running a DJ night, and no, that cannot be done, right? So that has to be reported. And if there is any default, then what is the subsequent rectification that has been taken place? That adequate amount should be brought back and it should be invested and like that. Next is reporting of fraud, which we have read about in section 143 subsection 12. When we read about the duties of auditor, auditor is also obligated to report fraud to central government. See, if the fraud is less than 1 CR, it has to be reported to board or audit committee. If it is exceeding 1 CR or it is at 1 CR, more than equal to 1 CR, then you have to report it to central government. So whatever fraud you have discovered, you have to report it here in CARO also. If you're doing the audit of Nidhi company, you have to ensure 3 things. First, there should not be any default. If there is default, report that. Secondly, net owned funds to deposit should be the ratio of 1:20. And thirdly, Nidhi company should maintain 10% unencumbered term deposit. Next is related party transaction. You see whether the company has done any related party transaction. Yes. Then whether it has complied with section 188 or not. Next is internal audit system. Now, not all companies have to go for internal audit system, but if you have an internal audit system and there is an internal auditor which has made a report, that report is to be considered by the statutory auditor. Okay. Next is non-cash transactions. Non-cash transactions means what? See, we have a section 192 which deals with the restrictions on non-cash transactions with the directors. So if the company has entering into any non-cash transaction with directors, it has to check that whether there is a compliance of section 192 or not. Next is for NBFC or housing finance companies. For them, it is mandatory that they need to register themselves under section 45IA with RBI. So if they register themselves, it's great. So the first thing you should do is ask for their registration certificate, because otherwise they're not even allowed to carry out those activities, right? So whether registration has been obtained or not. Next is cash losses. If the company has incurred any cash losses in the financial year or immediately preceding financial year, that has to be reported. If there was another auditor who has resigned, there could be many reasons of resignation, but if he has raised any concerns or objections, whether they have been considered by you or not. You also report on the financial position of the company, right? That whether the company will be able to meet out its liability at least for 1 year or not, right? Then you have CSR compliance, with respect to unspent account, right? Whether it has been transferred adequately and properly or not. And lastly, there are points which have adverse remarks, or they have been qualifications. So that is going to be indicated separately, that okay, paragraph numbers of the CARO report, these contain the qualifications or adverse remarks, right? So that's it.
Hello, everyone. So now we are going to revise the chapter of directors. Now, when I say directors, it's basically contained, the provisions are basically contained in 3 chapters, chapter 11, 12, and 13, right? Right now, we are going to revise chapter 11, which is appointment and qualification of directors. Now, because we're starting with something new called as directors, we have to understand why prima facie there is need of directors, right? So you require directors in a company for 2 reasons. One, that company is a separate legal entity and it cannot function on its own because it does not have eyes or ears or mind to think like a normal human has, right? An individual has, because it may be a separate identity in the eyes of law, but it cannot take that decision. So decision making is something which has to be taken by humans or individuals only, and that's why we need human intervention. Now when I say human intervention, there are two bodies which manage the company. Which are the two bodies? One is the board of directors, the other is the shareholders, right? Shareholders are someone who have invested in the company. Now if they believe that they have that management skills of managing the company also, they themselves can volunteer to become the directors. But prima facie, directors are the ones who have all the powers of decision making of a company, unless those are reserved for the shareholders, right? Okay, so there are certain powers which have been held back, which have been reserved for the shareholders, and otherwise the management, company is being managed by the board of directors, the day-to-day affairs, everything are going to be taken care by the directors only. The shareholders do not intervene in the decision making or in the day-to-day affairs and management of the company. They intervene in 3 situations. One, when they think and believe that, oh my god, the directors are having some malified intention, right? They're doing some fraud in the company, so the shareholders will intervene. Second, they believe that the board is incompetent, right? Like the members are technically not sound, they're not able to take decisions, etc., etc. Third is a situation of deadlock. When majority decisions can't be taken, maybe there are 2 groups which have been formed or something like that, right? So that's a situation of complete deadlock where people, maybe they are not in talking terms or anything like that, and hence the decision making is hampered, right? So only in these 3 situations the shareholders intervene in the board. Otherwise the decisions are being taken by the directors within the powers of the company and within their own powers also. Okay, but prima facie, ma'am, who is a director? Director is somebody who is appointed as a director. So even if you're doing all the functions and duties of a director and you're not appointed as such, you cannot be called as a director. And collectively, all the directors are called as board, board of directors, or directors. So these words are synonymous and can be used interchangeably. Okay, so I hope the meaning is clear. Who can become the director? Well, it could be any individual who meets certain criteria. It could be me who is investing in the company, my relative, it could be some outsider person, some very highly qualified some person, some not so qualified person, it could be anyone. Because there are 2 types of directors. One is executive, the other one is non-executive. When I say executive directors, they are in the employment of the company. They're like employees, right? They are working day and night with the company. They're associated closely with the company, right? They are involved in all the policy formulation, everything. They're engrossed in the affairs of the company. Then you have the non-executive directors who are not the employees. They have an independent perspective. They come for a certain tenure only. They're not occupied here whole time. Okay. And they don't work under any contract of employment or full time. They are like part time. It could be independent directors. Executive directors, example, managing director, whole time directors, they are called as executive directors. Okay. Fine. Now, here is a complete overview
When I say directors, the meaning is given in section 2 clause 34, need. As I said, there are two prima facie need for appointment of directors. Why do we need to appoint the directors? One is because the company can't function on its own. You need somebody, right? Secondly, there is a clear legal requirement to appoint the director. It's very clear and obvious that the companies need to have directors, one, two, or three minimum. So, Section 149 mandates the requirement of directors. So, for these two reasons, we need to appoint directors. Okay. Then, board is a collective body. Fine. Who can become the director? Somebody who is not disqualified, who gives consent, who holds tin. What do they do? There are duties that we read in section 166. Then salary we are not covering in this particular chapter because it's given in chapter 13 basically. Okay. Now, categories. We have different types of directors that we are going to read. Now, as they are appointed, prima facie, all the directors are appointed by passing an ordinary resolution in general meeting. How the directors are appointed? This is how the directors are appointed. So, the power to appoint a director is with the shareholders, prima facie, unless otherwise given. We have a section called as section 161, where some directors may be appointed by the board. We have a situation where even NCLT can appoint the director. Okay, so there are situations like that, but prima facie, the directors are appointed by the shareholders by passing ordinary resolution in general meeting. Okay, now how do they leave? They may resign. They may resign, they may be removed, or they may have to vacate because they are disqualified or more grounds. Okay, fine. So let's begin. This particular chapter has section numbers starting from 149 to 172. The very first section, section 149, right? Directors. Minimum 1, 2, and 3. 1 in case of OPC, 2 in case of private, 3 in case of public. Maximum 15 directors in all the companies. However, this can be increased by passing a special resolution. So, if you want to appoint more than 15 directors, that is also possible, but you will have to pass special resolution. Now, here articles of association also play a role. If your articles have restricted that, okay, the maximum directors that we want to appoint in our company is 10, although the act permits it up to 15, now you have written 10. So this is an internal rule which you have formed, which is well within the act, so not any wrong rule that you have formed. Now, if you want to appoint 12 directors, you need to first amend these internal rules. How will you amend that? How will you alter the articles of association? By passing SR. So you alter this and then you appoint the directors to then you increase the number of directors that may be appointed in your company, 2 more, and then you appoint that, right? Okay. Now, this upper limit of 15 directors is not applicable to government companies or Section 8 companies. So, government companies, you can appoint 25 directors without passing SR. Yes, you can. Okay. Now, if I say that I want to appoint Reliance Industries Limited as the director of my company, can I? Ma'am, you were saying that to manage a company, we need a human, we need a brain, right? And then you're appointing somebody who's again brainless, right? Somebody who's again an artificial person. So that is not done, right? So to manage that, you will again need some human intervention. So basically, you have to understand that you cannot appoint any body corporate as a director. Director has to be an individual and an individual only. Only and only individual can be appointed as a director. Okay, ma'am. Now, in section 149 is very huge. Section 149 has certain portion and then it has a lot of portion of independent director which we'll revise later. Okay, so right now, the next thing, woman director. What is woman director? A director who's a woman, as simple as that. It need not be independent. It can be executive. It can be non-executive. It can be nominee. It can be SSD. It can be anyone. But it has to be a woman. I mean, all the companies, no. Not in all the companies.
In companies which are listed or public company with paid up capital of 100 crores or more or turnover of 300 crores or more. So listed 100, 300, listed 100, 300, listed 100, 300. At least one woman director. At least one woman director. Okay, ma'am. So if that woman director dies or maybe resigns, then that is called as an intermittent vacancy, which has arisen, which is a sudden vacancy and has arisen without or in between the term, right? The term of the woman director has not ended and that vacancy has arisen, right? So this is going to be filled by the board, next board meeting, or 3 months, whichever is later. Whichever is later. So if I say that, okay, a woman director was appointed for this tenure of 5 years, but here she died. Now what will happen? The board of directors will appoint another woman director. Okay, and that woman director has to be appointed within 3 months or first board meeting, whichever is later. That means maybe 3 months have passed, but the board hasn't met yet. There's no board meeting, so how will they appoint? So till that meeting. If the first board meeting took place within 1 week only, oh, how so quickly? It's difficult to find a woman director. So till 3 months you have a time, right? So that is how it has been designed. Okay, now moving to the next point. Next is resident director, which is mandatory in every company. Who is a resident director? Who stays in India for at least 182 days during the financial year. Okay, and then we also have the requirement of independent director. So whenever you are being asked to check the composition of board of directors of any company, you have to see that, okay, there should be a resident director, woman director if need be, independent director if need be, right? So these are the 3 requirements that you will see apart from checking that minimum directors are fulfilled or not, 3, 2 and 1, right? So this is what you are going to see in the composition of board whenever you are evaluating the same. Okay, now to become a director, what do you need? You have to be an individual. You must agree, that is, give your consent. You must have done, you must give a declaration that you're not disqualified, and your directorship should be within the limit of section 165, and there are other disclosures and process of applying for your candidature and all, right? So these are the basics which must be there for you to become a director. Now we come to section 152, that is appointment of directors. Appointment of directors. Okay. To become a director or to appoint a director, it has to be done in general meeting only by passing OR. The person you are appointing must have done, the person must not be disqualified under section 164. It must give the consent. That is something that I have already told you, right? So after you have all of this, you can be appointed. How will you be appointed? By passing ordinary resolution in general meeting. Fine, ma'am. But let's say the company is incorporated on 1st January 2027. You'll wait for the general meeting to happen and then the directors will be appointed. So how this general meeting will happen? Who will call the meeting? Who will send the notice? Who will do all of that? The board. But there's no board because there are no directors. Because directors' appointment take place in general meeting. No. Auditors can still wait, but directors, no. The moment company is incorporated, you need the directors to function. The company can't take decisions on its own. So the first directors can't be appointed in the general meeting. The first directors have to be pre-decided. Pre-decided how? Their name is mentioned in the articles. If not, the manner is mentioned in the articles. If not, all the individual subscribers to the company become the first directors. Individual subscribers, because I already told you, body corporates cannot become the directors. Supposedly, a company is being formed by 4 members, A, B, C and XYZ Limited. So XYZ Limited can't become the director. So A, B and C, if nothing is mentioned, you 3 become the first directors. You will call the general meeting, everything, and in the general meeting, there will be a regular, proper appointment. Maybe you only will be reappointed or someone else can be appointed. Fine. So that
will be appointment, will be like for that tenure, 5 years and all, right? Okay, so this is how the first directors are appointed. So first directors hold office till ensuing AGM, ensuing general meeting only, and they may be reappointed. And if they don't want to be reappointed, the new eligible persons according to section 160 can come and they may be appointed. Now we come to the concept of rotation. Again, it is something which is not mandatory in private companies but is mandatory in public companies. So public company, your articles may say that all my directors are going to retire by rotation. So every year, everyone is retiring and they may be reappointed or they may leave. This could be first situation. Second situation, if your articles don't say anything about rotation, then the act says the articles could provide that all directors will retire. The act cannot provide that 2 directors will retire. No, the articles cannot provide that 2 directors will retire or anything like that. No. If the articles provide that everyone will retire, that's valid. Or then we come to the act. In the act, it is clearly said that at least 2/3 of the directors have to be appointed as rotational directors. So when you're appointing a director, you clearly say that you are a rotational director, you're a non-rotational director. So somebody who has been appointed as a rotational director, right? If there are total 9 directors, 2/3, 6 will be rotational. Out of these 6, 1/3 are going to retire at every AGM. So 1/3 is 2. So 2 directors are going to retire at every AGM. Fine. Okay. Now, when they retire, 1/3 retire at every AGM. If AGM is held, of course, they will retire. If AGM is not held, then whatever is the last date to hold AGM, on that date, the retiring directors have to vacate. Now, when they vacate, they may be reappointed, right? Okay, because the whole concept is that they should be under surveillance, right? So they are like, I am accountable to the members. What if I am not delivering my best? The members may not reappoint me. I will complete this tenure, but if I'm not doing my best, they'll not reappoint me, right? So that is the whole concept of rotation, so that they do their work and diligently and in the fair and transparent manner, right? So they may be reappointed, or somebody else may also be reappointed, or they may pass a resolution that we don't want to fill the vacancy. There are 12 directors on board, whereas we don't have so much of work. So even if one director is retiring, we don't want to fill his vacancy. You go. We anyways don't need so many directors. So we have resolved that we don't want to fill the vacancy. That can also happen. But if none of the decision is taken, the AGM will be adjourned. Okay, the AGM will be adjourned. And even if at the adjourned AGM also they could not take any decision, then there will be automatic reappointment of retiring director. However, there won't be any automatic reappointment of retiring director if he is disqualified. If there is contravention of section 162, single resolution, if he has expressed his unwillingness, I don't want to be appointed. If there is specific requirement of OR or SR for his appointment, like maybe an independent director is going to be reappointed for his second term. So there won't be any automatic reappointment. Anyways, independent directors are not liable to retire by rotation. So that is an example which is not applicable, but I'm just giving you that vision. Okay. And then if the resolution failed, what does that resolution failed? So Mr. X was the retiring director. We proposed his reappointment in front of the members and they declined. So a resolution was put forth and failed or lost. Now, no decision could be taken at the adjourned meeting. Will he be reappointed? Automatic reappointment? No. You can consider someone's silence to be yes, but someone's denial to be yes, no, not at all. Okay. Moving to the next section, section 160. Section 160. Okay. So this talks about right of persons other than retiring directors to stand for directorship. Basically, if there are first directors, okay, they are reappointed, then some of them retire, they're reappointed, retired, reappointed, retired, reappointed. So the same loop is going on. What if somebody other than these retiring directors want to come and become a director? Can they? Yes. So this is for persons other than retiring director. Okay. Other than retiring director, there could be any member who wants to become the director. There could be any non-member who wants to become the director. So member himself or maybe some other person, non-member himself, they want to propose their candidature that I want to become the director. Now, when they propose the candidature, the board, you have to tell it to the members, and the members will decide whether they want to appoint the director or not. Right. But just to screen out the serious applications, because if the board screens out, it will be like the board is getting biased and they're not letting that member even being proposed to be appointed as director. Right. So, in keeping that in view, they have a deposit of 1 lakh. So when somebody is proposing a candidature, you also have to give 1 lakh rupees. And that 1 lakh rupees will be refunded only in 2 cases: if you're elected as a director, or if you get at least more than 25% of votes cast, valid votes. If you get only 10% votes, that is non-refundable deposit, and that's gone. That's gone. Right? Okay, so they can propose their candidature along with this deposit by giving a notice at least 14 days before general meeting at registered office. Now, the company will send this candidature, notice of candidature, at least 7 days before to all the members plus website. And thereafter, at the general meeting, if by passing resolution the member is appointed, the director is appointed, it's appointed. However, when I talk about there is somebody who has been recommended by board, NRC, or a recommendation of independent director, right, then this deposit is not needed. Okay, then this deposit is not needed. Now, this particular section is not applicable to private company, not applicable to 100% government company, or wholly owned of such wholly owned subsidiary of such company, or Section 8 company where the election is happening by ballot. Okay. Next, we come to the provisions of DIN. When I say DIN, there are so many sections, starting from section 153 to section 159. The first thing is, what is DIN? What is DIN? DIN is a unique number, right? Just like we have PAN to file income tax, we need PAN. To give votes, we need voter ID. Likewise, to become a director, we need DIN. And that's a unique number given only to me. It cannot be similar to any other person. And it's given to me for a lifetime. So it's not that it's going to keep on changing, that right now I'm a director of this company, so I have this DIN. Then I become the director of that company, I have another DIN. No. One DIN applicable in every company till your life. Okay. Fine. So, ma'am, if I want to become a director, I need to have this director identification number. How do I get it? There are 2 ways to get it. If you are becoming a director of a new company, then that company is also being incorporated using the form Spice Plus. In Spice Plus, you can get the DIN up to 3 directors. So you can fill in the details in Spice Plus only and you can get your DIN. Option number 2, you can apply. There is a form called as DIR 3. So if you want to become a director of an existing company, you don't have DIN, fill the form DIR 3, apply it. Right? How do you do that? So individual, if you're intending to be appointed as a director, you file an application in DIR 3 with central government, and there will be automatic generation of an application number. CG is going to examine the same and allot it. If they find that your application is defective or incomplete, they will intimate via website and you get 15 days time period to rectify the defect. If you rectify it, they will allot. If it is still defective or not rectified, the application will be rejected. Along with the application, you need to give or attach certain documents: photo, ID proof, address proof, board resolution. What board resolution, ma'am? See, you can't get DIN just like that. That, okay, I want to, like, you can get PAN, you can get voter ID, right? Even if you don't want to vote, you apply and you get that voter ID, right? But you won't get DIN just like that. You will get DIN, you can apply for DIN only when you're being proposed as a director somewhere. So the board, they pass a resolution proposing your candidature in the general meeting, and thereafter in the general meeting your appointment will be made subject to passing of resolution. So this proposal, that resolution has to be attached over here, and specimen signature. Okay. Now, central government has the power to say that any other number can also be considered as as DIN, right? So that is, we have deepen, designated partners identification number, right? Which we read under LLP Act. Okay, so this is the process of application and allotment of DIN. Now every director, once you get DIN, you have to intimate that to the company. That's for existing directors mainly, and then we have penalty and all, that is not so important. Now it is your obligation to intimate DIN in every reference, every document. Okay, fine. Now, DIN is going to be valid for lifetime, only one DIN per individual. Existing director to intimate DIN, I already told you. Company to ROC, that is also. Now, changes to be intimated by individual. You have filled certain details like this is my name, this is my address, and everything, right? Whenever there is any change in those particulars which you've mentioned in DIR 3, you have to intimate that change to central government within 30 days by filing DIR 6. Okay, so you give that, and central government, if they're satisfied, they will get the changes done, and they will also inform to the concerned, the DIN cell of ministry will inform to the concerned ROC. Okay, now there is something called as DIN cancellation. DIN cancellation, what is that? Central government has given you DIN, it can also cancel the DIN. Okay, intimate changes, I think I already told you this, right? Okay, so cancellation of DIN, they can also get your DIN cancelled when? If you have duplicate DIN. That means you have, many people in our country have duplicate voter IDs, they have duplicate PAN, etc., etc. Secondly, if the DIN has been obtained by wrongful or fraudulent means. Fraud is guilty mind. Wrongful means is any wrong that you have done. Maybe you have given incomplete documents, wrong documents, or anything. Third is death of that person. Fourth is unsound mind, or fifth is insolvent. And we also have a case of surrender of DIN. When do we surrender the DIN? Supposedly, I am being proposed as a director in a company. So I applied for DIN and got the DIN. But then I was not appointed as a director in that company. And I have no future plans to be appointed as a director. And I'm like, oh, why did I apply this DIN? I don't want this DIN, right? So I have never used that DIN. That means using that DIN, I have never become any director. I've never become a director of any company. So that's an unused DIN. It has never been used for filing any document, anywhere, anything, no liability, nothing. So I can surrender this DIN. And if the DIN is surrendered, the central government may deactivate it. Okay, so the DIN can be cancelled or deactivated by the government, right? Okay, moving to this, I've already told you. Moving to the next section, that is section 165, number of directorships. See, there is always a limit on how much work a person can do, right? If he's overexerting himself or herself, then definitely there will be compromise on the quality of the work that he's delivering, right? The same thing applies here also, that there is a saturation, there is a limit. Like if I have become a director in 50 companies, I'm not actually doing any work of the director, right? I am just trying to extract as much as money I can in the form of remuneration from all these 50 companies, right? So there's a limit. It has been set by the law itself so that there is no confusion, and just to ensure better administration, right? So there is a limit. What is that limit? The limit is of 20 companies, including your alternate directorships, Now, if you are a director in maybe 30 companies, 40 companies, right? And this particular act comes into picture, the section comes into picture. So the director, if you are in more than specified number of companies, then you have to choose, okay, I will continue with these directorships and I'll leave these. So resign within 1 year and intimate your choices to ROC. Okay, so this is something which is transitional and obsolete, right? Now, after commencement of the act, the maximum directorships that are allowed is 20. It includes your alternate directorships.
However, it excludes your directorships in dormant company and Section 8 company. Section 8 company, there is specifically different exemption which has been given at that it is in case of Section 8 company, Section 165(1) doesn't apply. So that is why. Okay. Now, there is a sub bifurcation, right? That okay, if I am a director, maximum 20 companies, which includes all my companies. It does not include dormant and Section 8 companies. Within that, there can be maximum 10 directorships of public company. However, there is one more thing which we have to keep in mind, that sometimes it happens, okay, that there's a public company and it has a private subsidiary company. If you're a director in this private subsidiary, although it is a private company, it is still considered and treated as a public company. So if you're a director in such private subsidiary of a public company, then again that is counted as a directorship in a public company. So these are the two limits that you have to take care of. One is the overall limit and the second one is limit of public companies. Right? There could be more stricter provisions in the companies by passing SR and reducing the number of maximum directorships which a director can hold if you become the director of that particular company. Okay, so I hope that's clear. Now we come to another important section, and that is section 164, which talks about disqualifications. So somebody who's an individual gives consent, gives a declaration that he's not disqualified, is proposed, is appointed, or is named as first directors in the articles, right? That particular person becomes a director. Someone who is not disqualified under section 164, right? Now, in the section 164, there are in total 9 plus 2, that is 11 grounds of disqualification. Okay, 9 the general grounds, 2 are the grounds that gets attracted because you work in a company, because you are a director in a company which is a defaulting company, which becomes a defaulting company. Okay, other than this, law does not specify any academic qualifications that, okay, you have to be a graduate, you have to be a postgraduate, you have to be a chartered accountant, a cost accountant, or anything like that. No. It doesn't, there's nothing requirement as such. Okay, in case of independent director, you need a person who has experience and expertise in certain fields, right? But just to become a normal director, there is absolutely no qualification which has been specified, only that you should not be incurring these disqualifications. That is, a person shall not be eligible for appointment as a director if he is of unsound mind. Now, unsound mind doesn't mean that, okay, we are saying, are you mad? Are you nuts? No. It has to be as declared by competent court. Undischarged insolvent, that means he has been declared as insolvent, but he has not been discharged yet. So he can't start afresh, right? Insolvency application pending, that means he has applied for insolvency. He hasn't been declared as insolvent yet. Okay, so application is pending. Next is, if somebody has convicted for an offense. Convicted means found guilty. Now, the offense may involve moral turpitude, may not involve, it doesn't matter. Whenever you are convicted, you are found guilty, there could be 3 situations. You have been sent to imprisonment for less than 6 months, maybe 1 month, 15 days, or no imprisonment. It could be, it comes over here. Secondly, imprisonment of 6 months or more. And third, imprisonment of 7 years or more. So if the imprisonment is less than 3 months, the person is not disqualified. If the imprisonment is 6 months or more, the person gets disqualified for 5 years to be appointed in any company. And here also you leave. Okay. If the imprisonment is of 7 years or more, then you become disqualified for life. You become disqualified for life. Okay. Next point. The person is disqualified by court or tribunal's order. So if the court has passed an order that this person is disqualified to be appointed as a director, that person will not be appointed. Okay. Then, if your unpaid calls are more than till 6 months, what is this written, ma'am? Unpaid calls, I mean, I am going to be appointed as a director. When you are appointing me, at the time of appointment, you are checking, Okay, you give your consent, yes. You are an individual, yes. You have done, yes. You'll give all the declarations, yes. Are you disqualified under section 164? No. So we are checking. At the time when we are appointing this particular person, we are checking, are you disqualified or not? So we'll ask, do you have unpaid calls? What unpaid calls? It is for those prospective directors who are also shareholder. So if you are also a shareholder, in the capacity of shareholders, you're not responsible enough to be making calls, to be paying calls timely. That is, the company has issued shares on application money. They had paid, they had asked for 5 rupee, and now they're making a final call of 5 rupee, and you're not paying that calls in time. There was a last date fixed for payment, and you have not paid that. In fact, after the last date, 6 months have elapsed, till 6 months after last date. Okay, so if you want, you can add in the charts here after last date. So in that situation, you become disqualified. Next is, if there is an offense under section 188, that is related party transaction offense, you become disqualified for 5 years. Of course, we read this later, right? Not allotted in, that is a general thing. Directorships more than 165, that is also a general thing which we very well know, right? Okay, so these are all the 9 grounds of disqualification which gets attracted generally. Okay, now we come to the second part. Section 164(2). Now you become disqualified because you are a director of a defaulting company. What is a defaulting company? The defaulting company, you become disqualified for 5 years. Okay, now the defaulting company means that the company has not filed financial statements or annual returns for consecutively 3 years. What are you doing in the company as a director? You are a director of a company and the company is doing this work. You don't deserve to be a director. Get disqualified for 5 years. You are a director in a company and that company is not repaying its debentures, deposits, or it has declared dividend and not giving that. In fact, the due date has come and the failure continues for 1 year or more. So then again, that's a defaulting company. So if you are a director in any such company, then you become disqualified to be appointed for 5 years. The question here is, because section 164 and section 167 go hand in hand. One talks about the disqualification, the other talks about the vacation. Right. So if a person is disqualified under section 164, it has to immediately vacate. That means if you become of unsound mind, you vacate. If you become insolvent, you vacate, right? If there is an offense, you vacate. If din is not there, you vacate. If directorships exceed, you vacate, right? Whatever disqualification is attracted, you vacate. That is what written in section 167. There are 8 grounds of vacation if disqualified under section 164(1). Why not under section 164(2)? Because you vacate here also, but then the vacation is slightly different. What it is different? Supposedly, there is a person who is a director in 4 companies. Okay, this is the defaulting company. That means this company has failed to repay its deposits and the failure continues for more than 1 year. So you are a director in these 4 companies, right? You are disqualified to be appointed in all these companies as well as other companies. You are disqualified to be reappointed in all these companies as well as other companies. But you vacate in these 3 non-defaulting companies, but not this defaulting company. So you leave the directorship of every company, but in this defaulting company, you will stay to rectify things. But you will not be reappointed. You will not get another employment opportunity. You will not be reappointed. You are not reappointed. You are disqualified to be appointed or reappointed for 5 years, but you don't vacate in the defaulting company. Okay, so that is why, see, if you look over here, if the disqualification under section 164(2), vacation in all companies except defaulting. Okay, that you have to keep in mind, right? Okay. Now, sometimes it may so happen that I am a director and I have just joined the company and I get to know about these defaults. Will I become disqualified? No, I don't. Within 6 months of appointment, within 6 months of appointment, I don't become disqualified. Okay. Now, Section 164(3) provides additional grounds. Provides additional grounds. Likewise, Section 167 also provides additional grounds for private company that if you want, you may mention more things that no, our company's director will have to vacate if he attains the age of 60. You can write whatever you want to. So you can provide additional grounds of disqualification also, additional grounds of vacation also. Okay. So I hope this is clear. Now, there is something more. Section 167 provides this ground as vacation. That means if you are disqualified, you need to vacate. Okay. Other than this, also, you need to vacate if you're not disqualified. That means you can be appointed again, but you have to vacate. If you absent yourself for all the meetings held in a span of 12 months, that means it's not calendar year, it's not financial year, it's 12 months. That means if I don't attend this board meeting from here till 12 months, if I don't attend any board meeting, then I have to vacate. But I'm not disqualified. So I can come back and I can be reappointed if everyone agrees. Okay, but I have to vacate. Got it? So that is a ground of vacation only. Then, if Section 184 contravention is there, that means I participate in some board meeting wherein they are discussing a contract in which I'm interested, or I fail to disclose the contract in which I'm interested. So these are also the grounds when I have to vacate. I may be reappointed. I may be reappointed. If I'm removed under Section 169, then I have to vacate, but I can be reappointed. If I am appointed because I was holding some office and I ceased to hold that office, so I have to vacate, but I can be reappointed. Like if I am, it is being clearly written that someone who is the MD of its holding company will also be a director of its subsidiary company. So if I am the MD of the holding company, I was the director of subsidiary also. Now I failed. Now the tenure has ended. So I have to vacate here also. That is what they're trying to tell. Now there are 2 points, this and this. These are the 2 points which are ideally included in this, but given separately. Why? Disqualified by court. This was one of the disqualifications we have read. If you are convicted of an offense and imprisonment is 6 months or more, this is again a ground of disqualification. Why written separately? Why not included over here? Because again, it has a separate thing of vacation. Okay, what is that separate thing of vacation? Here we come. Here we come. Right, there is a court order passed and court order found you guilty, but then you don't vacate till 30 days. Why? Because you have an option to file the appeal. If you file the appeal, then you don't vacate till the appeal is disposed of. And if you don't file the appeal, then you vacate when the tenure to file the appeal expires. Right? Now the court order is passed. Again, in that appealed court order, you're not guilty, no vacation. If you are guilty, again you don't vacate, because there is still an option to further file an appeal within 7 days. So if you further file an appeal, no vacation till this appeal is disposed of. So you are deferring your vacation. And if you don't file a further appeal, then you vacate after 7 days. Okay, so that is how the vacation happens in case this is a court order, because against the court order you may file an appeal. Okay, I hope that's clear. Now, sometimes it may so happen that all the directors are vacating the office because of one ground or the other. Then in that situation, the promoter steps in, and in their absence, central government steps in and they appoint the director just to call the general meeting. And till the time in the general meeting, the regular directors are not appointed. Okay, fine. Now, we have something called as duties of director. Maybe in a few charts, this particular thing is not written. So please take a screenshot and there will be space. Please write this. Okay, so section 166, the duties of director. Again, very important from exam perspective. First, you have to act in accordance with your articles. You have to act in good faith. Good faith, that means for the best interest of everyone. The environment, community, stakeholders, shareholders, members, creditors, employees, everyone. right? Then whatever duty you are doing, you have to do with proper care and independent judgment. You should never put yourself in a situation that you don't know, should I go for this, should I go for this? Why? Because one side your personal gain is there, second side it's the company's benefit. So never put yourself in that situation. Don't take judgment. That is why we tell that in this contract we are interested, and we refrain ourselves from participating in those board meetings where they are discussing the interested contracts. Okay, never to achieve undue gain. Whatever gain you are in fact achieving, that's a liability towards the company, and you have to give that. And lastly, no assignment of office. Assignment of office means transferring your rights. That means if I am going somewhere, I'm saying you be here and you do all that work, right? I'm giving you all that power. You are no one to give that power. You have to go. The company will see who has to be replaced in your place, right? So you don't have any option of assignment of office. In fact, in the provisions of alternate director, we have very well seen that if there is a director who goes out of India for 3 months or more, then the power to appoint alternate director in his place lies with the company and not with the director, right? Okay. We also have something called as a topic called as liability of directors. So director is liable to 4 things: to the company, to the shareholders, to outsiders, and some statutory defaults. First of all, to outsiders. I mean, a director will be liable to outsiders. Why? Company is a separate legal entity. The company will be liable. Why will the directors be liable? Directors are sometimes liable when they do fraud, right? When they issue misstatement in prospectus, when they allot shares in an irregular manner, irregular allotment of shares, when the court passes an order, when they do the acts ultra vires, right? So in these situations, they become liable to third parties. They become personally liable when they enter into a contract in their own name. I mean, they are supposed to enter into a contract on behalf of the company, then the company will be liable, but they have entered into their own name. Then secondly, when the directors will be liable towards the company when they are negligent, when they do ultra wires act, when they do something illegal. When are they liable to the shareholders? Again, they have the shareholders have entrusted a responsibility on the directors, and directors, if you are negligent, then you become personally liable. And lastly, for statutory defaults, filing of annual return, filing of financial statements, all these, the directors are responsible. So under Companies Act, there have been various places where there are penalties for the directors or for the officer in default. So if you're doing that non-compliance or contravention or the defaults, you will also be liable and you will have to face the consequences, right? Okay. Moving to the next section, section 161. Section 161 is divided into 4 parts, right? We have additional director, we have alternate director, we have nominee director, we have casual vacancy. The very first one, that is additional director. What is an additional director? Sometimes it happens that, okay, the directors are being appointed by the board and they're regularized in general meeting. So that's one way to look at. And the second one, maybe the board is overburdened and they need a director immediately to function, to work, but they can't wait till the general meeting. So they have been conferred the power to appoint the additional directors. First thing, directors are appointed in general meeting by the members. That's the general rule we have. However, under section 161, the board of directors have been given the power to appoint directors if they meet certain requirements. First, if you want to appoint additional director, there must be power in your articles. If your articles are silent, then table F operates and table F gives you the power, because table F has given the power. Okay. Now, who can be appointed? You can appoint any person. Till when he will be holding office? Till the date of annual general meeting. On annual general meeting, he may be regularized and he may be appointed. He may be reappointed like that. Or he may leave. If AGM is not held, then also he leaves on the last date on which AGM should have been held. How he is appointed? By passing special resolution. Okay, so I have Mr. X. Mr. X was proposed to be appointed as a director in the AGM, but the members declined. So the resolution was put forth, but it was not passed and lost. The directors thought of an idea. They said, no problem. We also have the power. We'll say I have lots of work and I'm appointing Mr. X as an additional director. You can't do that. So somebody who has failed to be appointed at general meeting can't be appointed as an additional director. So any person other than this can be appointed as an additional director. Okay, coming to the next part, that is alternate director. Alternate director, if there is any director which goes out of India for 3 months or more, so for minimum 3 months he has gone out of India, then the board may fill this vacancy. Board will be like, oh, who will do his work? If it can be managed, no need to fill the vacancy. It's not compulsory, right? You may not. If you have power in articles, table F doesn't say anything over here. So if you have power in articles, point number 1, or by passing an ordinary resolution in general meeting, then also power can be given to the board. So in these two ways, the board can get the power. If the board gets the power, they may appoint someone else by passing board resolution who is going to hold office till original director comes back or till expiry of the term of original director, whichever is earlier. Maybe he was appointed, the original director was appointed for 3 years, and his tenure expires in 4 months, right? So you stay as a director in 4 months and then you leave, because you are appointed in that director's place. You can't exceed his tenure. Okay, and somebody, supposedly I am already a director of this company and you want to appoint me as an alternate director for somebody who is going out of India. No, I will do my work. Get somebody else to do that work, right? If I can only work and it can be managed, then there is no need for alternate director. So you can appoint somebody who is not holding any directorship or alternate directorship in that company. Got it? Okay. So alternate director is not an agent, although the alternate director is appointed in place of the original director. He has complete freedom and power to take his own decisions. He will incur his own liabilities and duties. It's not that he has done some work and that particular person will be liable. No. It's just that he's appointed in his place, so his term is fixed as of the original director only. Otherwise, he's going to take his own decisions, right? Fine. Next is nominee director, right? Section 161(3). Nominee director is what? Again, a person who is being appointed by the board if the articles give the power in 3 situations. Any law says that you have to appoint a nominee director, or maybe there is any agreement, like if the company is taking loan from bank and company, we both decide that, okay, I am giving you loan, but then you have to appoint my representative as your nominee director. So that's by virtue of an agreement. Or the third case, government has invested in the company. So because of government's shareholding, the government is sending a nominee director, proposing, and that's being appointed by the board. So if the articles permit, the board can appoint nominee director in pursuance of any law or agreement or by virtue of government shareholding. Got it? Next. Filling of casual vacancy. Now, what is casual vacancy? Vacancy is what? The seat becomes vacant, right? And it may so happen when the term of the director expires. Maybe a director is appointed for 5 years and then that 5 years have ended. So of course he will go, you may call him back, you may reappoint him, right? Or you may appoint somebody else, right? If he can be appointed, you may appoint him. But when in between the term, the director office vacates, that means there's a sudden happening of what? Which is not pre-planned, because this was pre-planned. What was pre-planned? That you will stay here for one term of 5 years. This was pre-planned. Now there is a sudden happening which has occurred, like the director has resigned, maybe the director died, maybe the director has been removed, maybe he has incurred some disqualification immediately, etc., etc. So if any of these things happen, that means there is a sudden happening and casualty. So if there is a casual vacancy, again, you need power in articles to fill that, right? See, here also you need power in articles. Here you need power in articles or OR in general meeting. You get power from these two sources. For nominee director also you need power in articles, and for casual vacancy also you need power in articles. Then you pass a board resolution and you also pass an ordinary resolution. Why? How? Let's see that. So if the office of director appointed in general meeting ends otherwise in normal course known as casual vacancy, the board may fill this vacancy subject to AOA. That means you need power from AOA by passing a resolution at board meeting, and there will be subsequent approval of members in general meeting by passing OR. Okay, now there was a director who was appointed for 5 years. After these 3 years, that means his 2 year tenure is still remaining, but after these 3 years, he died. So this is a casual vacancy case that may be filled by the board, right, by passing ordinary resolution. So the board has filled this vacancy. He is going to hold office for what? 5 years? For these remaining tenure, 2 years only. Because again, it is a casual vacancy. Now, he's appointed by the board by passing board resolution. Whatever is the first general meeting, in that meeting, there will be an ordinary resolution passed for approving the director's appointment. Okay. Now, section 162, you don't need to revise, you don't need to study. All you need to remember is that if at a general meeting we wish to appoint 2 directors or more than 2 directors, there has to be a separate resolution for each one of them. Okay, for each one of them. Right? Okay. Moving to the next section, section 163, that is appointment by proportional representation. What is proportional representation? If I have to appoint 5 directors, A, B, C, D, E, I propose the appointment of first director. Mr. A, should he be appointed? There will be everyone voting. There are some majority shareholders and there are some minority shareholders. The majority shareholders say no. The minority kept on saying yes, yes. Will he be appointed? No. Second, again. So this is the normal voting system by which you don't really get any director who may be representing or who may be wanted by those minority group. So we changed the method of voting in proportional representation, which is again not mandatory, but it may so happen. First of all, it's not applicable to 100% government company or its subsidiary, right? And the directors who are appointed using this different voting method of proportional representation, they cannot be removed under section 169. So it's not that, okay, we are appointing and you're removing. No, that cannot happen because removal is by majority. Simply by passing OR, you can remove a director. Okay, so that is not allowed. How this changes the scenario? Let's take an example of one of the voting methods that's cumulative voting. Now, what happens? We have to appoint 5 directors. And if I have like 10 shares, I'm a very small shareholder and I have just 10 shares. So I will get 10 votes when the appointment is happening of this. Again 10 votes, again 10 votes, again 10 votes, and again 10 votes. 50 votes in total I will have for appointment of these 5 directors. I will not use 10, 10, 10, 10, 10, 10 votes to say yes or no. I will use all my 50 votes. I will use all my 50 votes. I can use all my 50 votes to say that I want this person to be appointed. Got it? So that's cumulative voting. This way, it can be ensured that, okay, my or the minority shareholders representative is also being appointed over here. So the concept is very similar. The vision is very similar to small shareholders director. Okay, so we have these 3 types of voting. Single transferable vote, cumulative vote, otherwise. Now, company may appoint directors by proportional representation of at least 2/3 of directors. At least 2/3 of directors. So either you may say, if you are appointing or if you're using this method, then at least 2/3 of your directors have to be appointed by proportional representation and the rest can be appointed by normal voting. Got it? Okay. Now, next we have, now once the director is appointed, Can he leave the company? I mean, what if he doesn't like the workplace, if he's not finding the right cooperation, if he has too much of assignments to accept and he feels that, okay, I am finding a better opportunity, so can he resign? The answer is yes. How to resign? That is the question, right? So the resignation is very simple. You give a notice in writing, give it to the company. The board will take note of it and the board is going to inform the ROC, right? But then because you are liable for all the acts which are done within the company with your consent and all of that, so you have to give it's very important that let everyone know that you're no more a director. So you have also been given an option that first thing is you want to resign, give a notice in writing to the company, board takes note, and board is going to intimate the resignation within 30 days in dir 12 to roc. Okay, you also have to display on company's website. Fine. Okay, ma'am. Now, the director may voluntarily, this is optional, this is compulsory that you have to inform the company, but this is optional that you may within 30 days in DIR 11 file a copy of resignation to ROC just to be on the safe side, because ultimately, ideally, it has to be routed through the company. You give to the company files with ROC, but you may also do this, right? Now, the resignation, what is going to be the effective date of resignation? The effective date. Let's say you are giving this particular resignation and you have not mentioned any date anywhere, then whatever date you are giving the resignation, date of receipt of notice, that is the effective date. Sometimes we are giving the date and resignation on this particular date, but we have written it clearly that my resignation is going to be valid and effective from, or with effect from 15 days later, or any specific date is mentioned. So that specific date. So resignation to be effective later of the date of receipt or the date specified. Clear? Okay. Next, we come to removal of directors, section 169. Section 169. How can a director be removed? If the directors want to remove another director, they cannot, but members can. Members have appointed them, members can remove them. How do they remove them? There is a certain term, right? Maybe they have been appointed for 5 years. Now, after 5 years, you're not removing them. The term is over, you're not maybe reappointing them. So that is not removal under section 169. In between the term, you want to remove the director. How can you do that? You have to send a special notice. That means special notice can't be sent. Just, I am one member and I want this director to be removed. I don't have any option, right? I have to become that eligible member. Eligible member means collectively, maybe I'm holding 1% of total voting power of the company, or at least 5 lakh rupee. Then I become an eligible member. Okay, section 115, we talk about eligible notice, and it's required when we want to remove a director, when we want to appoint someone else, and more cases. Okay, so I become an eligible member. So eligible member may send a special notice at least 14 days before general meeting to the company that we wish to pass this resolution for removing a particular director. As soon as the company receives that notice from the eligible members, it's going to forward a copy of it to the director. Forward a copy of it to the director. Means what, ma'am? Director, do you know the members have sent a notice they want to remove you in the upcoming meeting. So what do you have to say about it? Communicate something, talk to them. So the director is going to write a written representation and give it back to the company. The company is going to forward it, that this, a copy of notice and the representation by the director saying that this is the notice we received from certain members. They want to pass a resolution of removal of this director, and this is what director has to say, so that every member goes through the same and they can make an informed decision in the general meeting. So at least 7 days before the general meeting, it is sent to the members. Sometimes it is not possible to send it to the members, so it is read out at the meeting. If sent, fine, the general meeting will be held and there will be ordinary resolution passed and the director can be removed. Okay. Now, the director can be removed. Sometimes the director abuses his position, misuses his position, and writes in the written representation all the defamatory matter and etc. etc. So, any person who is getting affected by that written representation can apply to tribunal and say that, see here, the director is misusing this power and saying all rubbish things and communicating all false thing to all the shareholders. Stop this. So the tribunal may pass an order that there's no need to send any written representation. Okay. Now, once the director is removed before his tenure has ended, there is a vacancy. And that is a casual vacancy. Why? Because he has been removed midterm. So it is going to be filled in the same manner. Right. But if there was special notice that somebody else will be appointed in general meeting, then that can be done. Right. There are certain types of directors who are not going to be removed, who cannot be removed under section 169. First, the director which is appointed by NCLT. Second, the director which is appointed by proportional representation. Third, the nominee director. And fourth, the director, independent director in his second term can be removed, but it requires SR instead of OR. Okay. Now, when we have spoken about independent director, let's talk about independent director. Continuing our section 149. What is an independent director? Who is an independent director? Why do you need independent directors? Independent directors undoubtedly hold a lot of importance in any company for better decision making, for better transparency, for better accountability, for ensuring fairness, everything. Okay. But again, it's not possible to appoint them in every company. Independent directors are like expert, experienced industry people who come and give you a lot of insight, vision, and guidance in an unbiased manner, right? So it's very important that such person should not be inclined or connected to the company, because if they're inclined towards the company or the directors, or they're connected to the company, they will never be able to give an unbiased and fair opinion, and that is the whole purpose of independent directors. Okay. They're not required in all types of companies. They're required in listed public company and certain prescribed class of companies. In listed public company, whatever is your total strength of directors, out of that, at least 1/3 have to be independent director. That means if you're appointing 9 directors, 1/3, at least 3 have to be independent. Okay. Then there are prescribed class of companies. Public companies with paid up capital 10 crores or more, public companies with turnover 100 crores or more, or public companies with loans more than 50 crore. So if you fall into any of these 3 criterias, you need to appoint independent directors, minimum 2. Now both these are subject to audit committee. What is that? We read about the audit committee in section 177, and it says that the same types of companies also required to constitute an audit committee in which there are going to be minimum 3 directors, out of which majority will be independent. Now, supposedly there's a company which decides that I want to have 5 directors in my audit committee. So it is a company with a paid up capital of 20 crores. So it's not a listed company. It is this. According to section 149, it needs 2 independent directors. Yes. According to section 177, if you have 5 directors in your audit committee, then majority has to be independent. That means you need 3. So according to section 177, you need 3 independent directors. According to section 149, you need 2. So what will you appoint? 3. Because if I appoint 2, it's going to be contravention of this section. But if I appoint 3, it's going to be compliance of both. Because here also it's written minimum 2. It can be 3. Right? So that is what is written, that it has to be subject to requirement of audit committee also. Fine. Now comes the most complicated part. It's not complicated, but it's difficult to learn because there is so much. Okay. But then it's important. Who can be appointed as an independent director? Someone who is an individual, who gives consent, who has done, who is not disqualified under section 164 and gives a declaration of the same, whose appointment is within the directorships, who meets the criteria of independence, and his name is there in the data bank as created under section 150. This is the requirement which has to be fulfilled, and if this requirement is fulfilled, then you're being proposed and you're being appointed by the members by passing ordinary resolution in a general meeting, and thereby an independent director is appointed. So that's how the whole structure is. What is the criteria of independence, ma'am? If you are an MD, you can't be an independent director. MD, WTD, nominee director. Nominee director, you will always be a representative of the bank or the government, right? So, no. and you should be satisfying all the conditions. First, you should be a person of integrity, expertise, and experience. Not in my opinion, not in your opinion, but in the opinion of board. If it is a government company, in the opinion of ministry. Okay. Now, secondly, you should not be a promoter of company holding subsidiary associate, which you may call as cash, just to learn. You should not be related to promoter or director of cash. You should not have any pecuniary relationship with cash or promoter or director of cash in current year or preceding 2 financial years. What is pecuniary relation? Monetary relation. If I want to be appointed as a prospective independent director of that particular company and I have a building which I have given on rent to that company and I'm getting rent, this is a monetary relation that we share. The only monetary relation that we can share is remuneration. Or if the monetary relation is not exceeding 10% of my total income. But if it is a case that, okay, I have only two sources of income, one is this rental income and one is some salary. And salary I'm getting 10 lakhs and 10 lakhs I'm getting the rent. That means the monetary relation that I am sure is exceeding 10% of my total income. In fact, it's 50% of my total income. So I am totally dependent on that company. I'm financially totally dependent on that company. So I can't be an independent director. Okay. Next point, there are 4 points in this. None of whose relative. So if I am the prospective independent director in a company, my relative can't be holding security in cash during current or preceding 2 financial years for an amount exceeding 50 lakh or 2% of paid up capital. My relative can't be indebted to cash or promoter or director of cash in current year or preceding 2 financial years in excess of 50 lakhs. My relative can't give any guarantee to cash or promoter of cash or director of H in current year or preceding 2 financial years for an amount of 50 lakhs or more. What is given guarantee? There are 3 parties. There are 1, 2, and 3 parties. Okay. This is my relative, this is the company, and this is some third person. My relative does not have to pay anything to the company. Company has given loan to this third person and my relative has said that if third person does not pay, I will pay. So you are not currently indebted to the company. My relative is not currently indebted to the company, but my relative might have to pay if the third person defaults because my relative has taken guarantee or given any security. So there could be indebtedness for an amount of 50 lakhs or more. So in that situation also I am disqualified. My relative should not have any monetary relationship with cash of 2% or more of turnover or total income. Okay. Next point, again there are 4 points and these 4 points are not just for me or my relative but for both of us. Neither me nor my relative can be KMP or employee in cash in preceding 3 financial years. Neither me nor my employee, but my employee can be, my relative can be an employee in preceding 3 years. That means 3-year condition does not apply in case the relative is an employee. I cannot be an employee. I cannot be KMP. My relative cannot be KMP. My relative cannot be employee. But my relative can be employee in the preceding 3 years, not currently. Okay. Now, neither me nor my relative can be employee, proprietor, or partner in preceding 3 years in audit firm, cost audit firm, or CS firm of cash, or a legal firm which has 10% or more of its total income from cash. Okay. Now, neither me nor my relative, that means together, we can't be holding 2% or more of total voting power of the company. So if anyone asks you what is the maximum voting power or maximum shareholding which an independent director can hold, independent director together with your relatives, you can't hold more than 2% of voting power. 2% or more. That means it has to be less than 2%. It can't even be 2%. Okay. Neither me nor my relative can be CEO or director of such an NPO which is receiving 25% or more from the director, company, or holding subsidiary, associate, or such an NPO which holds 2 or more percent of voting power.
Okay, now these are the points which we have done with extreme details and a lot of examples. Right now, it's all about learning those points, right? So please try to learn as much as you can. And the last one is very simple, that independent director, you have to possess the qualification as prescribed. What is the qualification which is prescribed? You should have experience and knowledge in certain fields. What are those fields? Finance, management, sales, marketing, corporate governance, etc., etc. Okay, fine. Now, what is the tenure of independent director? Independent director, you can be appointed for maximum 2 terms. One term is of maximum 5 years. So 5 years, again 5 years. Then there has to be a cooling period, and then you may be again be reappointed. During that cooling period, you can't, cooling period is of 3 years. During that cooling period, you can't be associated with the company in any capacity. In any capacity. Okay. You will not be liable for every act which the company is doing. You will be liable only for those acts where you have given your consent, or where you have not acted diligently. Only in these two situations. The non executive directors are not responsible for anything and everything. Okay. Now, if you are going to be appointed as an independent director, you also need to give a declaration of independence, because all these points can't be elaborately and detailed checked by everyone. So you have to give a self declaration that yes, I meet the criteria of independence. When you will give it? In the first board meeting that happens after you become the director. Okay. And every year in the first board meeting, and every time when there is change of circumstance, which can create a doubt that, oh, are you still independent? Are you still meeting the criteria of independence? So you give a declaration that yes, I still meet that. Okay. Independent directors, you follow a schedule 4. What is that schedule 4? That is a code of conduct for independent directors. So we have 7 schedules under Companies Act. Schedule 4 says that, right? Not required to be studied right now. Then what do they are not going to retire by rotation, and they can be removed in the first term by OR, in the second term by SR, right? Likewise, their appointment also goes. In the first term, they are appointed by OR. For the second term, they are appointed by SR. They are going to get what they get: sitting fees. What is sitting fees? Every time they're coming to attend a particular meeting, you're paying them. That's the sitting fees. Reimbursement of expenses, maybe to and fro expense and all that, profit related commission. What they don't get: stock option. Why? Because in that situation, they will be financially interested in the company. What is stock option? The option to buy the shares of a company at a predetermined rate in future. So you know that, okay, if I stay, that is an incentive for making the employees stay for longer. So now you know, okay, if I stay for 1 more year in this company, I'll get an option to buy the shares at such reduced price. Okay, let me work for 1 more year, right? So if independent directors also get this, they will take all the decisions just to increase the share price, because they are financially interested in the company now, right? So that is why they are not entitled to stock option. Okay, right. Now the data bank, as I told you, to become an independent director, you also need that your name should be there or included in the data bank. The data bank is maintained by central government. Central government has told that, okay, we will notify an institute, which is IICA, right? And they are going to have the partners and all that, right? So they maintain a data bank. What is that? It is going to contain the name, address, qualification of certain people who want to become the independent director, right? Okay. Now, there are 3 types of people who have to apply or who can apply. One is, when this rule came into picture, there were many independent directors who are working as independent director, but their name is not there in the data bank. So they have to apply within 13 months along with the fees. They can apply their name to be included for 1 year, 5 year, or for lifetime. Okay. Anyone, like the company approaches me and they said that I want to appoint you as an independent director. I said, I need to apply it then. Go and apply that. You have the form. I also need to enroll myself in that data bank, then do that. So if you intend to be appointed as independent director, then before appointment, you have to apply for inclusion of your name. Voluntarily also, even if you don't have done, you have done or you don't have done. If I want, it's like an employment opportunity. So if I want, I can apply and I can get my name enrolled in that data bank. But that is not it. If it was the case, then everyone would have done that. Within 2 years, you also need to pass a proficiency self-assessment test in which you need to score at least 50%. Once your tenure expires, then within 30 days, you can file the application for renewal. But there are certain people who are exempt from this test. The director or KMP who have served as director or KMP for at least 3 years in listed public company, unlisted public company which has a paid up share capital of 10 crores or more, or any body corporate which is listed on a foreign stock exchange in such a country which is a member of FATF, right? Any body corporate which is incorporated outside India, but then it has a share capital of 2 million US dollar or more. Then any statutory corporation like LIC. Okay, if you have 3 years of experience in the pay scale of a director in any ministry, like Ministry of Corporate Affairs, Ministry of Finance, Ministry of Commerce and Industry, only these ministries, Ministry of Heavy Industries, right? If you are in the pay scale of Chief General Manager or above in SEBI, RBI, ADA, PFRDA for 3 years, so you are exempt. Lastly, those individuals who have been in practice as an advocate for 10 years, chartered accountant for 10 years, cost accountant for 10 years, company secretary for 10 years. So these are the people who are exempted from test and they're not required to pass any self-proficiency assessment test. Okay. Now, small shareholders director, section 151. Again, very important from examination perspective. Many students ask me, ma'am, is SSD mandatory? No, it's not mandatory. It is possible only in case of listed companies. Who is a small shareholder? The shareholders who hold shares of not more than 20,000. So maximum they are holding shares of 20,000 only. Okay, they are small shareholders. Any listed company may think that, oh, I am not able to, we don't have any director who is representing the interest of small shareholders. So my small shareholders may not be getting what they want, right? We're not getting to understand their perspective. So listed company suo moto on its own. It has not been forced voluntarily, right? They may appoint SSD. SSD is what? A director which is elected by small shareholders. That means if there are 400 shareholders in a company and only 100 shareholders are small shareholders, there is going to be a director who is elected only by those 100 shareholders. That is a small shareholders director. Sometimes small shareholders of a listed company may feel that we want our representative on board. So, on notice of at least 1,000 small shareholders or 1/10 of small shareholders, whichever is lower, they may send a notice to the company, and the notice should have clearly written that this is our candidate, this is the name, this is the address, this is the shares held by that candidate, and there is a statement of the candidate that yes, I hold the DIN, I give my consent to become SSD, and I'm not disqualified. So this declaration and everything is going to be attached with the notice and given to the company, and company calls the meeting of the small shareholders, and one person is elected as SSD. He may or may not be independent director. Okay. If he meets the criteria of independence, and gives the declaration of the same, he shall be considered as independent director. Okay. Now I have explained you this in entirety in the class. Okay. So keep that in mind because there are a lot of points and then the confusion floats in. Okay. Now, one person can be SSD in maximum 2 companies. That too, the second company should not be in the competing business. There is no reappointment allowed for SSD. That means you are appointed for 3 years. Then there is going to be a cooling period of 3 years. Then you can again be reappointed. You can again be appointed, but no consecutive reappointment. Okay, fine. And they are appointed on non-votational basis. They can be removed under section 169. They have to vacate the office if any disqualification under section 164 is attracted, if there is any ground of vacation under section 167 is attracted, or if they cease to meet the criteria of independence, right? Lastly, in this topic, we have a lastly in this chapter, we have a topic of registers. Sweat equity shares, share certificates, buyback, the securities bought back, charges, deposits, members, debenture holders, the register of members, register of debenture holders, right? Then we have the books of accounts under section 128, register of directors, KMP under section 170, copies of annual return, registers of investments which are not in company's name, etc., etc. So there is a huge list of the registers which are required to be maintained by the act. Of course, this list is again important, and it's you must learn it, right? Okay, that's it. Thank you.
Okay, let's now revise the chapter of appointment and remuneration of managerial personnel. If you go by Companies Act classification, it's chapter 13 of Companies Act and starts with section 196 and goes till section 205. Right, there are a few sections which are not in our syllabus, which we're not supposed to read and revise, of course. Now, before we begin with this particular chapter, there is something called as managerial personnel, and we need to understand who is managerial personnel. So managerial personnel basically covers three terms, that is MD, manager, as well as WTD. This particular meaning is different from the definition of KMP, wherein more people are included, so don't be confused with the same, right? We are talking about appointment and remuneration of these managerial personnel, right? We also have some provisions with respect to KMP, but broadly, when I talk about section 196 or when I talk about section 197, this talks about appointment of MP, this talks about remuneration of MP, right? Remuneration to MP plus other directors. So one by one, we are going to revise this all, okay? So if I say that the company has two type of directors, executive directors and non-executive directors, right? MD and WTD both fall into the category of executive directors, right? Now, executive directors plus the manager is what managerial personnel means, and whose appointment we are going to read in section 196, right? Other than that, the directors chapter that we have already read talks about the appointment of section under section 152, which is majorly for non-executive directors, but because once you're appointing your MD or WTD, then they have to be governed by this section. Of course, if somebody is MD and whole-time director, then he has to prima facie first fulfill all the requirements of being a director, and then he can come into this particular category, right? Now, before I go on to section 196 revision, you have to understand that what do we mean by managing director, because the definition of managing director is the most important one, then comes the definition of manager, and least important one is the definition of WTD. So managing director, who is he has to be a director in the first place. He has or he is entrusted with substantial powers of management of affairs of the company, right? How he has got that powers? By articles or by an agreement or by resolution, whether it's a board resolution or an ordinary resolution in general meeting. When I say that he has got substantial powers, supposedly a director has been given the power to sign the share certificates. Is it that he has been given substantial powers? The answer is no. Because the power to do administrative tasks of routine nature are not to be included in the substantial power. So if I say I give you the power, or the board has given one particular director the power to affix common seal or power to sign a negotiable instrument or share certificate, as I said, it cannot be said that he has got the substantial powers. Okay, so these are the points that you need to remember. Then comes your definition of manager. Manager is somebody who may be a director, who may not be a director. So it is just an individual. Now, many a times we feel that, okay, this is a company, and in the company, if we go on to appoint managing director, oh my God, there are so many formalities, because in the first place, that person has to be a director. So he should have DIN, he should give consent, he should not be disqualified under section 164. Again, if any disqualification is attracted or if more grounds are there, he may have to vacate, right? So there are so many requirements of becoming MD. So instead of appointing MD, why not we appoint manager? Manager is exactly going to do the same work. In fact, he is or he has the management of whole or substantially the whole of affairs of the company. So even more role can be assigned to a manager, right? So many a times, although many a times I wouldn't say, because in the practical arena we see that there are more MDs in the company than we have managers. And manager doesn't mean that product manager, sales manager, factory manager. No, manager is somebody who's occupying an overall managerial position in the company, right? He may also be a director, it may be under a contractor service or not, right? When I talk about WTD, WTD is very simple. It could be any director who's in whole time employment, right? Okay. So, the very first thing that section 196 tells us, section 196 actually tells us that who can be appointed as MD, WTD, or manager, how long can they serve the company, what is their basic eligibility criteria, right? How they are going to be appointed. At times you need CG's approval, so when do you need CG's approval, and all of that, right? The very first thing that section 196 says, and which is the most important thing, no company is going to appoint at the same time a managing director and a manager. That means a company, you can't have a MD and manager together. You can have two or more MDs, although they are not appointed as such. You can't have two managers. You can have manager and whole time directors. You can have MD and whole time directors. Okay, fine. Now, whenever I say that, okay, these are going to be appointed, they can be appointed for a maximum term of 5 years only. There is a time limit because it has to be like there is a check on their appointment, like it prevents that indefinite association with the company, that everyone is relaxed and not working at all, right? So keeping that logic in mind, this has been made the provision that if Mr. Z, let's say, is appointed for 5 years as MD, after that he has to vacate. He has to vacate. So that means, will there be a cooling period? The answer is no. There can be reappointment also, but then at one stretch, he can be appointed for 10 years. Okay. Now, if I say that the company, you are appointing one particular person as MD and you can appoint for maximum 5 years. So the minimum tenure is not given. Minimum tenure could be 1, 2, 3, 4. Maximum is 5. Supposedly one person is appointed for 3 years. Now, at the end of 3 years, can he continue for 2 more years because maximum term was 5 years? No, his one term has ended. Now he can be reappointed. He can be reappointed. And just to not hamper the flow of the company, he can be reappointed. Supposedly he is appointed for 5 years. He can be reappointed earlier than 1 year. He can't be reappointed earlier than 1 year before expiry of his term. So if his term is going to expire here, he can be reappointed here, not before that. Like we have appointed this particular person, after 1 year we have made the reappointment for next 5 years also, then after 1 year we have made the reappointment for next 5 years also. Again, you are destroying the whole essence of this particular provision. Okay, so the reappointment can take place, and it can take place even before the person's term has expired, but not earlier than 1 year. Okay, fine. Then comes your disqualification. What are the disqualifications? There are prima facie 4 disqualifications which are being written. First one is age. Somebody who is below 21 can't be appointed as MD, WTD, or manager, and somebody who has attained 70 years of age again can't be appointed. But then there is a relaxation also for somebody who has attained the age of 70. If you have attained the age of 70, then you can be appointed if SR is passed. Now, let's say the SR is also not passed. Still, there are members who want that, okay, this particular person should be appointed. That means the votes in favor are more than votes against. So, in this situation, if you obtain CG's approval, you can again appoint somebody who has attained the age of 70 years. So if I ask you, can somebody who is 19 years of age be appointed as MD? The answer is a clear cut no. There is no relaxation in this. But somebody who has attained the age of 70, yes, can be appointed if SR is passed. Even if no SR is passed, but the votes in favor are more, then after obtaining CG's approval, he can still be appointed. Okay, somebody who is an undischarged insolvent, somebody who has made any suspended payment to the creditors, or who has been convicted by the court for more than 6 months, for a period of more than 6 months. In these three cases, you are disqualified for life. You can't be appointed as MD, WTD, or manager. Got it? So these are the disqualifications, or the age and eligibility disqualifications, which are given in the section. Now, this is not it. We also have Schedule 5. When I talk about appointment of managerial personnel, it is read with section 196 is read with Schedule 5 Part 1. Schedule 5 Part 1. So we will go to that and we will read about that, right? But before that, how do we appoint a managerial personnel? A managerial personnel is going to be appointed in the board meeting. Oh, wow, ma'am. So there will be notice sent to all the directors. First, the notice is going to be called for board meeting and there will be a resolution passed. After that, you will call a general meeting and their ordinary resolution will be passed. So you need approval from the board and then you need approval from the members. And sometimes you also need CG's approval. Okay. So you call the board meeting, the board resolution is passed, you appoint that particular person, and in next AGM you get the approval of the members. If you get the approval of the members, great. You have to file the return of appointment to ROC, and if no approval is made, still the prior acts which have been done by MD, WTD or manager are going to be valid. Okay, so if an appointment is not approved by the company in the general meeting, any act which is done by these persons before their such approval, they are still going to be valid. They're still going to be valid. Now, sometimes you need approval of CG also when you do not comply the conditions stated in Part 1 of Schedule 5. If you comply with the conditions stated in Part 1 of Schedule 5, then all you need is a board resolution plus an ordinary resolution to appoint these three people. Okay? Right, whoever, these three people. Now, when I say, ma'am, we want to appoint CS, which we read in section 203 about KMP, then there you only need board resolution. But KMP also includes MD, and if you want to appoint MD, you have to follow this particular procedure. So don't be confused at all in that. Okay, next we go to the conditions which are stated in Part 1 of Schedule 5. What are the conditions? The very first one, you should not have been sentenced to imprisonment for any period, 1 month, 2 month, 3 month, under the specified 19 statutes. Okay, or there shouldn't have been any fine imposed exceeding 1000 under these statutes. If it is there, then you can be appointed only after you get CG's approval. See, if you do not fulfill the conditions which are stated in section 196, you can't be appointed. But if you do not fulfill the conditions stated over here, you can be appointed subject to CG's approval. Okay. Next is, you have not been convicted, but you have been detained. Detained under conservation of foreign exchange and prevention of smuggling activities. I hope you know what detention means, right? Next is, you have not completed the age of 21 and not attained the age of 70 years. Many students get confused over here and ask me that, ma'am, somebody who has not attained the age of, somebody who has attained the age of 70 years can be appointed by passing SR. Yes, that has been clarified. That if your appointment is approved by SR, no need for CG's approval, because this is something which is stated in the section. So the same point is stated in section 196, which is going to be over and above this. So somebody who is 19 years of age and we need CG, we get CG's approval, can we appoint that particular person as MD? The answer is no. Section is going to supersede that. Okay. Lastly, he must be a resident of India. What do we mean by resident? He should be there for at least 12 months immediately preceding the date of his appointment. Okay. So that is what resident means. Okay, if these conditions are fulfilled, great. If these conditions are not fulfilled, then you need CG's approval. So basically you need to check and you need to obtain CG's approval, right? Okay. Now, when we are appointing MD, WTD, or manager, if we are appointing Mr. X, who is also MD of ABC Limited, and we are appointing him as MD of PQR Limited, right? Is it allowed, ma'am? We have prima facie read under section 203 that you can't be KMP in more than one company except its subsidiary. That is what we have read. But then there is an exception. What is that exception? Exception number one, with the permission of board, you can be appointed as directors. Exception number two, one person can be appointed as MD in two companies, subject to, in the second company where you are going to be appointed, UBR needs to be passed, that is unanimous board resolution. What is unanimous board resolution? Where all directors give the consent, right? So in this particular situation only there will be UBR, otherwise there will be board resolution plus OR plus CG's approval if needed. Got it? You have to file the return of appointment within 60 days of appointment, right? Okay. So MR1 is the form, return of appointment, and MR2 is the form for seeking CG's approval, right? Okay. Moving to the next section, section 197, wherein we talk about the overall managerial remuneration. When I talk about remuneration, there are two situations. One is when the company has immense profits, and the second is the company does not have adequate profits or there are losses in the company. What do we mean by profit or loss? It is not the general profit and loss account that, okay, this is the profit that we are getting. No, it is in accordance with section 198. Okay. Now, if there are sufficient profits, maximum 11% of the net profit can be paid, can be used to pay the remuneration to all the directors, plus manager. All directors, yes. All directors means MD also, WTD also, non-executive directors, that is part-time directors, etc. Also, yes. This entire thing. Okay. If we want to pay more than this, we need authorization, that is, we need approval from members. Okay, ma'am. That is not it. This was the larger limit. We have a sub limit also. We have a bifurcation also, right? There would be two situations in the company. There are managerial personnel, there are no managerial personnel. That means the company has appointed somebody as MD, or maybe there are whole-time directors, or maybe there is some manager. And the other case, the company may also function only with the non-executive directors. That means the company neither has MD, nor has WTD, nor has manager. Ma'am, is this possible? Yes, it is possible. When we read the section of KMP, then also you will realize that only in case of certain companies these are mandatory, otherwise they may function like that also. So these are the two situations. When there is no managerial personnel, that means we need to pay remuneration only to our non-executive directors. We can pay maximum 3%. Maximum 3% of net profits to these. If there is managerial personnel also, then maximum we can pay 1% to the non-executive directors. Maximum we can pay 1% to the non-executive directors. Again, there comes a bifurcation. There would be a situation, there are managerial personnel now. Maybe there is one of them, maybe there is more than one. So if there is only one managerial personnel, that means maybe there is one MD and a few non-executive directors. So to non-executive directors, you can pay 1%. And to this managing director, you can pay maximum 5%. If there are more than one, that means maybe there is one MD, there are two whole-time directors, there's manager, MD and manager can't be together. So maybe there is one MD and two whole-time directors. So together, to all these managerial personnel, you can pay 10% maximum. So 5 or 10% depending upon if the company has one MP or more than one MP. 1 and 3% depending upon if the company has MP and does not have MP. Okay, got it? So this is the limit which has been set in section 197. You need to learn and understand this limit beautifully for exam. Okay, now if the company has defaulted in payment of dues to any bank, then you need prior approval of bank or PFI also. If you need to pay, if you want to pay more than this particular limit, then SR is needed. But then, as I said, before obtaining SR, you also need bank or PFI approval. Got it? Okay, ma'am. Now, what about the case where there are losses or maybe there are inadequate profits? In that situation, the entire remuneration, what can be paid, what can't be paid, is going to be governed by Part 2 of Schedule 5, right? Which we are not supposed to read. Okay, there are more points in section 197. What are those more points? First of all, the sitting fees. The sitting fees is exclusive. That means when I am saying you can pay maximum 11% of remuneration, you can pay this plus you can pay extra sitting fees. So sitting fees is not included in that remuneration. Okay. How do you pay? Mode of payment, you can pay monthly, you can pay as a percentage of profits, or a combination of both also. Sitting fees is over and above remuneration paid to a director for attending meeting, even in case of losses. Maximum sitting fees which can be paid is maximum 1 lakh. But many a times there is a discrimination seen in sitting fees. That means if there are 3 directors or 4 directors, one is a woman director, maybe she's getting less. Or maybe there is independent director, he is getting less and other directors are getting more. So this discrimination should not take place. Whatever fees you're paying to other directors, you can't pay less than that to independent as well as woman director. Okay. So I hope this is clear. Fine. Now, sometimes it can happen that some excess remuneration has been paid because initially whenever we hire someone or we appoint someone or we enter into a contract of service with someone, it is like, okay, we'll pay you monthly 2 lakhs, so at the end it's going to be 24 lakhs, and we calculated, which is maybe you're a non-executive director and this percentage exceeds 1%. Now we have paid more, so we need to take it back. So the person has to refund it within 2 years or lesser period as allowed, right? Sometimes it can be waived, but for that waiver, you need to pass SR within 2 years. You need to pass SR within 2 years, and if there is any default in payment to bank or PFI, you need their approval also. So that is the case of excess remuneration. Okay. Now, there is something more. Whenever we pay remuneration to any managerial personnel or manager or managing director, we pay it for everything. Like whatever you're doing in the company, you're getting remuneration for that, and there is a capping of 11% on that remuneration, right? So we are paying it that way. But like if I am the director and there is a computer which was not working, so I just checked a few bugs. Maybe there is I do not have, I am not an IT expert, I just had knowledge, I just fixed it, right? Maybe there was somebody who needed some help with an Excel report or maybe MIS report and I helped it. Am I going to get extra for doing these services? The answer is no. So remuneration for other services is included in managerial remuneration. It is not included if it is not included if I render some service of professional nature and in the opinion of NRC, I have the qualification to do so. Which means that supposedly there is a hospital and I am the director of the hospital and I am also a very famous heart surgeon. So I perform some surgery there, right? So, am I going to get extra for that? Undoubtedly, yes, because you're qualified according to the board, according to NRC, and you're rendering some services of professional nature. So, you are. Maybe I'm rendering some legal consultancy services if I'm qualified to do so. Maybe I am an IT expert and I have that and I am rendering some services. So, in that case, only it is going to be extra, it is going to be allowed. Otherwise, it's not going to be allowed, right? Okay. Now, before I go to the next section, there is something more, and that is all about disclosure. So, we also have section 197.12 read with rule 5, which talks about disclosure. Disclosure, like what? Disclosure is only mandatory for listed company. So, listed company, in your board's report, you need to write and you need to provide a lot of details with respect to managerial remuneration, like what? The first one, ratio of remuneration of each director to the median remuneration of employees of the company. What do you mean by that? Like, I am being paid 10 lakh and the median remuneration is 5 lakh. So the ratio is what? 2 is to 1. So median is what? If there are 10 employees and we rank them according to the increasing of their remuneration, which is the middle one, right? That means in a way you can say average, but not average calculated the average, it is calculated. That is the basic maths concept. Okay, now, so basically what I'm comparing the ratio that this director, and in fact the ratio of each director that I am getting compared to the median remuneration of the employees, right? Okay, the next is the percentage increase in my remuneration, the percentage increase in the median remuneration, how many permanent employees are there, what is the average increase in the salary, percentile increase in the salary, affirmation that whatever remuneration we are paying is according to the policy, right? Then there are some employees who are getting a lot of salary, who are drawing a major chunk of company's finances, that also needs to be reported. So, a statement showing the top 10 employees, right? Then, if you are employed in the company and you're drawing more than equal to 1 crore and 2 lakh per financial year, or 8 lakh 50,000 per month, or you are employed but you're not drawing more than this amount, but you're drawing more than MD, WTD, or manager, then also your name has to be reported. Okay, what is your designation, what remuneration you are getting, what is your qualification, what is your age, everything has to be reported. Okay, got it? Some more basic things, that the insurance is not going to be part of your remuneration, the indemnity insurance which the company takes on behalf of the directors, right? And that is it. Okay, then we come to section 198. Now again, section 198, I don't know why it is not here. Okay, section 198 now. Section 198 is not just used over here, but also when you read about the CSR provisions, then also you calculate the net profit according to section 198 only, right? Okay, so basically it is used at two places. Now, there is no specific calculation or anything like that, but then it is all about including certain things in your profit and not including certain things, right? That is how deducting certain expenses and not deducting certain expenses, that is, it is all about that, right? That is, if there are some very huge capital profits, if there are some very huge maybe capital profits basically mean that if you have bought a particular product at a certain price and you're selling it for more than that price, that is capital profit. I have seen many students getting confused in this calculation of capital profit. So you have to understand one basic criteria that, okay, if in my books I bought a particular product for 10 crores and in my books the WDV is 6 crores, and if I'm selling it at 8 crores, so 8 minus 6 is 2 crores is the profit that is allowed and can be a part of your P&L. But if your WDV is 6 crores, your cost was 10 crores and you're selling it at 12 crores. So 2 crores is the capital profit. You bought a particular product at certain price and you're selling it more than that price. That is capital profit, and that is not allowed. Okay, so first thing, the bounties and the subsidies that you get from the government, that is an allowed credit. What is not allowed? Premium on shares, profit on sale of forfeited shares, profits of capital nature on sale of undertaking, profits from the sale of immovable property, right? And again, the part where your sale price exceeds the cost, credit is not going to be allowed. But sale, as long as it exceeds the WDV, that is the cost in the WDV, that difference, that is allowed, right? I just explained you, and we have done a lot of examples in the class. Next is your revaluation profit, which is an unrealized gain. So it is not going to be allowed. There are certain normal deductions which are allowed, like your working charges, like your remuneration, like your bonus, right? Like your interest on debentures, interest on loans, and expenses on repairs, depreciation. All this is going to be allowed. What is not allowed is your income tax, is your loss of capital nature, the revaluation loss, etc. Okay. Now, section 200. Section 200. What is section 200? Section 200 talks about the company fixing limit or fixing the remuneration. We have seen two categories. One, the company has immense profits. Second, the company is not having so many profits and is having losses, right? Basically, that is the situation. In that situation, it is very important to give certain guidelines that what remuneration should you be fixing or approving, right? So at times CG approves it, at times the company does it, right? So they have been given certain parameters, and this is something that you need to consider, and this is something that you need to learn. So when you're fixing remuneration in that particular case, what you should keep in mind is what is the financial position of the company. Is the person drawing remuneration in any other capacity from the company or from other companies? What is he drawing? What is his qualification and experience? Right, there are certain more prescribed parameters, and in that prescribed parameters we see what is the company's financial position, financial performance and operating performance in the last 3 years. What is the relation between remuneration and performance? If your remuneration increases, does your performance is also increasing, right? Remuneration policy, is it differing from other employees? What is the security which is held by the directors, right? So there are all these factors which needs to be considered, the parameters which needs to be considered, and this is important for exams, so you need to learn it. Okay, next is your compensation for loss of office. What loss of office? It is paid only to MD, WTD, or manager. It may be paid, it is not mandatory, right? It may be paid, it is not mandatory, and it is going to be paid to only these people and not to any other directors. Now, one MD is appointed for a term of 1, 2, 3, 4, and 5 years, right? So he thought that his future for the next 5 years is secured, but after 2 years, they found a better candidate and they simply removed or terminated him. Now, for the next 3 years, what is he going to do? He had plans after these 5 years, but what is he going to do? This is an unfair removal, and for these unfair removals, there should be some compensation which is going to be paid, right? The compensation which can be paid maximum is lower of unexpired tenure or 3 years. That means if you have been appointed for a tenure of 5 years and you have been removed only after 1 year, you are not going to get compensation for the remaining 4 years but only 3 years. But if the remaining years are only 2 or 3, whichever is lower, so for the remaining 2 years, that is how your compensation will be calculated. Okay, the compensation will be based on what you were drawing, or the average remuneration in the preceding 3 years. Based on that, for the remaining tenure or 3 years, whichever is shorter, you are going to get that compensation, right? However, there are certain cases when this compensation is not going to be allowed. You are resigning, your wish, any disqualification is attracted and you have to vacate. There's nothing which the company has done wrong. You have done some fraud, you have done some negligence, you have done some misconduct. You are responsible.
You have done, or you have been so negligent that because of you, the company is now going to be wound up. So no compensation. You are being removed, but because the company is going to be merged into another company, and now you will be the MD of that merged company. So there is no loss of office technically, right? Or you have done anything which has brought about your termination. So you yourself are responsible. Got it? Okay. And now the last section is section 203, appointment of KMP. It is not mandatory in all companies. As I told you, there are many companies which can function without appointing any whole-time director or managing director or manager. Fine. Okay. So if you're a listed company, it is mandatory to appoint. Even if you are not a listed company, but you're a public company with paid up capital of 10 crores or more, then also you need to appoint any one of these plus CFO plus CS. So MD, WTD manager, or CEO and CFO and CS. But if you do not fall into this category, but you are a private company with a paid up capital of 10 crores or more, you don't need all these, you just need one CS. That is mandatory. Of course, you can appoint MD, and as when you want to. How do you appoint? By passing a board resolution. Okay, if there is any vacancy, it is going to be filled by the board only, right? Okay. Now there are certain things. One person can be KMP in only one company except in its subsidiary. He can be a director in others with a board permission, as I already told you. One person can be MD in maximum two companies, that too if specific notice is sent and unanimous board resolution is passed at the board meeting. This also I told you. Now you can't be MD and chairperson together. You can be if your articles provide so, or the company is not doing multiple business, or even if the company is doing multiple business and you fall into that prescribed category as by government. The company has appointed separate CEO for each business. So this is very detailed point that I am telling you, right? Overall, this is the section that we have to keep in mind, and that's it with the revision of this particular chapter. Okay, thank you. Okay, so let's now revise the chapter of board meetings and its powers, right? If I talk about this particular chapter, it's a huge chapter, right? Covering a lot of sections and is divided into two broad parts. One is the meetings of the board, and second is the powers of the board, as the name itself suggests, right? Okay, so what do we mean by board meetings? When I talk about board meetings, it is nothing but the meeting of the directors. Why is it important to meet? Undoubtedly because company is an artificial person and company can't run it on its own. So you need somebody to take decisions on behalf of the company. Now, prima facie, the board of directors have been entrusted with majority of the decisions of the company, except for those which are reserved for the shareholders, right? Now, how are they going to take this decision? Undoubtedly, the power to take decisions for or on behalf of the company is not with one director, it is collectively with the board. So, how do they take decisions? For them, it's important to meet. And if they don't meet regularly, companies' major decisions might be taken rashly or in a haste or not calculated or not thoughtful, right? So it is not going to be in the best interest of the company. That is why there have been made some sections which mandate the requirement of board meetings. Now, just like we have read general meetings, we also have board meetings wherein we see that what has to be done before the meeting, what has to be done during the meeting, and what has to be done after the meeting, right? So before the meeting, you need to send notice. During the meeting, you have to ensure quorum, how the resolution shall be passed, voting shall take place, and after the meeting, it's all about entering into the minutes and all, right? So that is one by one we are going to see for that. But first, section 173, from where this chapter starts, the very first thing that we see is that every company must hold 4 minimum board meetings. Minimum 4 board meetings. When you get incorporated, the first board meeting has to be held within 30 days of incorporation. Okay, within 30 days of incorporation, wherein you decide the first auditors and all of that, right? We can relate it to a lot of sections. So first board meeting within 30 days. Thereafter,
minimum 4 meetings in every year. But then that is not it. The gap between two board meetings should not be more than 120 days. Should not be more than 120 days. Like, that is the whole essence. No, the board should meet at regular intervals. There shouldn't be a lot of gap. Now, there are certain exemption benefits granted to certain types of companies. First, when we talk about section 8 company, if minimum one meeting is held in every 6 calendar months, it is completely fine. Okay. Secondly, we come to OPC, small company, dormant, and startup private company, you can say. Then minimum one meeting in half year, and gap between two meetings should be at least 90 days. Now, here the purpose is that one meeting has to be done here, one meeting has to be done here. Many companies, what they do is they are going to do two meetings here, and then all year round the board is not even meeting, because minimum two meetings are only mandatory for them. So this should not happen. Minimum gap between these two meetings should be at least 90 days, just to ensure that the flow isn't done like that. Okay. So this is for them. And then we have one person company. One person company, with whom will you meet? You need to find someone else. So if you are a company with just one director, you may have up to 15 directors, and that can also further be increased. But you may also be formed with just one director, because when I talk about minimum number of directors in a company, for OPC it's 1, for private it's 2, and for public it's 3. So OPC, if you have just one director, the director isn't going to meet anyone. The director itself is a meeting, right? So for them, this particular section is not applicable, undoubtedly. Okay. Next, we move to how the meeting is going to take place. I mean, fine, you have called all the directors, and all the directors are going to come and discuss. But what if some director is unable to attend? Now, in an era of technology, don't you think there should be some option of participating through electronic mode also, right? Like, if I have to attend a wedding and I'm not able to be there, people can always just at one click do a video call, and I can be a part of the ceremony, and I can look around, I can contribute my thoughts, I can talk to people concurrently, right? The same thing is put here also, as simple as that. It could be any AV means, right? Audio visual means, a video conferencing. So whenever a director wants to participate in a board meeting, he could participate in person by walking into that room physically, right? Or he may also be present in that meeting through video conferencing or AV means. Clear? Okay. Now, when I talk about this AV, there is a certain procedure which needs to be followed, and there are certain things which needs to be taken care of. Like, before I tell you this, what do you think, who is going to actually call for that meeting? Like, who is responsible for convening a board meeting? If a company has a company secretary, it is always CS. CS, along with the chairperson, convenes the whole meeting. If there is no company secretary in the company, then there would be any person who is authorized by the board along with the chairperson. He's going to do all that, right? So basically, we have the company secretary and the chairperson. Now, when you're convening the meeting, it is very important for you to ensure certain things so that the meeting can be made a success. The very first thing, there should be proper equipment. Proper equipment. Undoubtedly, if you need, like, maybe you need a speaker, maybe you need certain setup. So you should have that proper equipment available pre-hand. Secondly, you have to maintain the security and integrity of the meeting. Why? Because board meeting is something which is highly confidential, unlike general meeting, which is of the shareholders and members. So in board meetings, there are bigger decisions about the companies, maybe merger, maybe something like that, which can be highly confidential unless that information is leaked out. So when they're discussing, there shouldn't be anyone else who is not a part of the meeting, who is not a director, and he is attending the meeting. That should not happen. So, one, you have to ensure that no other person has access to those proceedings. Secondly, you also have to ensure that you properly identify the person. Like, maybe the video is blurred and anyone is participating. No, there should be proper identification procedures, and security should be made intact. Okay, so this is done, this is done, right? Thereafter you have to record the proceedings. So whatever mode you are, maybe you are attending through a Zoom call, so Zoom recordings should be prepared, and thereafter they should also be safely kept. Maybe you put that recording in a pen drive, you name it, you label it, you keep it with the records, physical records. Maybe they are going to be kept electronically where you're maintaining, labeling it, right? So they are going to be safely kept also. And okay, this I will tell you. Sometimes there may be a differently able director who is not able to see, so he wants and he needs somebody to accompany him to do that process. So he may request, and the board can allow the same. Fine. Okay. And you have to ensure that everyone is able to hear and see each other, because it is not a lecture or a one-way communication like this. It is going to be a two-way communication, right? So participants, all the board of directors should be clearly able to see and hear each other throughout the meeting. Fine. Okay. Now when I talk about the procedure, first thing is you're sending notice to all the directors. In the notice, you clearly specify that you also have an option to participate through AV means. Now, whoever director is interested to participate through AV means will give his intimation in advance that yes, I will be willing to participate through VC or AV, right? Okay. Now, the board meeting, when the board meeting is conducted, maybe there are 5 directors in the company, 2 have participated through VC and 2 have participated through physical, and the quorum required, let's say fictitiously in this particular case, is 3 directors, so only 2 have come physically but 2 are also participating through VC. So is quorum met? Quorum is the minimum number of directors needed to validly convene a meeting. Is quorum met? Yes, because the directors who are participating through electronic mode are also a part of quorum. Okay. So chairman will ensure the quorum. Thereafter, there will be a roll call. Roll call is as good as taking of attendance. So director have to state that yes, my name is this, I am attending from this particular location, I have got the agenda, no other person is attending beside me, etc. Fine. So that is what roll call takes place. Fine. Okay, so after that, there will be discussions, deliberations, identification before speaking, there will be voting, and after every agenda, the chairperson will announce the summary that, okay, this was the agenda, this is what we have resolved, these are the directors who have dissented, who have not agreed, and have voted against the resolution. When the chairperson is announcing that, there would be somebody, preferably the company secretary, who is noting the minutes, right? So the draft of minutes is being generated. Once the meeting gets over, the draft is going to be circulated to during also it is going to be circulated to all the directors, and they confirm. So it is circulated within 15 days. They confirm the accuracy. If they do not reply, they have to reply within 7 days. If they reply within 7 days, great. If they do not reply, it's going to be deemed approval. And thereafter, the minutes are entered in the minutes book and signed by the chairperson. So that is how uh, the entire procedure is. Okay. Next, we move to section 173(3). This is all about notice. So here starts the process of meeting, pre, during, and post. So pre, before the meeting. There is no particular format which has been specified. It has only been said that you need at least 7 days notice in writing. Oral notice is not going to be sufficient, and it has to be sent to every director. Every director means every director. No matter whether the director is interested, no matter whether the director is alternate, additional, he has himself said that I don't want the notice, still notice has to be sent to every director. How can it be sent? By hand delivery, by post, at the address which is provided, which is registered with the company. Electronic means maybe email which is registered with the company. Okay, it is going to be sent, and if the company fails to give notice as it is supposed to, and you conduct the meeting, it's going to be void. Even if the failure is accidental, then also it is going to be void, apart from the fine that is already applicable. Now, sometimes it may so happen that the company you want to discuss something very urgently and you can't wait till 7 days. I mean, today I will send the notice, I have to wait for 7 days and then only I can conduct the board meeting. We don't have that much time. Now, if you don't have that much time, what can probably be done is send a shorter notice. Ma'am, is that allowed? Yes, it is allowed. However, in that, when you send that shorter notice, please ensure that at least one independent director is present in the board meeting, just to ensure that yes, there is transparency and no fraud taking place in the company. If at all the independent director cannot be present, then the decision is going to be circulated to all the directors, and at least one independent director will ratify it, will accept it, that yes, it's fine, I agree. It has to be in written, it has to be in writing. Okay, then it's going to be valid, otherwise it's not going to be valid. Okay, next we move to section 174, which talks about quorum. Now, what is quorum? I already told you, quorum is the minimum number of directors which are needed, because it is a collective decision and has to be collective. Let's say there are 5 directors in a company and just 2 maybe there are 15 directors in a company and just 2 directors walk in and they decide something. Do you think the decisions are going to be good enough? No. Why are there 15 directors in the company? Just because the company needs 15 directors, right? So the decisions should also be collective. And that is why quorum is the minimum needed. What is that? 1/3 of total strength or 2 directors, whichever is higher. So if I say there are 15 directors in a company, 1/3 of 15 is 5. 5 or 2, whichever is higher, is 5. So in this case, the quorum will be 5. So at least 5 directors have to come and have to be present either physically or through AV, then only it is going to be a valid quorum. Now, whatever fraction comes, that is going to be rounded off to 1. Is that clear? Okay. Now, what if the quorum is not present, ma'am? If the quorum is not present, then it is going to be adjourned. Adjourned according to the articles. If articles don't say anything, adjourn to the same day, same time, same place next week. At the adjourned meeting also, if the quorum is not present, then the meeting is going to stand cancelled. Unlike general meetings, in the general meeting, the present members constitute quorum, but not in the board meeting. If at the adjourned meeting the quorum is not present, the meeting is cancelled. Fine. Again, you have to send a notice again, then you will call it. Okay. Fine, ma'am. Now, there are certain cases when there are many interested directors. Ma'am, what about interested directors? And what is interested director? Interested director is somebody who is interested in the contract, which is going to be taken up as an agenda in the board meeting. Like maybe I am director of this company and you want to appoint my brother as another director. Now, if I vote, I will of course vote in favor, or maybe I will have some biasness, right? That is why I am being told not to vote. You are entering into a contract with a company of whom I hold 60% of shares. So, of course, I will be interested. And of course, I will think from that perspective also. So, I may not give an independent opinion here because I'm also inclined towards the other party. Right, so I am interested in a contract, and whenever you are interested in any contract or arrangement, you have to refrain yourself. You cannot participate in that meeting, you cannot vote in that meeting. Now, this does not apply to private companies. Private companies, if you give the proper disclosure that yes, I am interested, you can participate, you can vote. But in other companies, that is in public companies, you can't. Okay, ma'am. But sometimes there again becomes a problem. Like what? There are, let's say, total 9 directors in a company, out of which 7 are interested. Now, if there are 9 directors, 1/3 of 9 is 3. 3 or 2, whichever is higher. That is going to be the quorum. So, 3 is the quorum. There are 9 directors and 3 is the quorum, and 7 are interested. So 7 interested directors, you can't participate and vote. We are left with only 2. But the minimum quorum is 3. How can this happen? So if this is a situation, that is whenever interested directors at any time exceed or is equal to 2/3 of the total strength, then quorum shall be the number of disinterested directors or 2, whichever is higher. So here we have disinterested also 2 and 2. So if minimum 2 directors also attend, that is going to constitute the quorum. Fine. Okay. Section 8 company, you have a different quorum. Quorum is lesser of 25% of strength or 8, but it has to be minimum 2. Next, we move to section 175. Section 175, before we actually go on to section 175, we also have certain matters which are stated in secretarial standards. Like what? Is agenda necessary for all the board meetings? The answer is no. Section or Companies Act never says that agenda is mandatory and you need to send the agenda. Like when I talk about the notice of general meeting, I need to send the notice and I also need to send the explanatory statement, tell what matters, etc., etc. But when I talk about board meeting, agenda is not mandatory. What are we going to discuss in the meeting? That is not mandatory to be sent. Yes, that is not mandatory to be sent, but as a part of good secretarial practice, it should be sent and it is recommended to be sent. Okay, fine. Can board meeting be held on a national holiday? Now, this is a debatable thing. Why? Although it's very simple, but because the institute has written something like that, it becomes debatable and students are always in apprehension that, ma'am, what exactly the point is. So let me tell you very clearly, board meeting can be held on any day. Sunday, holiday, national holiday, at any time, during business hours, beyond business hours, any place, in India, outside India, any place. Got it? That is the level of flexibility which the board meeting has got. But then, ma'am, when we look at the secretarial standards, we also get to know one thing, that an adjourned board meeting can't be held on a national holiday. National holiday means what? 26th January, 15th August, Gandhi Jayanti, etc., etc. Right? So an adjourned board meeting can't be held on a national holiday. Having said that, the institute in its material has simply stated that a board meeting cannot be convened on a national holiday. So that is why, for exam purpose, if such type of question comes and exam, you may take up this particular view that okay, board meeting can't be held on a national holiday, but deep down you have to understand that it is meant only for adjourned national holiday. It is only meant for adjourned board meeting. Okay, now let's come to section 175. What is section 175? Whenever board has to take decisions, it can take in two ways: at board meeting or through circulation. What is at board meeting and through circulation, ma'am? See, board, you have an agenda, whether you should give loan or not, etc., etc. Or let me not take the example of loan, because we all know that section 179 says that this can be done only at a board meeting. Let me take any example. You have to enter into a contract. You have to discuss it with the directors and resolve whether you should enter into this contract or not. There are two ways to do this. One is call the board meeting, all of them will come, attend physically or virtually, and then you decide. Or else draft a resolution, send it to all the directors, and they will accord their assent or dissent. Yes, we should, no, we shouldn't. If the majority gives the assent, the resolution is deemed to be passed. That is resolution by circulation. Now, it is not allowed for all matters under Companies Act. There are many matters for which have been clearly specified that this can be taken up only at a board meeting where you need a lot of discussions, etc. So, we have section 179, which clearly tells us that these matters are going to be taken at board meeting only. We have other sections also, like section 161(4), where the casual vacancy can be filled by the board, but at board meeting only. We have something called as political contributions, etc., etc. So we have many sections which have been specified that they cannot be implemented through passing the resolution by circulation. Clear? Now, what is the procedure? What is the requirement? You draft a resolution along with the necessary papers. You send it to all the directors by hand delivery, post, or email at the address registered with the company. If you get the approval by the majority in the subsequent board meeting, you are going to note it and include it in the minutes. Right? Now, many a times it may so happen that there are directors who say that no, I want to discuss so much in this matter with my directors. So just you have sent me a resolution by mail. I just have to say yes or no. No, I want to convince other directors. This is such a beautiful opportunity. We must go for it. And I've seen this, I know this, I know that, right? So he has so much to discuss with other directors. So he wants an opportunity that no, please don't take this up through circulation, hold a board meeting, and I want to discuss it with other directors. Can he do so? No, no, because he's just an individual director. Maybe if the company has just 3 directors, he can do so. At least 1/3 of directors, if they want that the resolution should be taken at board meeting, then chairman will cancel this and call for a board meeting, and then that agenda will be taken up at board meeting only. Okay. We also have standards, secretarial standards. The annexure to it says, SS1, the annexure to it says that there are certain matters which cannot be taken for passing resolution by circulation. Now it has all the matters which have been specified in section 179. General items like whenever you want to approve financials, you want to check what laws are applicable to the company, you want to appoint secretarial auditor, internal auditor, then all the matters of section 179 like borrow, invest, grant, making calls on shareholders, buyback, approving remuneration of MD, WTD manager, right? Making political contributions. And then you also have amalgamation, takeover, merger, issue of securities, approving budget. So there are many things which can't be taken up through circulation. Fine? Okay. Thereafter, once the meeting gets over, the resolution is passed. We also have sections 118 and 119, which talks about minutes of meeting. Now, although this is not the section which is a part of ideally CMA final syllabus, it is actually a part of inter, but because in board meeting also once the meeting ends, the minutes have to be prepared, they have been reproduced in our syllabus, right? What are minutes? Correct, fair summary of what happened in the meeting, right? And it has to be prepared. Okay, ma'am. So when it is prepared, there are certain things which you include. Which directors attended the board meeting? Which directors have not agreed, have dissented on a particular resolution? Chairman, you could see that if there is any matter which is defamatory, irrelevant, or detrimental to the interest of the company, you may not include that. Minutes are kept properly and they serve as an evidence, and they can also be inspected. But minutes of board meeting can't be inspected. What are you saying, ma'am? Yes. Because in board meeting, you have discussed something very confidential. You have prepared a summary of it, and all the members are coming and evaluating it and inspecting it, and then the information is all leaked. No. So, minutes of general meeting can be inspected by the members, but minutes of board meeting, they can't be inspected. Okay? So, keep this in mind. Now, section 177, audit committee. Section 176, not a part of syllabus, but still it's clearly written. And I have told you this. Now, I'm not going to tell again in the revision class. Audit committee, section 177. What is audit committee? Committee is what? Nothing but a group of directors, right? What are they going to do? They are going to look at certain functions with respect to audit, with respect to examination, with respect to checking of internal controls, with respect to ensuring that everything is in order, with respect to examining the financial statements, recommending who should be appointed as the auditor, whether it's secretarial auditor, internal auditor, stat auditor, whatever it is, right? Dealing with the auditors, checking their report, etc., etc. Ma'am, all these things can be done by the board. Yes, prima facie, they are done by the board only. The board, you decide, okay, this auditor should be appointed. So you go ahead and talk to that auditor. Everything falls into place. You recommend that auditor and appoint it. The members pass an resolution and they appoint it. That is what happens. But when the company grows, you need to delegate things. Everything you cannot do. You have so much to do. You have so many things to discuss. So instead, what you do, you form different committees. Now, they are nothing but a directors who have maybe expert knowledge about finances and audit and all of that. So they are better ones. They understand it better. They can do that feasibility study. They can analyze. They can look. They can do everything, and they can always come and recommend and report to the board because they are working under the board only, right? So there are only big companies which are required to constitute audit committee. What are those big companies? All the listed public companies and the same companies which are required to appoint independent director, like paid up capital of 10 crores or more, turnover of 100 crores or more, or loans more than 50 crore. So you will constitute an audit committee which will have at least 3 directors, out of which majority has to be independent. So if there are 4 directors in an audit committee, 3 are going to be independent. 3 are going to be independent. Fine. Now, what does this audit committee do? The functions or the duties, right? This is important. This is not important. What are the functions of audit committee? They are going to recommend. Ultimate decision is of the board only. The board may also disagree with the recommendation of audit committee. So the board or audit committee are not deciding that this is going to be the auditor. No, you're only recommending. Recommend what? The appointment, the remuneration of auditors. Fine. Review the auditor's performance, examine the financial statements before it is handed over to the, before it is signed or adopted by the board. And also, once the audit report is prepared, that also is going to be reviewed by you first, then it is going to be presented to the board, right? Okay, you scrutinize certain loans, you also approve the related party transactions, then you value undertakings whenever necessary, then you evaluate the internal financial controls, you monitor the use of funds which have been raised through the public, that are they put to good use or not, correct use or not. Okay, now when I have said you approve related party transactions, what are they? You have section 184, you have section 188, you have section 177. These are the 3 sections where you talk about this, where you relate to this. What are they? Section 188 tells us what are related party transactions, not exactly. Then you have section 2 clause 76 which tells us what is a related party. What is a related party, which clearly says that, okay, we have a director, we have the relative of director, we have KMP, we have the relative of KMP, holding, subsidiary, associate, etc., etc. They're all related party to the company. Now, company, when you enter into 7 specified transactions under section 188, you need approval. What approval? Approval of audit committee, or you can say board, and if it exceeds the limit, you also need the approval from the members. Okay? Okay? That is the approval that you need for related party transactions. That means maybe the company is selling its goods to the directors. To the directors. Now there are arm's length price, etc., etc. That we get to section 188, then we will understand and realize. Then in that case, section 188(1) is not applicable at all. Okay, so if you're selling your goods to your director, then you can't sell it without any approval. You need audit committee's approval. Okay, if it is not covered in section 188, you audit committee only gives the recommendation. Fine, otherwise you need approval. Okay, now if the amount is 1 crore or lesser, you may not take approval. If you do not take approval, then it can be ratified within 3 months, and it's going to be otherwise it's going to be voidable at the option of audit committee. Audit committee may accept it or may rescind it. Fine. Now there is something more that I want to tell you, but before that, okay, Both report, you have to disclose this, and if you contravene, this is going to be the penalty. Now, we also have something called as omnibus approval for related party transactions. What is omnibus approval? Omnibus approval is like a one-time approval for a series of transactions. So there's a company, and this is director's brother. Director's brother has a building which he has given on lease to the company. So every month, company has to pay a lease rental of 2 lakhs or 5 lakhs, whatever it is, to this director's relative. So it is a related party transaction, and it needs approval of audit committee. Now, every month they are coming, and every month they are seeking the approval. It is wasting the time of the party, wasting the time of the director concerned, wasting the time of the audit committee, because it's a recurring thing which is happening. So for such type of transactions, what can happen is you take a one-time approval for all the transactions for maximum 1 year. After 1 year, again, you have to take that approval. And it's not allowed for selling undertaking of the company. You can't take that omnibus approval for selling undertaking. Okay. So, based on the repetitiveness and justification, how justified it is to give omnibus approval and how repetitive nature it is, audit committee can give omnibus approval for related party transaction and may impose the conditions on the same. Now, before that, they will always specify the criteria. If you fit in that criteria, you can go and ask for omnibus approval. What is the criteria? That maximum value during financial year, maximum value per transaction, what disclosure has to be made, what transactions are not permitted, how frequently it's going to be reviewed, intervals and all that, right? So that criteria will be specified. Based on that criteria, you can approach and you can get that approval. And what is the disclosure that needs to be made? The name of related party, nature and maximum amount of transaction, base price, other info, etc. Okay. So I hope this is clear. Fine. Now section 177 is not yet over. We also have something called as vigil mechanism. Now, the companies which are required to constitute audit committee are not the companies which are also required to have vigil mechanism. It is entirely different. Vigil mechanism is for preventing the ones who raise their voices. It is giving them safeguards against victimization. If I know somebody, maybe my manager is indulged in a fraud, I will be always afraid to report. Why? Because I cannot report. I don't have any good reporting channel. If I have to take any complaint, I have to go to my manager only. So if I'm going to my manager and telling him, see, you are involved in a fraud, he's going to immediately demote me, fire me, or plot against me and throw me out. Right? So I am scared. So I will be silent. And that is why such type of genuine concerns will not be reported in a company, and company can't function better. Now, in the listed companies, in companies which have public deposits, because a lot of public money is involved over here, and a company which has borrowed money from banks or PFI in excess of 50 crores. Again, a lot of public money is only there, because in banks also you have public money only, right? So in such type of companies, it is mandatory to establish a vigil mechanism. Vigil mechanism is nothing but a system, but a setup. Setup where if I am an employee and I want to report a genuine concern, I should have a direct access to the chairperson of audit committee. I should have a channel through which I can report anonymous complaints or direct complaints, whatever it is, and action should be taken. If action is not taken, I should not have to go to my manager, but I can directly walk into that particular person. I should have that access, right? Or whoever is overseeing that vigil mechanism, because if the company has audit committee, then audit committee is going to look after that vigil mechanism. If the company does not have audit committee but is required to form a vigil mechanism, then any director who is nominated is going to look at the vigil mechanism. Okay, fine, clear? Next, we come to section 178, which talks about NRC and SRC. Again, two committees. NRC, which companies are required to form NRC? Same. Listed public company and the companies which are required to appoint independent director, the companies which are required to constitute audit committee, the same companies also required to constitute NRC. So if you fulfill that criteria, there are 3 things that comes applicable to you straight away. Okay. Fine. This is clear? Okay. Now NRC, what are you going to do? And what is going to be your composition? You have to have minimum 3 directors, and they are going to be non-executive only. There is no such requirement in audit committee. Here 3 or more non-executive directors, and half have to be independent directors. So here we have lesser serious requirement in comparison to audit committee when it comes to independent directors. So if we talk that, okay, let's have 4 directors in NRC, at least 2 have to be independent. But in audit committee, if we have 4 directors in audit committee, then at least 3 have to be independent, because there it was written majority, here it's written half. Okay. Whoever is the chairperson of the company, despite being an executive director, he can be a part of NRC, but he can't chair the NRC. What NRC does? NRC, Nomination and Remuneration Committee. So you have to look at who should be appointed and what should he be paid. Again, you will be recommending to the board, because you're still operating under the board. So you identify the persons who can become directors or who can be a part of senior management. You evaluate how the board is functioning, how the committees are functioning, how the directors are functioning, right? You also tell who should be removed, who should be appointed. You formulate that entire criteria of that what should we see in an independent director, right? The policy, the remuneration policy. So you help in that formulation. Okay, so you recommend that. All that has to be taken care of. Next is stakeholders relationship committee. Stakeholders relationship committee is entirely different. The more number of people you have, the more number of complaints will be generated. So you have to understand that if there is a teacher who caters to only 5-10 students, right? Only 5-10 students, then you don't need a separate team or anything like that. Maybe somebody's system has crashed, maybe the software is not working, so you connect, and only one person will be able to help all these 5, 7, 8 whatever students are there. But if this comes to 800, if this comes to 8,000, then the problem strikes. One person can't serve. Now you need an entire dedicated team to help them on these technical grounds, to maybe help them on certain other grounds, right? So as it grows, you need more people. So if the company has more than, if the company has more than 1,000 stakeholders, means shareholders, debenture holders, deposit holders, bond holders, everyone collectively, at any time during a financial year, not just at year end, but at any time during financial year, then you also need to constitute SRC, because they might have n number of complaints. I have not got my dividend, I have not got my share certificate, my transfer is not taking place, etc., etc. To all these problems that they have, that has to be resolved. So to resolve these grievances of the security holders, you need a SRC. Okay. SRC. Now, what is going to be the composition of SRC? There is no composition which has been specified. It's only stated that the chairperson will be non-executive director and such other members as needed. Okay. Fine. Next, we move to section 179. Section 179. Now, this section tells us what board can do, what is the power of the board, right? So, prima facie, board can do everything which company can do. Like, we have a memorandum of association, and in the object clause, it is written that company can enter into construction contracts. So, board, you can enter into construction contracts. Under Companies Act, it is written that a company may alter its articles. So, board, you can alter your articles. Correct? Correct. So basically, within, like, board can exercise the powers, but obviously it has to keep in mind, or these powers are subject to Companies Act, Memorandum, articles, or maybe any regulation which is set on general meeting. Right? Yes, ma'am, correct. So that is what exactly a company can also do basically. But then, as you said, alter its articles just by passing board resolution, the articles can't be altered. For altering the articles, basically you need to pass special resolution. And when I say special resolution, that means it is the power which the members have. Correct. So basically, board, you can do everything which a company can do subject to these other than the powers which have been reserved for the members to be exercised in general meeting only. Apart from this, undoubtedly, you can do everything. And when I say you can do everything, it means that you can do it at a board meeting or through resolution, as we have read in section 175. However, section 179(3) tells us that there are certain powers which are going to be exercised only and only at board meeting. What are those powers? What are those matters? If you want to make a call on shareholders, right, you want to get the call money from the shareholders, that is something which is not going to be done, that is not something which is going to be resolved through circulation. Okay, so calls on shares, buyback, issue of securities, borrow, invest, grant, that is borrow money, invest funds, grant loan, security, guarantee, approve the financial statements, diversification, amalgamation, takeover, and then we have other matters as prescribed, in which we get 3 more points, that is to make political contributions, to appoint or remove KMP, and to appoint the auditors, that is secretarial and internal auditor. So if you want to do any of these, you have to call a board meeting, because these are the matters which require more discussions. Okay. Now, out of these are the 3 powers, that is borrowing of money, investment of funds, and giving of loans, can be delegated. Delegated to whom? Maybe committee of directors, maybe MD, maybe manager, maybe any other principal officer of the company or of the branch, whatever the case be. Right? So these are the 3 powers which can be delegated to them also. Okay, I hope that's clear. Fine. Now we come to section 180. Now 180, 179 has given the power, and 180 comes just running behind it and says, stop. Your power is restricted. You have the power to borrow money, but you can borrow only up to this amount. Beyond this, if you want to borrow, you need to go to the members and take their permission. Fine. So there are 4 things which have been specified which require special resolution. Okay, what are those 4 things? First is selling or disposing undertaking of the company. Either whole undertaking or substantially the whole undertaking. Now, what do we call as undertaking? Maybe I've just started a venture and I have spent 1 lakh rupees on this particular venture. It has not generated any revenue, and now I want to sell it off. Do I need to pass special resolution for this? The answer is no. That's not even an undertaking. So, what is an undertaking? Undertaking means either you have invested more than 20% of your net worth, or that undertaking is generating 20% or more of the income. So if it satisfies any of the 2 criteria, then that is going to be called as investment. That is going to be called as undertaking. Now, if I want to sell this entire undertaking, then I need SR. If I want to sell substantially this undertaking, that means 20% or more of this undertaking, then also I need SR. Clear? So that's the first point. Moving to the second point. If I want to invest, if the company, I means the company right now, okay, so if the company wants to invest the compensation that they have received on merger, now basically I've explained you this in the class, whatever money we are receiving on amalgamation that belongs to the shareholders, it cannot be invested anywhere without their approval, right? So it has to be, it can be invested in like the trust securities like post office, bank, and all that. Otherwise, no. Third, borrowing. You can borrow. Undoubtedly, under section 179, you also have the power to borrow. So this borrowing you can exercise only at board meeting, fine. But then, if this borrowing, the amount that you've already borrowed plus the proposed borrowing. Now, when I say this borrowing, then it is not including the temporary loans. Temporary loans means your loans which are repayable or demand or within 6 months, that is the short term loans, or maybe like the cash credit, CC, discounting of bills, etc. All that is not included. All this is not a part of the loans. So whatever amount you have already borrowed plus what you're proposing to borrow, if that exceeds paid up capital plus securities premium plus free reserves, then you need SR. If it is not exceeding or within that limit, then BR at BM is going to be sufficient. The last one. If you give time to your director, if you extend the repayment of loan time to your director or remit the loan given to the director, then you have to pass SR. So maybe you have given loan to a director and that director is asking for more extension of time, and we can't give loan to a director as it is prohibited under section 185, correct? But under certain schemes and all that you can give, right? That falls as an exception also. So if they want the extension time, or if there is any debt which is due from a director, any debt which is due from a director, then with respect to that, if they want any extension, maybe it's in pursuance of any related party contract, etc., whatever it is, then that SR will be needed. Okay. Now, when you pass SR for this, you will also specify that you are giving the power to the board to borrow up to 5 lakhs. So the amount has to be clearly specified. If the amount is not specified, that SR is going to be void. Okay, clear? Next, we move to section 182, political contributions. Now, company, you are allowed to make political contributions, but if you're a government company, you're not allowed. And if you're a company which is in existence for less than 3 years, then also you're not allowed. Otherwise, you're allowed. You have to pass a resolution at board meeting only. You can give the political contribution through check, draft, ECS, or other specified instrument, right? You can give it directly or indirectly, but you have to disclose it in P&L account. And two things are also going to be deemed as political contribution. One is when you give any donation to somebody who's not a political party, but that somebody is doing something which is affecting the public support for a political party. So he's doing something in favor of a political party. So that is an indirect contribution only, and it's going to be deemed as political contribution only. Secondly, when you are maybe giving an advertisement, etc., right? So that is also going to be political contribution only. Next, we come to section 184. That is disclosure of interest by a director. Now, I already told you this, although, but I will just repeat myself. I am a director of this company, or I'm going to be a director of this company. I may also be a director of this company. I may hold shares of this company. I may be a partner in this firm. So, all the other business connections that I have, I'm not talking about the relatives, all the business connections that I have to disclose it. I have to tell the company that these are the business connections that I have. When will I tell that? In the first meeting of the board in which I'm participating. In the first board meeting of every year, whenever there is a change. So I will disclose my interest in any company, any body corporate, any firm, any association of individuals, etc. My shareholding, my partnership, whatever it is. So I am going to disclose this. Fine. In MBP 1. I hope that's clear. Now there is something called as specific disclosure also. Specific disclosure means the company you are entering into a contract with another company, and this company I have the shares or something like that, right? So I'm interested in this contract. I'm interested in this contract, I have to give another disclosure. And I will not participate in the board meeting in which this contract is being discussed, and I will not vote on this matter. Got it? Because I become interested. If I do not disclose, if I participate, if I vote, it's going to be voidable at the option of the company. Because the company has every right to know that I was interested in this particular contract. Fine. Okay. Now, nothing applies where the shareholding is not more than 2%. Okay. Now, one thing. Whenever I'm talking about any contract or arrangement, see, company, you enter into a contract or arrangement with this, and you are the director of the company, and you hold more than 2% of paid up capital, or your promoter, manager, or owner, I should say, promoter. Yeah, you can say you are a promoter, manager, CEO of that body corporate, or maybe the company is entering into a contract with a firm and the director is a partner, owner, or member. So, in this situation, you have to disclose and you will not participate. Clear? Next, we come to section 185, loan to directors. Loan to directors. Prima facie, what is the situation? That company, you are prohibited. You cannot directly or indirectly give loan, guarantee, or security. Now, when we are starting this particular section, we will also read section 186, where we will be talking about LGSI. What is LGSI? We have loan, we have guarantee, we have security, and we have investment, right? Now, investment we read only in section 186, but loan, guarantee, and security to the directors or some related entities is what we read in section 185, and to others we read in section 186, right? So, company, if you are giving loan, guarantee, or security to the director, or the director of holding company, or the relative of such director, or partner of such director, or a firm in which such director or relative is a partner, then that's complete prohibition. That's complete prohibition. But you are permitted to give loan, guarantee, or security to any private company in which your director is a director or member. Okay, any body corporate whose board acts according to the director of the company, any body corporate in which the director holds more than or equal to 25% of voting power. You can do this. You can give LGS to these if if SR is passed. If SR is passed, and whatever money you are advancing is not going to be invested, or likewise it is going to be utilized for the principal business activities only. How do you pass SR? The notice is sent along with the explanatory statement. So, in the explanatory statement, there will be clearly the details are going to be mentioned, and thereafter SR is passed. Fine. Now, company, if you are a government company and undoubtedly you get the approvals from ministry, CG, then it's not applicable to you. That means you can go ahead and give the loan to your directors if you want to. Also, if you're a private company and no body corporate has invested in you, your borrowings are lesser than lower of 2 times of paid up capital of 50 crores, you have not done any default in repayment of borrowings, then again, this is not applicable to you. You are exempted from this particular section, section 185. Fine. So, through MCA circular, we have a non-applicability. Now, there is one more thing in general that is this. Company, if you want to give loan to your directors, you can. How can you give that? If you are giving loan to your MD or WTD, not to your independent directors or part-time directors, MD or WTD, because they are like employees only. So, as a part of same conditions of service as you extend to the other employees, like if you're working in my company, you are eligible to take like this much loan in this conditions. I'm extending it to all the employees, so am I extending it to you also. So, that's allowed. Secondly, if there is a scheme which has been approved by SR, so through that scheme, if anyone is taking that loan, that is allowed. Thirdly, if I'm a banking company If I'm a banking company and in the ordinary course of business, I'm only lending loans. So you are also one of the persons and you take that loan. However, the rate of interest, although a bank can give their own employees a loan at a reduced rate of interest, still the rate of interest should be more than or equal to the government security yield. At least it cannot be lesser than that. Fine. If the loan is made by holding company to its wholly owned subsidiary for business, fine. Or if you are giving a guarantee or security by the holding to its subsidiary, guarantee or security by holding to subsidiary, loan by holding to wholly owned subsidiary. Fine, that is also allowed. So non-applicability on these four things, this particular section is not applicable. Moving to the next section, section 186, LGSI. Before that, we have a small thing which we have already although discussed when we were discussing about the definition of subsidiary company, that you can't have more than 2 layers of subsidiaries. Now this here, they talk specifically about the investment company. So company, you can make investment, but in maximum 2 layers of investment companies. This is not applicable to banking company, insurance company, wholly owned subsidiary is not counted, NBFC with net worth of more than 500 crore, government company, not applicable. Fine. Okay. Now we come to LGSI. So loan to any person or body corporate, undoubtedly other than the directors, because directors we have already read in section 185 and that's already covered, right? Okay. Then guarantee to any person, security to any person with respect to the loan, of course, investment in the body corporate. Whatever you are doing will require UBR. UBR means what? UBR means if there are 5 directors in the company and 4 directors attend the meeting, all 4 have to give consent. It can also happen that, okay, one is not voting, maybe 2 have voted in favor, etc., etc. No, all 4. So consent of all the directors present in the meeting is called as UBR, unanimous board resolution. That's needed. Okay, that's needed. Now this LGSI has a limit. LGSI has a limit. If you make the LGSI proposed plus existing and it does not exceed the limit, then fine. UBR is sufficient. You don't need any members' approval. But if it exceeds the limit, then you also need SR. What is the limit? Higher of 60% of paid up capital plus free reserves plus securities premium, or 100% of free reserves plus securities premium. So whatever is higher, that is the limit. If it is exceeding the limit, then you also need SR. Otherwise, UBR is sufficient. Okay. Now, when you are actually passing a unanimous board resolution, then undoubtedly you have to give notice to the members and they are going to come. Whoever comes, everyone has to vote. If the LGSI limit is exceeding, then again UBR has to be passed. You cannot do away with the UBR. After UBR, you also need members' approval through SR. Now, there is one more thing which we called as PFI approval. PFI approval means the company has taken loan from any bank or PFI, right? You need their approval also if the limit exceeds. If the limit does not exceed, then you don't need their approval unless you have done a default in repayment. Okay. So if the limit does not exceed, SR not required, and no default in payment, approval of PFI also not required. Otherwise, you need PFI's approval. Clear? Whatever loan you will be giving, you have to ensure that the rate of interest on loan, maybe you are giving a loan to your another other company. Okay. The prevailing yield cannot be lesser than the prevailing yield of government security. It has to be either equal or more than that. Fine. You will disclose all the details in the financial statements, and there are certain exceptions which we have already discussed. There is going to be a register which is going to be maintained and kept at the registered office, which is also going to be open for inspection. Okay. So I hope this is clear. Next, we move to section 187, which is a very small section, I would say, which talks about investment of companies in its own name. So company, if you have any security, if you have any property, if you have any asset, that is going to be in your own name. It cannot be in any other person's name. Like if I'm staying in a house, it can be in the name of my father also, right? But company, if you own an asset, it has to be in your name only. But this company is my wholly owned subsidiary. That means all the shares are held by me. Yes, then only it will be wholly owned subsidiary. But can all the shares be in my name? All the shares are held by me, that's fine. But can all the shares be in my name? If all the shares are in my name, that means this company has just one shareholder. And if it's a public company, by Companies Act law, there have to be minimum 7 members. So this would be contravention of law. But you can make your wholly owned subsidiary. That means you can own all the shares of a company. Yes? Yes, ma'am. So what do? Now, the company, you will hold all the shares, but through the nominee. So you will appoint 6 other people, give them 1 share each, just for the name's sake. These are your shares. You know it. The company knows it. Everyone knows it. You are getting all the benefits, everything. You have an agreement. Just they're holding the shares in their name. So they're nominees. That is allowed. So if it is necessary to do so, that is allowed. There are 4 more exceptions, I would say. If I am giving my share certificates to the bank that, okay, on behalf of me, you collect the dividend, you collect the interest, etc., it's allowed. If I transfer the shares to SBI or maybe any scheduled bank, why have I done that? Because they are going to facilitate the transfer, right? Many a times I want to sell my investments and I don't have that platform, so I'm giving it to the bank, I'm transferring it to their name just to smooth the process. And if it's done within 6 months, great. If it's not done within 6 months, I will retransfer it. So that is also allowed. If I am giving it as a security to the bank because I've taken loan from the bank, it is allowed. If my deposits, my investments are in the name of the depository, undoubtedly if the shares are in demat form, that is how it will be. So that is again allowed. Okay, and here we move to the last section of this particular chapter, that is in your syllabus, I would say, because there are many other sections which I have very quickly told you, but that we're not going to revise here. Okay, now section 188, that is related party transactions. First of all, what is related party? What is related party? Director, their relative, KMP, their relative, firm in which director or manager is relative. Then you have a private company in which the director or manager is a relative or is a director, right? Relative is a member or a director. Then you have a public company in which the director or manager is the director and holds more than 2% of paid up share capital. Then any body corporate who's acting according to you or you are acting according to that person. Then you holding, subsidiary of holding, investing, right? And other as prescribed. That is going to be called as a related party. Fine. Now, if you are doing any transaction with a related party, other than at arm's length price, because if you're doing it at arm's length price and in the ordinary course of business, like I am the director of an airlines company and I'm booking a normal flight just like any other customer would, then that's not a related party transaction. To that transaction, section 188 is not applicable. Fine. So other than at arm's length price, if the company is entering into any contract or arrangement with a related party, then you need a resolution at board meeting. If it doesn't exceed limit, no OR is needed. If it exceeds the limit, then you also need ordinary resolution at general meeting. Fine. So board meeting, the resolution is mandatory. Ma'am, is it for all the transactions? No. there are 7 specified transactions in section 188 to which you need this. Otherwise, if the company is entering into a related party transaction other than these 7 specified transactions, no approval is needed. Fine. What are those 7 specified transactions? Sale or purchase of goods or materials, buying or selling of disposing of property, leasing of any property, availing or rendering of services, then buying or selling through agent. That is also one point. Then you have appointment at OPP, then underwriting of securities. Now they all have been specified a limit. Sale or purchase of goods or material, 10% of turnover. So if it is 10% or more, then you need OR. If it is less than 10%, you don't need OR. All you need is a board resolution. Fine. Likewise, we have 10% of net worth, 10% of turnover, 10% of turnover if it exceeds 2.5 lakhs and if it exceeds 1% of net worth. So approval is needed in all these cases. Approval of members is needed in all these cases. Otherwise, board resolution is going to be sufficient. Fine. So basically, if you're entering into a related party transaction, company, you're entering into a related party transaction, and that is one of the transactions specified in section 7, in section 188, then you will see if it exceeds limit or if it does not exceed limit. If it is not exceeding limit, you will call the board meeting because the resolution has to be passed at board meeting only. How do you call the board meeting? By sending notice. Along with this notice, the agenda will be sent, which will clearly specify what is the related party, the nature of relationship, what is the terms of contract, right, the price, any advance received or advance paid, how did you end up to the commercials, all factors have been considered or not, etc., etc. The directors will come. Interested directors will not participate. In private company, they can participate. Right? So interested directors will not participate. There will be voting. There will be resolution passed. Now, that is it. But if you exceed the limit, then thereafter you will also send the notice of general meeting along with explanatory statement, which will again specify the name of related party, the director who is involved, the nature of relationship, the terms of contract, the pricing, other information, etc. Now the members will come. There will be voting and all of that, and all you need is an ordinary resolution. All you need is an ordinary resolution. However, again, related party will not vote. If you are a member, you may be a member also. You may be a member also. So again, you will not vote. Related party member will not vote. Again, in private company, he may vote. Fine. And that is how the resolution will be passed. The resolution will be passed. If at all you don't take the necessary approvals you had to, then it is going to be voidable at the option of the board or the members, and it can be ratified within 3 months. Otherwise, it's going to be voidable at the option of the board or shareholders. If there is like maybe there was a director involved and he did not get the necessary approvals, and the transaction has taken place, the contract has been entered into, whatever loss the company is suffering, the director, that concerned director will indemnify. And then you also have the penalty. You also have the exemptions, which I have told you, like it's not applicable to the case of compromise, arrangement, amalgamation, etc. Right? So that's it for the revision of this particular chapter. Thank you. Okay, let's now revise the chapter of inspection, inquiry, and investigation. So this is chapter 14 of Companies Act 2013, starting from section number 206 going till section number 229. Right? Okay. Now, basically, when we start with this particular chapter, we can see, as the heading itself suggests, that it's divided into 3 parts: inspection, inquiry, and investigation. These can be called as 3 escalating stages to discover what is actually going on in a company, or how well the company is performing, are there any irregularities which exist in the company, right? So inspection, inquiry and investigation, if we go by the general meaning, we can understand that inspection is something which is not negative. Like maybe a factory is opened and some safety officer goes to check if everything is in order or not. That is a routine inspection. I'm talking in general parlance and we have not yet started with the chapter, right? If I talk about inquiry, inquiry is something when something bad has happened. Maybe there's an accident which has taken place in a factory, and although everything seems to be okay, but still there is an inquiry just to resolve that doubt, right? So this is something, oh my god, there's an inquiry going to go on. So it is kind of negative unless the clean report is made. An investigation means there is absolutely an allegation, a suspected violation of some law, and is always negative, no matter what the outcome is, right? Okay. Now, that is the general meaning. Now, if we talk about this particular chapter, the initial four sections that we talk about, section 206 till section 209, they actually prima facie talk about the two terms, that is inspection and inquiry. And thereafter, almost the entire chapter is dedicated to investigation. So investigation contains a major chunk of this particular chapter, and inspection and inquiry is very short content and portion. So what is inspection? What is inspection happening? Now here we are obviously talking about all the white collar crimes and all that. We're not talking about and investigating into the real crimes, which of course the criminal procedure applies here also. That also I will tell you, especially when we talk about section 212. But broadly, we are talking about the frauds that we want to discover. We are talking about the mismanagement which might be going on in the company, the irregularities, the misfeasance because of which the company or the people are suffering losses, etc., etc. So we want to discover that. We want to find out the truth. Now, if we talk exactly according to our exam oriented revision, first section is section 206. Section 206 tells us there is a company which might have filed any document, fine, or ROC might have received any information from some other source. The document filed could be any MGD form. Maybe we have just filed the financials with ROC. Based on those financial statements, ROC just went through those documents and analyzed and scrutinized that document, and based on that, they found that here you have written some information, and in the earlier document there was some other information. Maybe they're contradicting each other, maybe there is some issue which needs to be resolved. So they want more information from you. They want more information from you. I have not yet even uttered the word inspection in the sections, right? So ROC, the company filed financials with the ROC. ROC looked at those documents and they want some more information. So they sent a written notice to the company seeking more information or explanation or any further document. Fine. Now they are sending this written notice to whom? They are sending this written notice to whom? That you have to produce such and such document within reasonable time. Fine. They are sending it to the company, and can send it to the officers, the employees. In fact, the past officers and employees will also be liable to respond. Why? Because if the information relates to some previous period, maybe somebody was the director of a company and now he has left the company. He was a director maybe in year 2025 and now he has left the company. Okay, so since he has left the company, will he still be liable to give the information that ROC needs? Yes, he will still be liable if ROC has sent a written notice to them. So they also have to furnish the information or explanation, whatever they know. Okay, so once the company or the officers, the employees, past officers, if they have received the notice within reasonable time that's specified in the notice, they have to reply. Okay, they reply within time, great. They have taken some extension and replied with extended time, okay, still fine. No reply, then this happens. If they have replied and ROC is satisfied, okay, because of that there was a mismatch, okay, fine, we get it, no problem. Right? So ROC is kind of satisfied, there is nothing further done. If ROC is not satisfied, or you have not replied properly, there is an adequate reply, or you have not replied at all, then ROC will record the reasons and give a written order to company for inspection. For inspection. So they are giving another written notice that now you produce all your books, accounts, papers, everything, and now we are going to go for inspection because there is something which is not, the documents are not actually able to satisfy us. Fine. So now the inspection will be conducted. How the inspection will be conducted, that is given in section 207. Okay. So once the inspection will be complete, you have to prepare a report and you have to submit it to central government. The report is submitted under section 208 and you will give the recommendation that we'll see in 208, and CG may also further carry out the investigation. Okay. So far, I hope you're good. So section 206 is not yet complete. We also have to read about inquiry, but section 206 prima facie tells us that when inspection is triggered. Inspection is triggered when ROC, on scrutiny of a document or of the information that they have, asks for more information and the information is not satisfactory or not filed, then ROC may proceed for inspection. That is the hierarchy. Okay, correct? Then we also have something called as inquiry. Inquiry is also there in section 206 only. Now, when can inquiry happen? If ROC has some information with them, or maybe there is any complaint, any representation made by any person, okay, made by any person, that the company is doing some fraud or anything like that, okay, or if the grievances of the investors are not addressed, fine. So in these three situations, any person may give the representation or information to ROC, or ROC may have information available with them only. So based on this, if ROC is satisfied that the business is being done fraudulently, or there is non-compliance of act, or the grievances are not addressed. So in these three situations, if ROC is satisfied, then ROC will inform about the allegations to the company, give them an opportunity of being heard, and thereafter carry out inquiry. Now, who is going to do the inspection and who is going to do the inquiry, right? So it may be done by ROC or it may be done by the inspector appointed. Now, both these cases, inquiry or inspection, ROC may initiate or CG may also say that you have to do this inspection or inquiry as the case may be, and there also the inspector will be appointed and inspection or inquiry shall be carried out. So inspection can be done directly by ROC or by central government. I hope that's clear. So section 206 actually tells us in what situations inspection or inquiry is triggered and can be initiated. Once it is initiated by either ROC or inspector, the next step is how it is going to be conducted. That how is actually given in section 207. Okay, thereafter, once it is conducted, then the report shall be made, and that report is given in 208. You also have the powers of search and seizure, that's actually given in section 209. Fine. Okay. So how it is going to be conducted? Once the order of inspection and inquiry is passed, ROC or inspector, what you will do is you will call for the books and papers, and it is the duty of every director, every officer, every employee that you have to produce whatever document is asked by ROC or inspector in whatever form it is asked. Okay. And of course, give all the assistance that you can in connection with the inspection or inquiry. Fine. If you disobey, then there is imprisonment and or fine. and if orders and everything are followed, then registrar, you have certain powers. Registrar or inspector, you can say, you have certain powers. See, we also read about powers of inspector in section 217, and we also read it in under section 207. Okay, broadly the powers are same which are stated, with slight differences. With slight differences, no, I would say with slight additions. So ROC, what you can do, or inspector, what you can do when you are doing that inspection or inquiry, if nobody is listening to you and you don't have any power, like if I suddenly ask you and start questioning you, if your parents actually question you that where were you might answer that, right? Because you're scared your parents may take a step, they may snatch the phone for you from you, etc., etc. So you're little scared and you will obey them because they have certain powers. But if I am asking you where were you, out of maybe respect you will reply, but otherwise I don't have a power to do anything to you, right? Or to guide you or anything like that, right? So in that perspective you might just walk away, you might not even want to answer, right? But if I also have the power that I may take your phone, I may do this and that, then you will be scared from me also and you will do that, right? In the same manner, if ROC or inspector, if I am the ROC or inspector and carrying out that inspection or inquiry and asking from you the documents, why will you give the documents to me? What if I don't give? What will you do? Well, ROC or inspector has been conferred with the same powers as of a civil court. So, if ROC or inspector has asked you to produce the documents and you do not do, it is as good as disobey of court, and you will be punished as you disobey the order of a civil court. So if you have been summoned, if you have been called by ROC or inspector, consider this as a summon of a civil court. So if you disobey the summon of a civil court, then it has consequences and penalties. Likewise, here also it will be applied because you have been got the same powers as of a civil court in respect of discovery of books, summoning and enforcing attendance, inspection of books, registers, and documents. So, insert, of course, you haven't got all the powers of civil code, but in these matters, you've got the powers of civil code first. Secondly, you can call for the books and copies. Undoubtedly, you can also make copies of the books, and you can also place the identification marks before returning the books in case you have seized them. Even if you have not seized them, then also you can place identification marks. Fine. So these are your powers that you have, which are stated in section 207. And of course, penalty is stated. I'm not dealing with the penalty. Okay. Then we have section 208. Section 208 actually talks about the report. So once your inspection or inquiry is complete, you will prepare a report in writing and give it to central government. Give it to central government. Fine. Now, once you have submitted the report, although it has been delegated to RD, once you have submitted the report, what is the finding of the report? The report may say that this particular person has done something or has committed some fraud, and we recommend that this should be investigated because this might turn out to be serious. It's not very small fraud, it may turn out to be something big, right? So it may include a recommendation if that is needed for further investigation. So of course you will support. Why are you recommending further investigation? So if there is a need to do so, do it. Okay. So that is all about the report. Fine. Now, inspection and inquiry. During that inspection or inquiry, you have a reasonable ground to believe, okay, I am carrying out the inspection and I'm continuously asking for the documents. I have found something. I have found that this particular director has been continuously involved in embezzlement or taking funds of the company, misappropriating the funds of the company. And now I ask for those documents from that director. The director will now be like, oh my God, looks like they have found out and now they're collecting the evidence and the proof. I need to tamper this proof, right? So they may do that. Like they may change it, they may alter it, they may falsify it, they may destroy it, they may mutilate it, they may hide it, right? So if ROC or inspector has reasonable ground to believe that the documents relating to the company, KMP, director, auditor, CS, whatever it is, they're likely to be destroyed or done this way. They may, after obtaining special court's permission, this is very important. Often this is asked that, okay, they entered into the premises and they seized the books without obtaining special court's permission. So often in the case studies, this particular point is incorporated. Even in MCQs, it is asked that whose permission they have to take. So this point is extremely important from exam perspective. So ROC or inspector, you have to take special court's permission, and thereafter you can enter into the places wherever permission you have taken. You enter into the places, search the documents, seize them, that is taken to your custody. Okay, you prepare a list. Ideally, you tell them that these are the documents that we're taking along. The company has every right to take copies of those documents at their cost, and thereafter you can take these documents with you. Once you're done with the checking, you can also place identification marks, but you have to return the documents within 180 days. They can be called for a further period of 180 days if need be, but prima facie it has to be returned within 180 days. Fine. And before returning, again, you can make copies if you want to. Okay. So I hope that's clear. So that is about inspection, inquiry. And now we move to investigation. Now, when I talk about investigation, we have so many sections of investigation. We talk about section 210, investigation into affairs of the company. Then we talk about section 213, where again investigation into affairs only, but through NCLT. Then we have investigation into affairs by SFIO, that we read in section 212. We have investigation into ownership, that's section 216. And we also have investigation into the related entities, that we talk in section 219. So we have these many sections which we talk about investigation and which we have to read, right? So we'll start one by one. First of all, investigation into affairs. So we have prima facie 3 sections of investigation into affairs. One is section 210, second is section 213, and the third one is 212, where the investigation is not done by a normal inspector, but it's handed over to SFIU. Just like there is a crime which has happened, it may be investigated by normal police department, right? It may be handed over to some specialized agencies, maybe CBI and all that, right? If there is something big that's happening or bigger crime that's happening. Likewise, in company frauds, if there are normal frauds or normal investigation that needs to be carried out, it will be done by the inspector who's appointed. Sometimes when the frauds are serious, then it will be assigned to SFIU, that is serious fraud investigation office, that we read under section 212. Okay, so first of all, section 210. Central government, if you feel that yes, it is necessary to investigate, you may pass an order of investigation. Okay, you may pass an order of investigation when inspection or inquiry or both happened and there is a report under section 208 which is submitted, and based on that report maybe there is a recommendation that investigation should be done, and in your opinion you consider it necessary, you may order investigation. You may not. Okay, then on receipt of SR by company, that means the company's members have resolved and they have passed a resolution that they feel that maybe there is some fraud going on in the company and they want you to pass an order of investigation. So you may, in public interest, you may. Okay. And lastly, if NCLT or court passes an order, then you must order investigation. So in these 3 cases, you may, but there is a mandatory order of investigation by CG if the court or NCLT has passed an order of investigation. Correct? Okay. Now we have section 213 where NCLT is involved. So NCLT on the application of members or on the application of any other person, you may pass an order of investigation, and in that situation you will not carry out investigation. You will tell CG to carry out investigation and CG must carry out the investigation. Okay, so section 210 I already told you, and let's come to section 213. Fine. Now, in section 213, people are actually approaching NCLT. that if I tell NCLT and if NCLT passes the order of investigation, then CG can't deny it and CG will do it, right? Okay. So as members, to go to central government, see, you have two choices. One, pass SR and go to central government. Central government may order investigation, or else, if you are at least 100 members or members with 10% voting power, and you have proper evidences and documents, you can make an application to NCLT. And if NCLT is satisfied of certain things, NCLT may decide about investigation, and then CG is bound to order investigation and carry out the same. Got it? Okay. So members, if your company has share capital, then these many members. If your company does not have share capital, then 1/5 of the members. They become the eligible members. NCLT. Members can also come to NCLT and other people can also come to NCLT. Other people can also come to NCLT, ma'am. What is that actually happening? See, maybe I am just the creditor of the company, or maybe I'm just one person of the company who has been supplying a lot of goods to the company but not receiving any payment, or the company has been taking a lot of advance from a lot of people but not supplying goods. So we are the ones who suspect that there is some fraud going on in this particular company. But where do we go? We want this fraud to be investigated because we can't do that. We have no option to go to central government, right? Because we are not the members. If we convince the members and somehow the members pass SR, then maybe we can go to central government. This inspection inquiry has not happened, and maybe in public interest government, it's very hard to convince, right? So we can't go to actually central government. So we can go to NCLT. Any person can make an application to NCLT. You just have to provide that evidence, and if NCLT is satisfied of these things, NCLT, after giving a reasonable opportunity of being heard to the company and the parties both, they will decide about investigation. And in that situation, CG has to carry out the investigation. Okay, so these members, along with supporting documents and reasons, you may send an application to NCLT, or any person make an application to NCLT or NCLT suo motu if satisfied of these things, any of these things, that maybe the business is being conducted to defraud its creditors or members or any other person. Like I told you the example, the company has been continuously taking advance from a lot of people by saying that we will supply you the goods but never actually supplying the goods, right? So in that situation, well, the company's intent is clear. It's trying to defraud us. It will one day run away with our money. It does not have the intention to supply the goods. Secondly, the company is actually formed for fraudulent or unlawful purpose. That means maybe there is some trafficking, or it is just a shell company. It has not been formed for a proper lawful purpose. Okay. Maybe it is working in a manner oppressive to members, that we read in the chapter of oppression. Okay, maybe the persons who are involved in management and formation, that is management and promoter, they are involved in fraud or misconduct or misfeasance. Misfeasance is negligence, misconduct is not properly behaving, not exactly the behavior but also your other things, and fraud is intentional or deliberate, malified intention, you can say, right? Then members have been given incomplete information about the commission paid to MD, director or manager. The remuneration that you pay, you have stated, but other than that, you're also maybe paying some commission and all that, linked incentives. That information you're not giving to the members. So if NCLT is satisfied of these things, then NCLT can do that, and then CG, you are bound to carry out the investigation. For that, you will be appointing the inspector who is going to report to CG. Fine. Okay, then we come to section 212, where we talk about investigation into affairs by SFIU. So maybe on receipt of report under section 208, CG finds that, oh my God, this is a serious fraud case. maybe on receipt of SR, maybe in public interest, or request from Department of CG or SG. If central government considers that yes, SFIU is necessary, they will assign the investigation to SFIU. When SFIU steps in, everyone steps out. So no other investigating agency, maybe the crime was also being investigated by some police authorities, maybe income tax department was doing something, right? They will also stop. Everyone is going to stop, because SFIU is a multidisciplinary organization in India which comes under Ministry of Corporate Affairs, where you have the experts from every field, multidiscipline, right? So it's not just that, okay, in income tax department, if they're investigating, if they are thinking about or scrutinizing any case, they have probably one field people. They can only look from the tax evasion perspective and not other ways. But when I'm talking about SFIU, you are dealing and trying to detect and prosecute those white collar crimes. So you have people from the field of accountancy, forensic, auditing, law. You may also have some people from money laundering, right? All that, they can detect things, right? So if SFIU steps in, then everyone stops. If they're already investigating, or it has been initiated, then they will stop and transfer all the records and documents to SFIU. So once the case is assigned to SFIU, in these cases, what will SFIU do? SFIU, you will just check that whoever is the appropriate investigating officer under you, then you will appoint those and they will carry out the investigation in the same manner. They have the same powers as the inspectors have under section 217. Everyone will give them assistance, and they also have the power to arrest under section 2126. Fine, you don't need to read all this in detail. I've already told you what exactly you need to read and what you don't need to read. Okay, thereafter, once the investigation is complete, you will submit the report to central government, and if the report talks about fraud or anything, any prosecution, anything, then central government may direct SFIO that you initiate the prosecution. There are students who are often confused about this term prosecution. It only means the court trial starts. If there is a crime which has happened, if there is a murder which has happened, do you think the police will catch somebody and then send him to the jail? No, that does not happen. So police basically prepares a report, and then the case is being filed. The charge sheet you file, that is in the common language that you know, right? So that is being filed, and thereafter the court trial starts, where you can defend yourself, and ultimately the court punishes, right? In the same way, SFIU, you are investigating, you'll prepare a report where you will tell about that this particular person is suspect and all that, guilty. Against that particular person, the prosecution starts. That means the court trial starts. Okay, and ultimately the court is going to the investigation report is filed here is under the special court for framing charges. Okay, now, next we have section 216, where we talk about the investigation into ownership of company. So far we have spoken about affairs, but many a times people hide behind the mask of their relatives. Like if I have a company, I may not be the director or member of that company, my relatives are. So ideally it doesn't look like my company, but all the decisions I am taking. So I am the one who has actually invested in the company. I have given money to them from indirect sources, and they have invested my money only. So I am the one who's financially interested in the company. I am the one who is actually controlling this particular company, and I am the beneficial owner of shares. Shares might not be in my name, but I am the beneficial owner. I hope you understand the concept of section 89 and 90 that we have read about: beneficial ownership and significant beneficial ownership. So many a times it happens that when we look at companies' register of shareholders, we may not find Mr. X's name, but he is the beneficial owner. The shares are in the name of some friend of his, but he's actually the beneficial owner. So ideally under section 89 and 90, you need to report and give the details that yes, you are the beneficial owner and all of that. But when you have not, through this section, we can find out the hidden beneficial owners. So who are the real who are really financially interested in the company, who are the real controllers, and who are the hidden beneficiaries? Government intends to find out that through the investigation. So if there is any complaint any person has done or reference by NCLT or CMO to central government may order the investigation into membership to determine these people. For this again CG will appoint the inspector who will investigate into the matters relating to company and membership and will finally give a report to central government. Okay, clear? Now, many a times it also happens that there is no formal understanding between two people with respect to the beneficial ownership or something like that. There is an informal understanding. So that can also be investigated. Undoubtedly, when the people are trying to hide their ownership, there will be informal understandings only. Fine. Okay. Next, we move to section 219, where we talk about investigation of related companies or related entities. See, um, if the crimes are happening, or you must have heard. In fact, we also discussed something about Satyam scam, right? So basically, what happened? People were trying to inflate the revenues by generating fake invoices. Now, supposedly, there's a company, ABC Limited, everything clean, all records clean, and ABC Limited has invested a good chunk in the shares of PQR Limited. So, almost the entire money in PQR Limited has been transferred from ABC Limited only in the form of shares, right? Now, in that company, they're trying to generate all the fake profits and window dressing, manipulating the accounts, this and that, right? And ultimately, they will pass on that benefit to the people who are involved and ultimately show that, okay, there were losses and this is round and etc. etc. So, a lot of manipulation can take place basically. What I am trying to tell you over here is that sometimes the fraud does not happen directly in the company, but the company does it through its people, through its entities, maybe through its subsidiary, maybe through the MD. So, by checking at the bank accounts of MD, we get to know certain frauds. It may so happen by any employee, through any employee or manager, right? Or when even when they are not direct holding or subsidiary, it may so happen that Mr. X, you are the managing director of A Limited also, and you are also the managing director of B Limited, right? So somehow you're doing this, or you have done some fraud through this. Maybe you are involved, or maybe the company is involved, whatever it is. So sometimes it may so happen that we are investigating because CG has told us, we're in, SFIU is investigating, or investigation is done by CG on request or on order of NCLT. Okay. During this investigator, whether it's the inspector or the investigating officer of SFIU, during this investigation, they consider it necessary that I also need to check the details of these related entities. They may. But after they take the approval of CG, after they take the approval of CG, then they may. So, whose accounts? Subsidiary holding, subsidiary of holding, MD, manager, employee, body corporate which is being managed by MD or manager, body corporate whose board includes nominees, and body corporate whose board acts according to the direction of the director. Okay, so they may do so. Next we have section 220, which is seizure of documents by inspector. Exactly what we have read about search and seizure in section 209. So that we read during inspection and inquiry. This is during investigation. So during investigation, if the investigating officer has reasonable grounds to believe that books may be mutilated, altered, falsified, then they may enter and seize and return after completion of investigation. Fine. Now, inspector, after you have completed the investigation, you are going to submit the report. That's going to be your final report. And if you are also required by CG, then you also have to submit an interim report. Okay. The report, copy of the report can be obtained by making an application to central government, and the report has to be authenticated either by the seal of the company or by the certificate of public officer in whosoever custody the report is. Okay, fine. Now, once the report is submitted to central government, you may take certain actions. Certain actions. What are the actions which central government may take? First one is prosecution. Prosecution means what? After the report, we came to the conclusion that, okay, Mr. X, who is a director of the company, has done some fraud and is criminally liable. So there will be court trial which will start against him, and everyone has to give that cooperation. Okay, that may happen. Secondly, there may be winding up. Winding up, why? Because once the report has been concluded, we get to know that there is nothing left in the company, and all the people who are involved, they are involved in some mismanagement, right? So this company cannot actually function properly for the benefit of anyone. So the company, now you don't know the provisions of winding up yet. We have a chapter under Companies Act which talks about winding up, but more importantly, the major chunk in the provisions of winding up have been shifted to IBC after it came, Insolvency and Bankruptcy Code, right? So maybe the company is liable to be wound up under the winding up, or under IBC, right? Or maybe the company is not entering into winding up. That means investigation is going on. Maybe the company itself has passed or is willing or voluntarily going for winding up. Fine, then winding up can happen. But supposedly investigation is going on, there is no winding up which was taking place, the company was functioning as it was supposed to, but based on the report, CG discovered that no winding up should be done. That is how this company should be treated. So now central government can't just wind up the company. There's a procedure. So you have to make a petition to NCLT, and thereafter winding up shall take place. Likewise, we also have an application of section under section 241, which we'll be reading in the chapter of oppression. Okay. So that can also be done. That can also be done. Next is the recovery of damages or property. The recovery of damages or property. There is any director or there is any employee, maybe they have taken the property of some company, not particularly this company, or maybe of some other company wrongfully, right? Or they have misapplied the property of the company. That is, there is the machinery, maybe that particular person has taken that machinery of the company, maybe they have done some embezzlement, maybe they have done some fraud, maybe whatever. So recovery of that damages, recovery of that property due to their negligence, there is a loss which the company has suffered, so that is being recovered. That can also happen. Next is this is disgorgement. What is disgorgement? Disgorgement is the recovery. Ma'am, recovery here also we are doing, but this is the recovery of undue, or I should say illegal gain. Illegal gain. Like the company had to sell the goods of 25 CR. The company or one of the director has actually sold these goods for 30 CR and made an illegal profit of 5 CR. So this is not a punishment, this is not a compensation, these are not damages, etc. But this is an illegal gain which they have done, and we now want to recover that. We now want to recover that. So central government can also pass an order for this. So if there is a report of inspector which states that yes, the fraud has taken place, and maybe there is some KMP, some officer, some director who has taken undue advantage of that situation and has taken some benefit, that recovery of benefit is called as actually disgorgement and can also be held personally liable. Fine. So when central government gets the report, these are the different actions which may be taken. That is, first is prosecution, second is petition for winding up or oppression, third is recovery of damages or property, fourth is disgorgement. Fine. Now, central government, you will be indemnified for the cost of investigation that we'll be reading separately in a section called as section 225. Next, we have powers of inspector. Only individuals can be the inspector. I hope you know that. Next, we have the powers of inspector, the procedure. It is exactly the same that we have read before in inspection and inquiry. So, during investigation, everyone, you have the power to call for information, and past or present officers have to preserve and produce the books plus provide you all the assistance. You also have the power to seize the books and keep in your custody for maximum 180 days. You also have the power to examine people on oath. You will have the same powers as of a civil court in respect of certain matters, that is discovery or production of books, summoning and enforcing of attendance, and inspection of books and documents. Fine. So for these three matters, you will have the powers as of civil court. The officers, police authorities, everyone will provide you assistance subject to your take CG's approval. This reciprocal agreements you can avoid, and that is it. Okay. Next, we have protection of employees. Protection of employees, section 218. Now, during investigation, many of the employees or officers might not want to cooperate with the investigation. Why? Because they're scared that if I tell something, if I provide a document, if I tell some truth, then I may be demoted, I may be suspended, I may be removed, right? Or my salary may be reduced, or I may be treated indifferently or badly. So, this particular section actually provides them protection. So, when the investigation is going on during this particular sections, or maybe there is some proceedings which are going on during this period, if you want to, if the company or any body corporate wants to, who is involved undoubtedly, wants to discharge or suspend the employee, you want to punish him by demoting, by reducing his salary, by changing the terms of employment to his disadvantage, etc., etc., then you can do this only after you obtain the approval of NCLT. Now, you have applied for the approval. The NCLT will not give you the approval instantly. They will actually send it by post. Now we are waiting. If they do not reply within 30 days, we can proceed and take action against the employee, because sometimes the employees, we genuinely want to remove this particular employee because he's not working properly, but because the investigation is going on, we have been instructed that during the proceedings of investigation, you cannot actually suspend, discharge, punish any employee except with the approval of NCLT. So we need to take the approval of NCLT. Now, maybe sometimes the employee is not satisfied, maybe sometimes we are not satisfied with the order. So appeal can be made to NCLAT. Okay, within 30 days. That's it. We also have a section called as section 225, the expenses of investigation. So expenses prima facie or at the first place will be defrayed by CG. Later on, it can be recovered by certain people. Point number one, whoever has been prosecuted. So you are the one who has been prosecuted. Okay. Secondly, it can be reimbursed by somebody who has been asked to pay damages or restore property because you took so. Okay. Somebody who has whose name has been got, like maybe there is a company of whose some property has been recovered, so that particular person can also be asked to reimburse. And if there is no prosecution that has happened, so whichever company, body corporate, MD, manager was dealt in the report of inspector, or the applicants who had insisted on the investigation, they will actually reimburse. So this is just to ensure, because CG is not going to bear the cost of investigation. Like, I am somebody who said that some fraud is going on in this company, and I tried to provide certain documents and I requested NCLT. NCLT passed the order of investigation. Thereafter, CG had to carry out the investigation. Okay, CG carried out the investigation, and at the end result was that there is nobody who's involved in any fraud. Nobody it did not end up in prosecution of anyone. So no prosecution was instituted. Right now, what will happen? This entire cost of investigation, who's going to bear that? The applicants. The applicants and whoever company MD was involved. Okay, they are going to bear that. In fact, when we submit an application, CG sometimes asks us, before even appointing the inspector, they may ask us to give us a security amount up to 25,000 to cover this cost, because later you might deny, later you might not, and the recovery is difficult. Okay, so that is how expenses of investigation are met. Fine. Okay. Let's now revise the chapter of compromises, arrangements, and amalgamation. Right. So basically, there are three terms which are given. This particular chapter involves and revolves around these three terms. Right. It's chapter 15 of Companies Act 2013, starting from section 230, going till section 240. Right. Now, arrangement is the term which has actually been given in an explanation, and it's a wider term than compromise. Right. When I say compromise, it is nothing but a settlement of a dispute or adjustment of rights. When I talk about arrangement, it is a much wider term. It includes reorganization of companies' capital, consolidation of shares. It also includes the merger, amalgamation, debt restructuring, everything. So, arrangement is something which is very wide. Okay, but when I say amalgamation and merger, that is a special type of arrangement and it has been segregated. Okay. Now, compromise or arrangement, basically section 230 talks about compromise or arrangement. However, the application of merger and amalgamation also begins with section 230 only, but has a dedicated other section wherein few provisions of section 230 get applicable even to mergers and amalgamations. Okay. So let's begin and we'll start with section 230. What happens in section 230? Right, if I'm talking about any compromise or arrangement, let's say the company has taken loan from a bank of worth rupees 10 crore and is now not able to pay it, right? So it wants to enter into some scheme of some arrangement with the creditors, something called as maybe debt restructuring, where they're planning to change the installments, defer certain payment period, right? Something, right? So this is a scheme of arrangement, okay, with the creditors. Can it be done just like that? No. You have to follow the procedure given in section 230, wherein you will be needing NCLT's approval. Just like there is a capital section for reduction of share capital where you need NCLT's approval, so your scheme may also involve reduction of capital, and in that case the provisions of that particular section need not be followed. Okay, now who can make this application? Members, creditors, liquidator, or company. Fine. The arrangement or the compromise may happen between company and its creditors or between company and its members. Okay, so application is made to NCLT. NCLT may reject the application or accept it. When you make an application, you have to attach an affidavit which is going to disclose certain things. Point number one, the material facts of the company, like the latest auditor's report, the financials of the company, any investigation or proceedings which is pending, right? If your scheme involves reduction of capital, then that. If your scheme involves CDR, that is corporate debt restructuring, then some more details, like the scheme should be consented by at least 75% of the creditors in value, then only you can propose it. It should also have a creditor's responsibility statement, right? What safeguards they are taking for other creditors, the report by auditor about the liquidity of the company, right? And all the CDR is in accordance with the RBI guidelines. If not, then the statement to that effect, valuation report. So all these details are going to be enclosed, are going to be there in the affidavit, right? Which is going to be attached along with the application that's made to NCLT. Got it? Okay, so you make this application to NCLT. Supposedly, NCLT has accepted the application. When NCLT accepts the application, then NCLT will order that, okay, fine, we will look into your application, but first you get the necessary approvals. You call the meeting of your members, creditors, get the approvals, right? You may, just a second. You also need to send the notice to some authorities like income tax, ROC, right, SEBI, RBI, if they have any objections, we'll look into that, right? So let's see that. NCLT will order to hold the meeting of the creditors, members, relevant class, whatever the case is, right? So, based on that order, you will be sending notice to call the creditors, members, debenture holders. You will send the notice individually to them. Notice will be accompanied with a statement which will contain the details of compromise, the copy of valuation report, the effect on creditors KMP, and effect on the interest of the directors. Other matters like investigation proceedings, the details of shareholding. If there is no objection which is there from the statutory holders, then that sanction, etc., etc. Where are you going to make the documents available so that any member who wants to inspect can come and inspect it? Where you'll keep the copy of compromise or scheme, right? What is the status of other approvals if need be, right? So all these details are going to be there, and then you will send the notice to your creditors members. You will also put a notice on your website, and if you are a listed company, you will also send it to SEBI and stock exchange, and they'll be later sit on their website also. Okay, apart from this, you also send the notice along with all the documents to central government, to RBI, to income tax authorities, to ROC, to SEBI, to stock exchanges, to official liquidator, to CCI if there is need be, right? So they can also raise objections within 30 days of receipt of notice. Fine. So one, you have sent the notice to these. Second, you have sent it to these. So meeting will be called, and in the meeting, voting shall take place. How voting shall take place? The members or the creditors who are present in person can vote. They can also appoint their proxies, or they can also vote through postal ballot. But we need the consent of majority plus 3/4 in value. So if we are talking about members, then 3/4 in value of shares. If we are talking about the creditors, then 3/4 in value of debt. So that is the consent that is needed. Supposedly we got that consent, so we will proceed forward. If we didn't get that consent, the scheme cannot be approved. We can't go back to NCLT. Okay. So it has to be, this approval has to be got, has to be obtained. Fine. Supposedly there are some 50-60 members who disagree with this and they want to raise objections. Well, you can, if you hold at least 10% of the shares, or if you're the creditor, you hold at least 5% of debt. So you are eligible to raise objections. But, if this much consent is obtained and tribunal sanctions the scheme, then it is going to be binding on the company, creditors, members, liquidators, contributories, even dissenting shareholders, dissenting creditors, everyone. Okay. So you can also raise objections, they can also raise objections. Tribunal will consider the objections and will make sure that they have got the auditor's certificate that yes, whatever accounting treatment you are going to do, that will be according to accounting standards only. So that is going to be AS compliant. So if that is ensured, and considering the objections, tribunal may sanction the scheme. Once they sanction the scheme, they will send the order to the company, and company will file it with ROC within 30 days. When tribunal has passed the order of sanctioning the scheme, they may also provide for other matters like the court order. Whenever court passes an order, it provides for other matters also many a times, that this is going to be observed, this has to be done in this way, etc., etc. So NCLT may also provide for additional orders like, if you are converting preference to equity, then preference shareholders will be given an option with respect to their arrears and dividend, that they might claim it in cash or in equivalent equity shares. Second, protection of the creditors. Third, if in your scheme you are varying the rights of shareholders, then that cannot be done just like that. You have to comply with section 48. Okay. Then if there are any BIFR proceedings, that shall end. If other matters like maybe exit opportunity or exit offer to dissenting shareholders, right, that has to be according to rule 27 that we have discussed. And apart from that, the buyback is going to be in accordance with section 68 and like things, right? Okay, so once this is done, it will be filed, and that is it,
right? Okay. Next, we move to section 231. Now, 231 gives the power to NCLT to supervise, because once they have sanctioned the compromise or arrangement, maybe everyone is doing what they want to. Nobody cares for what tribunal has ordered. So, are you doing everything in order? Are you being able to generate revenues as you promised? Right? So, NCLT has the power to supervise the implementation also, give directions at the time of making order and even later. Maybe at the time of making order, they have given an additional direction that you have to give me progress report quarterly. Or maybe later they feel that no, this company is not functioning properly. We are asking the company, I will ask the company to report quarterly. So maybe later on also you can give directions. You can also make modifications. Modifications hasn't changed the entire scheme, no. Minute modifications or changes which are needed to facilitate the implementation, that is it, right? Facilitate means to smooth, to ease up, right? And order winding up, not just plain winding up directly, but if NCLT feels that you are not able to implement that compromise or arrangement, point one, and the company is still not able to repay the debts and everything, then order winding up. Okay. Next is merger and amalgamation of companies. What is merger and amalgamation of companies? Now, it may be like A Limited is going to be taken over by B Limited. It may be like A Limited plus B Limited is going to become C Limited, right? So I have explained you what these two terms mean and how do they have differences and similarities, but that's not needed for the section, and that because the provisions are equally applicable to them. So let's directly talk about the section. If you have made an application under section 230 with respect to any arrangement where you're talking about merger, amalgamation, demerger, any type of restructuring, then this section hits. And tribunal will ask you to order the meeting of the creditors, members, or any class of them, right? And these provisions shall become applicable. Some provisions of section 230, that is 233 to subsection 6 of 230, right? These are going to be applicable. What do you mean by that? That means the company now, you have been told that you order the meeting and these provisions are applicable. So you need to send the notice along with the details. You need to call the meeting. You need to vote by proxy, by postal ballot. You need to obtain that consent majority plus 3/4. Objections can be raised, right? You need to put the notice on website, everything. So all the provisions that we have read, starting from sending of notice till according of approval, right? The same provisions of section 230 shall be applicable here also. But because this merger or amalgamation is a special type of arrangement, one additional requirement is here. And that additional requirement is to circulate the additional documents to the members or creditors when we are obtaining their approval. Okay? What is going to be circulated? What is going to be circulated? The draft of the scheme, the confirmation that the scheme has been filed with ROC, a report explaining the effect of compromise on shareholders, KMP, especially the share exchange ratio, because it's a case of that merger, right? And then valuation report, and also the supplementary accounting treatment. If let's say we are talking about this merger in December, so the last drawn up accounts are March, so it's already been 8 months. So we have the financial position of the company 8 months ago. We need that latest, right? So supplementary accounting statement. Okay, fine. So all these details, all these additional documents will be circulated. Once all these conditions are satisfied and complied with, NCLT ensures of the same that you also submits an auditor's certificate that the accounting treatment will be AS compliant, right? So after that, NCLT may sanction the scheme. Once NCLT sanctions the scheme, it will send the order to the company, which is going to be filed with ROC. If the implementation of scheme is going to go long and long and long, every year you will file a statement of compliance with ROC within 210 days from the end of financial year. Okay. Now, just like we have read before, here also NCLT's order may provide for many matters. Like what? First is transfer of undertaking. What is this transfer of undertaking? So here we have a concept called as appointed date. What is appointed date? A date from which the scheme is going to be effective. Like you fix a date for marriage from this particular date, and after these rituals are performed, the people will be called as husband and wife, right? So that's mutually agreed between the parties. This is also mutually decided between the companies. So they fix a date that from this particular date will not be you and me, will be us, right? So they have decided that. NCLT may differ from that, but they have to record the reasons and then only they do that. Otherwise, the date which is mutually decided is going to be the date on which or from which this transfer shall be executed. So first is transfer of undertaking. NCLT is saying that from this particular date, all the assets, liabilities, whatever is decided is going to go to transferee company, right? So now this is going to belong to you from this particular date. It's like automatic transfer. We don't need to do anything else. Second is allotment. So it may provide for allotment of shares, debentures, right? So it has to be done accordingly. Okay, and when you allot the shares, if it happens that okay, that company is holding your shares and that company is now me only, so I can't hold my own shares, I need to cancel it, right? Continuation of legal proceedings, that now legal proceedings will now be continued against the transferee company. Dissolution without winding up. Dissolution is removal of name. Winding up is selling of assets to pay off the liabilities. So now if you have to give this house on rent, you need to first clear the furniture and then you give it or sell it, right? If the house is already empty, you can give it directly. That means you don't need winding up because everything has been transferred to the new company and this company is already empty. So you will straight away dissolve this company. Fine. There may also be made provision for the dissenting shareholders who did not agree, right? Then some shares might be held by some non-resident under FDI guidelines or so. So in that case, the share allotment will happen according to the manner specified in that order of NCLT. We had very old merger, you can say, Ranbaxy and Sun Pharma. So all the employees of Ranbaxy actually became the employees of Sun Pharma. So the transfer of employees can also take place. Now just tell me one simple thing. If a person is a CMA, let's say the girl is CMA or the boy is CMA, let's say the girl is CMA, right? She gets married to a boy who is a non CMA. Will this marriage make this boy a CMA? Well, no. If this used to happen, everyone would quit studying and actually start marrying, but this is not the case. So, if a listed company is being merged to an unlisted company, do you think this becomes listed? The answer is no. It will remain as unlisted only, right? The fee which is paid by the transferor company can be adjusted with the fees of the transferee company if they want to increase the share capital, and other matters can also be provided. So NCLT will again ensure that yes, they get their auditor and then they'll sanction the scheme, right? Okay. Next is section 233. 233 is again merger and amalgamation, but of certain companies. So this is a route which is not available to all the companies, but specific companies, basically because the government considers it to be low risk mergers, right? Easy, simple mergers. So if there are two or more small companies or holding in its wholly owned subsidiary or prescribed classes, that is two or more startup companies or one or more startup with another small company. So if you fall into these cases and you're going to merge, you want to amalgamate, then this is applicable section for you. You get a fast track route. You get a fast track route, that is, you can do the merger and amalgamation without NCLT's approval, but you need to file it with CG, right? So you will be sending notice to some people, official liquidator and ROC, to seek their objections and all of that, right? You get the approval of creditors, members, that's needed, right? And you go to CG. CG will register the scheme and then you're done, right? So it's as simple as that. So transferor and transferee company, maybe one company is in UP and the other company is in Rajasthan. So you have a different ROC and official liquidator, that is the officer of High Court, and you have different ROC and official liquidator. So both the companies are going to file a notice. And with your ROC, you will also file a declaration of solvency, right? Now you have filed a notice with them. They have every right to make objection within 30 days. Fine. You will consider the objections and you will get the approval of shareholders within 90% of shares. You will give the notice to the creditors, at least 21 days notice, and you will get the approval of the creditors, majority plus representing 90% of value, right? So here you need twin condition is stated, right? Once you get this approval, within 7 days, the transferee company will file the scheme with CG, ROC, and official liquidator. Again, okay. Now, CG has to register the scheme, but CG will see, is there any objection which is made by your ROC or your ROC or your official liquidator or your official liquidator? If no objection is made, CG is going to register the scheme. CG will give the confirmation order to the companies and the transferor company will be dissolved, and the scheme is filed, right, and executed, implemented, right? But if there is objection which is made by the ROC or official liquidator, then what will happen? Then central government gets scared and they say that, okay, objection is made, but I find it fine, they can still register the scheme. But if objection is made and in the opinion of central government it is not in public interest, then within 60 days you will hand it over back to NCLT. Not back, but hand it over to NCLT and ask NCLT that you continue this under section 232 like you do for all your normal mergers and amalgamations. So you consider the scheme under section 232. Now NCLT again has two choices. Either they can confirm the scheme, they find everything okay and they confirm the scheme here only in this section, or they consider it under section 232 and in that section they pass the order accordingly. So they can do whatever they feel like, right? Okay, so I hope this is clear. Right, now once the scheme is registered, then the transfer of all the properties and liabilities to the transferee company shall happen. The charges will now be enforced against this company. The legal proceedings will be shifted. And if there were some dissenting creditors or shareholders who have to get the payment done because they are not going to become the shareholders of this company, well, the payment will be made by this company, new company, if not yet made. So you become the creditors of the transferee company. Okay, fine. You will cancel the shares, the fee can be adjusted, and all these points that we have read before also. Moving to the next section, that is section 234. Again, a section of merger. But now we are talking about the cross-border mergers. Cross-border mergers. Yes, maybe we want to become we want to be absorbed into a company incorporated outside India, or that company we want to absorb within us, right? Company incorporated outside India, that is what we mean by foreign company for this particular section. So all the provisions that we have read from 230 to 232, you'll follow the same, but you will also be needing RBI's approval. So that is the additional thing. You also need RBI's approval, right? So if they also want to absorb us, then also RBI's approval is needed. In fact, they have to follow that the valuation that they are getting done, they have to do it with the register, they have to get it done by the registered authority and following internationally accepted valuation standards. Then make an application to RBI for that approval along with the declaration that you have done the valuation correctly, and then RBI will grant you the approval. Okay, once you've got the approval, then only you can proceed with such merger or amalgamations. Okay, now apart from other things, in your scheme of merger or of cross-border merger, the consideration may be paid in cash, in depository receipts, or a mix of both. This will be written in your scheme. This will be a part of your scheme, right? I have also told you, although we talk about section 230 to 232, I've also told you that recently the government had allowed this fast track merger route for reverse flipping merger. So I've explained you that, just keep that in mind. Okay. Next, moving to section 235. 235 is about getting some power to acquire the shares of dissenting shareholders. Now, this has to be differentiated from 236, wherein wherein once you become the shareholder of 90% shares, you get the right to purchase those minority shareholding. That is given in section 236. But when we talk about section 235, maybe you are in the process of acquiring shares. You have proposed a scheme of transfer of shares. So you have proposed a scheme of transfer of shares, like this is one company and this is another company. You want to buy the shares of this company. That means all the shares you want to buy. So you propose a scheme to these people. The board of directors like the scheme and they will recommend it to all the shareholders, but ultimately you have to buy the shares from the shareholders only. So here what is happening, it's not a case of normal merger that all the assets and liabilities we are buying, I'm issuing the shares of my company to the shareholders of this particular company, so this is transferor company, I'm transferee company and all of that. No, I'm only buying the shares. It involves only the transfer of shares. So wherever the scheme involves the transfer of shares, I have made an offer to these shareholders that I want to buy your shares at this particular price. The offer remained open for at least 4 months. They may accept it, they may reject it. Supposedly they accept it. Maybe everyone has accepted. Fine, great. Nothing is more is needed. Maybe only 40% have agreed. This section does not get triggered. Maybe 90% have agreed. That means I proposed an offer and 90% have agreed. So 90% of the shareholders of that company are ready to sell their shares to me. But there are some people who disagree. In that situation, I get a right that within 2 months, I can send a notice to the dissenting shareholders that I am anyway taking your shares. They have a right to apply to tribunal within 1 month. If they apply, then I will wait till the apply is dismissed, till the appeal is dismissed. If not, then after this 1 month, I will send the notice to this transferor company that I send the notice to your dissenting shareholders. I will give the transfer deed that now you transfer all the shares in my name. I will also give the consideration to be paid to your shareholders. So now they will register all the shares in my name, right? All the shares in my name. Within 1 month, they will inform all these dissenting shareholders that these shares are no more yours and we have got the money. It is going to be paid to you within 60 days of receipt of money and it will be deposited in separate bank account when I give it to them. Correct? Okay. So we have another section called as section 237, again amalgamation. Yes. But here we are talking about mergers and amalgamations in public interest. So CG has the power. Maybe there is a bank which needs to be amalgamated with another one because it's not performing well, and in public interest, they feel like that, doing that, right? So basically, CG, you will draft an order of amalgamation, you will send it to the companies involved. They will have 2 months to object, company creditors, members, right? And if their rights are getting less in the new company, then also compensation will be assessed by the authority. If the compensation you're not satisfied with, you have every right to make an appeal within 30 days, right? CG will consider the objections and suggestions, make necessary modifications, and give the final order in the official gazette, which is going to be laid before both houses of parliament, right? Okay. Now, one more section that we have is section 238. 238 relates to 235 only, which talks about that if transferee company has given offer to the shareholders of the transferor company, you must have given some document, offer document. Now you can't just promise anything and not deliver something, right? So whatever offer document you have to register with ROC, right? It has to contain certain details. You have to register with ROC, board recommendation and everything. And if ROC does not register, if ROC rejects that, no, I'm not going to register because it does not have adequate details and everything, you can appeal to tribunal if you want to, right? But without registration, you are not going to proceed to make this offer. Okay, so section 238 basically talks about registration of this circular, right? Okay, thank you. Okay, let's now revise the chapter of prevention of oppression and mismanagement. A very small chapter, chapter 16 of Companies Act 2013, starting from section number 241, going till section number 246, right? So ideally, we have roughly only 5 sections to read. The sixth one is not exactly a full-fledged section or anything like that.
So, when we begin and when we talk about the terms oppression and mismanagement, they have to be understood, right? Okay. But before we actually go to understand the terms of oppression and mismanagement, one very important thing that has to be known and that has to be understood is the majority rule. What is majority rule? See, majority rule is something that prevails not just in companies but everywhere. If there is a room of 10 people and you need to come to a decision, it cannot be all 10 people agreeing on the same thing. Someone might disagree. But does that mean that we can't proceed with that decision? We can. Because majority agrees. So it is quite obvious that when you want to run a company, you have to take a number of decisions, and all the decision making takes place through majority only, right? So anyone who has the major number of shares has the control of company, right? He has the control of the company, and that is basically the principle of democracy that has been here since ages, and it was basically established in the case of Foss versus Harbottle. So we have a case law wherein some people, there are two shareholders basically who alleged that these directors of the company have misapplied certain company's property. The court rejected their plea on two grounds. Ground number one, that they have misapplied company's property and not yours. Company is a separate legal entity, it is not you. So you are separate from company and you can't initiate that legal action because harm has been done to the company. Point number one. Point number two, the decision was lawfully taken by majority, and every now and then company takes n number of decisions on the basis of majority rule only. So every now and then if I have a problem, oh my god, company has entered into this particular contract, no I disagree, company did not declare dividend, no I disagree. So every now and then if people disagree and they move to the court, there would be endless litigations and no problem solving. So that is why court clearly established in this case that court is not going to interfere in the internal management and it is going to be run according to majority rule only. But then there comes certain problem because people at times could abuse this majority rule. Like what, ma'am? Like maybe the ones who have majority shares are making and taking all the decisions in their own favor and somehow harming the people who have lesser number of shares. Maybe, right? Like, for example, the majority shareholders, the ones who have majority shareholders, they have appointed themselves as directors. Can they? Yes, because the power to pass OR, SR, everything is with them only. So they appointed themselves as director or their own choices as directors and also approved that remuneration and everything, right? So they're getting very heavy remuneration. The company is earning profits and it's being paid to the directors in the form of remuneration. The minority shareholders are just sitting and idly watching because they're not even being getting any dividend or anything like that. Company doesn't want to declare dividend. It's routing the traffic through remuneration and taking it. And this has been happening for years and years and years. Now, what do these minority shareholders can do? Do you think it is fair to them? No. That's what oppression is called. So basically, when the general rule is that majority rules, but even the minority or even the minority shareholders can take certain actions to stop this. Maybe that's not fair, right? Certain actions under common law and then certain actions under Companies Act. So under Companies Act, we have different thing and this is something different. So first thing that you have to remember is what is majority rule, and then secondly, actions which may be taken by shareholders in common law, or you can also call this as exceptions to the majority rule. If the company is entering into any act which is ultra vires, then one shareholder can also go to the court and obtain a stay order that this company cannot enter into something which is ultra vires. If there is any fraud which is done by on minority, if the wrongdoers in management actually control the company, wrongdoers in management, that means the directors who are managing the company are managing it in a rubbish manner, right? They can be removed by the shareholders, but they are the only ones who are controlling the company also, because they have majority of the shareholders. So we can't even remove them, right? So how will we take action, and how will we reach the court? Because they will not allow us to sue them on behalf of the company, because they are in control of the company also. Next is, sometimes act requires some special resolution, and that act has been passed, that the provision, that resolution has been passed just by simple majority. So is it correct? No, it's not correct. So in such a situation, an individual shareholder, you have the right to go to the court and stop the company, restrain the company from doing so. Personal actions by shareholders. Shareholders undoubtedly are conferred with many rights, like right to dividend, right to vote, etc., etc. So if they are deprived of any right, unnecessarily they're not getting the right to vote. So if you're doing so, we can approach to the court. Breach of duty, right? Minority shareholder, you can bring action against the company where there is breach of duty by the director. So these are the general remedies which are available under common law. Now, we also have Companies Act, wherein certain minority shareholders get a lot of rights. We have read it over different sections, right? Like if we talk about appointment of directors, we have read about SST. SST is what? Somebody who is not owning a lot of shares, small shareholders, right? They have a right to elect one of their directors. Correct? Okay, we also have read something about e-voting. E-voting is what? Even if I'm not able to participate in the decision making every time, why? Because I'm not able to walk to the meetings, I'm not able to devote that much time, effort, energy needed. So I have this remote e-voting facility also, where I can every time register my vote. Correct? We have section 188, where if the company is entering into a related party transactions, then that has to be approved by the members, and the related members cannot vote. So it's ultimately us who are not related, who are kind of minority, they are approving their transactions. Correct? We have a beautiful chapter 16, prevention of oppression and mismanagement, right? We also have the previous chapter that we read, reconstruction and amalgamation and compromises. So we have section 235 and 236, where minority shareholders get certain rights to apply to NCLT when their shares are being acquired, right? So in that cases, so all these provisions are available under Companies Act. Okay. Oppression, my dear, you have to remember four basic things about oppression. Wherever any case study is being asked as to decide whether this is a case of oppression or not, you need to judge it on four basic parameters: visible departure from fair dealing, capacity as a member, continuous process, harsh, burdensome, wrongful. Okay. So, any act, or if the affairs of the company are being conducted in a manner which is prejudicial to the company, or prejudicial to public interest, or prejudicial to members, then that's actually oppression. But it should be in the capacity as member, it should be a continuous process, it should be harsh, wrongful. Got it? Okay. So, now we have these sections. Anyone who is eligible under Section 244 can make an application under Section 241. Tribunal passes an order or many orders under Section 242, and thereafter we have the post effects under Section 243. Okay, we also have an aloof section, Section 245, which talks about the class actions, right? Okay, so let's now begin with section 241. But to start with section 241, we actually need to know who are the eligible members under section 244 who can make an application. Cut to, let me tell you one thing very straight. Although majority rule is there, but if, now forget what minority shareholders can do under common law. Forget it. What you can do under other sections of Companies Act, that also forget. Now we're starting with chapter 16, right? So we are only going to talk about this particular chapter and what actions you can take in this chapter. So if you are a minority shareholder, right, and something continuous harsh acts have been happening to you, right, in the capacity of member, you are suffering, then you can apply to NCLT for seeking relief from oppression and mismanagement, and NCLT can pass various orders. But can one member go and raise that complaint? The answer is a big no. You have to be those eligible members. Who are eligible members? Come on, let's see that. So who are eligible members? We come over here. Members, if the company is with share capital, then 100 members or 1/10 of total members, right? Okay. That is one criteria. That is one criteria on terms of on the basis of number, lower of these two, or in terms of value, the members who are holding at least 1/10 of issued share capital. Please be very careful while you are writing answers for this particular section, because this is a very commonly asked question. And here we don't write paid up capital, it's issued share capital. Okay, it's issued share capital. If the company is without share capital, 1/5 of the total number of members. So this is the requirement. Now let's say, ma'am, 99% of the shareholders or 99 shares are being held by that majority group and I have just one share, I'm just one shareholder, right? So don't I get any chance to make an application? Well, if operation is happening well, NCLT may permit lesser number of members also. If you make an application to them, they can waive this requirement. Okay, so that is also an option available. Now, if you are making this application, you should have paid all your calls. If you are not paid your calls, then you're not eligible to make an application. So these members are eligible to make an application to NCLT. Likewise, CG is also eligible to make an application to NCLT for seeking relief from oppression or mismanagement. Okay, now let's say there is minimum requirement of 100 members or 1/10 of total number of members. Let's say in a company there are 800 members, so 1/10 comes out to be 80 or 100, whichever is lower. So 80 become eligible. Now 80 members have actually filed the application, but later on 5 members withdraw it. So 75 left. Is it valid and still maintainable? The answer is yes, because you need this requirement only at the time of filing of application and not later on. Not later on. Okay? Okay. So now we come back. Now, eligible members who are eligible to make an application, that we have already got to know. Now, any member, if you are eligible and you complain two things. You complain of oppression or you complain likelihood. Oppression means what? If the affairs of company are being conducted in a prejudicial manner to public interest, prejudicial to members, prejudicial to interest of company. So this is called as oppression, which I have explained you like in absolute detailed manner in the class, right? And then second is the likelihood. Likelihood means what? Maybe overnight this entire Ambani shares have been sold to another group. So there is going to be a change in the majority shareholders. Yesterday the control was with this particular group, now the control is with this particular group. Fine, that is absolutely normal. There could be a change in directors, there could be a change in shareholders. What is the problem? The problem is that it is not in the best interest of creditors, shareholders, or debenture holders, and there's likelihood, there are very high chances that affairs will now be conducted in a manner which is prejudicial, which may be harmful to public interest, which may be harmful to the members or any class of members, you can say. Fine. So these are the two cases. If there is any member who meets the eligibility criteria as mentioned under section 244 has this complaint, they can make an application to NCLT. Now NCLT, an application is being made to you, right? An application is being made to you. Now you are of the opinion that yes, the affairs, there's a problem. And winding up would be unfair. Winding up would be unfair. Winding up is just, but it would be unfair. That in normal situations, I would have wound up the company. But because if I wind up the company, it would not be fair for the members, right? For the shareholders, for other people, right? So I cannot do winding up. I will pass other orders to revive the company. Okay? To better the company. Right? So tribunal may pass orders as it deems fit. Whenever tribunal passes the order, within 30 days, the order has to be filed with ROC, and thereafter we have the consequences as given under section 243. Now the question is, what orders can be passed by NCLT? What orders can be passed by NCLT? That, of course, we get in section 242. So section 241 tells us who can, section 244 tells us who can apply, section 241 tells us when can you apply, right? And section 242 tells us what are the powers of tribunal, section 243 what are the consequences. Now section 241 has yet another aspect to it. What is it? In fact, I wouldn't say just section 241, but it is a whole chain of section 241 followed by the order under section 242 and followed by the consequences given under section 243. So what another thing can be done is the CG's power to request inquiry to NCLT into fit and proper person. So if CG feels that any person is engaged in fraud or negligence, or maybe the company is conducting the business, the person is conducting the business not with the sound business principles, or maybe it is being conducted in such a manner that it could cause serious injury to trade, industry, right? Or it is conducted with an intention to defraud the creditor. So whoever is the person involved, it could be the director, etc., right? MD, whatever it is. Now CG feels that whether this particular person is fit and proper or not to be as a director. So CG in that case will initiate a case and request NCLT to inquire into the same, right? Okay. Now NCLT, along with the concise statement CG gives that, now NCLT will pass an order whether he is fit and proper or not under section 242, and if he is not fit, then he will be removed, he will be disqualified for 5 years, he cannot be connected with the conduct or management of the affairs of any company for 5 years, and he will not be entitled to any compensation. That is the consequence that we get under section 243. Okay, I hope that's clear. Now we come to section 242, that is passing of orders. So tribunal has received an application under section 241. Now tribunal feels that yes, the company's affairs are prejudicial and winding up would be fine, would be just, but to wind up the company, it would unfairly prejudice the members. So NCLT will pass other orders apart from winding up, right? What orders can it pass? First is regulation of conduct of affairs of the company in future. Whatever you have done, you have done. Now in future, you have to do it this way. Maybe you have to hold these many board meetings or something like that, right? Then there is a deadlock between the members and these are oppressed, these are doing this. So you buy the shares. Either the shares will be bought by these persons or by the company that may be ordered, right? Now, if the shares are being bought by the company, that means it is buyback of shares, which has to be followed by consequent reduction of capital. So accordingly, that can also be done. Then maybe you are transferring or you are allotting the shares to your one majority group only. So restrict allotment. Or maybe transferring, buying shares from some people and increasing your stake. No, restrict transfer. So that order can also be passed. Then termination or setting aside or modifying your agreement, that is company's agreement with the director or with MD or manager, right? Okay. Termination, setting aside or modification of company's agreement with any third person after giving him a notice and his consent, then that can also be done, right? Now supposedly you have an agreement with your managing director that we will pay you a salary of 5 lakh, and based on the circumstances you feel they are unnecessarily drawing very high salary, not doing actually any work, so you have modified the agreement and made it 1 lakh. Right now that particular person is suddenly demanding that these damages have to be paid to me. So it has been clearly stated in section 243 in the consequence that if NCLT terminates or sets aside or modifies any agreement, then you will not be entitled to any claim or damages or compensation for loss of office. In fact, if your agreement is terminated, then for 5 years you cannot be appointed in the company as MD or manager or director in the company, right? Without NCLT's permission. Okay, so that is the consequence that we see. Fine. Okay. Now, there is something called as fraudulent preference. Fraudulent preference means preference given to the creditor with an intent of fraud. Like maybe the company, you know that the company will be wound up in a couple of months, so you have already paid to a specific creditor who you know, right? So that is giving fraudulent preference, and that often it is reversed when we go through that IBC, right? So if there has been any transfer of money, or maybe delivery of goods, or any payment, transfer of property, anything like that within 3 months before this application, right, which if this was an insolvency case would be deemed as fraudulent preference, then that same transaction can be set aside by NCLT here also. NCLT can also remove managing director, it can remove the manager or directors of the company. Once it has removed, maybe it can direct the manner in which they will be appointed, and it can also appoint its own directors who will be reporting to NCLT, right? So this can happen, this can happen. Then we have imposition of cost also, and other matters as may be specified. So these are many orders which may be passed by NCLT. Once NCLT passes the order, it has to be filed with ROC within 30 days, and that is it, I think so. There's penalty. Right, now we have consequences, which I have already told you that you'll not be entitled to compensation, disqualified for 5 years from appointment, right? In both the cases, the consequence of fit and proper person also, and this way also, right? This is something that we have already discussed. Now, okay. Yes, here this is also something that I have already discussed. In opinion of CG, any person who is guilty, CG may initiate a case against him, application to tribunal to inquire into fit and proper person. So we have discussed this. And now we have something called as class action application. Class action application. Who are the eligible members who can make this application? If the company is with share capital, then 100 members or 5% of number of members on the basis of members, or if you are holding share capital, issued share capital. If it is a listed company, 2% of paid up share of issued share capital, unlisted company 5% of share capital. That means if I am a member and I want to make a class action application, so I have to accumulate either 5% of number of members or 100 if I talk about a number, or maybe if I am holding 0.5% of issued share capital, I accumulate like 50 other people, and together our shareholding is 2.5%. So are we eligible? Yes, we are eligible. If we are depositors, see, depositors can't make an application under section 241, right? But depositors can make a class action application under section 245. In the class, I have clearly stated you the difference between section 241 and 245. So please don't be confused and keep in mind the points so that you can actually relate which section the question relates to, right? So, okay. So eligible depositors, 100 depositors or 5% of depositors in number, and if I take on the basis of value, depositor who owes 5% of total deposit. So you fulfill or you meet any of the criteria, you can make an application. So eligible members or depositors, you make an application to tribunal, right? Tribunal will consider certain factors and may admit your application or may reject it. Once it is admitted, they ask you to give public notice in the newspaper, website, everywhere, to all the members and depositors, and there will be one single application only. All the running applications will be consolidated into one. No two class applications are allowed, and the application will be with the lead applicant. If you're able to decide who the lead applicant is, great. If you're not able to decide, then NCLT will decide for you, and NCLT's order is going to be binding on everyone. Now, what orders NCLT can pass and what are the factors which they consider before passing, before admitting the application? The members should, a member or depositor should have submitted the application in good faith. Is there any evidence that other than director somebody may be involved? Then is this application your personal one? Like, mean you can pursue this case in your own right, or it is a collective harm, right? Any evidence that or not exactly any evidence, of course it is with evidence only. What are the views of the members or depositors who are not interested in the application? Like in general, we want to know the view. If there is a classroom and there are 1,000 students, there are 300 students who had a fight, right? So they're asking
for a remedy to me, right? But there are those 700 students who are actually sitting in the class. So I wanted to ask, what is your opinion? What actually happened? They said, yes, some wrong was done to them. So now their case is more strong. So I got to know the views of independent people also, right? Then what is the likelihood that your action can be ratified, right? So I have explained you these points in the revision class. It's not possible to like give you an example and explain you it in detail, right? So these are the factors which may be considered, and then you get certain remedies. Remedies like what? If you go to NCLT, NCLT can stop the company from doing something ultra wise, that is restrain from ultra wise, restrain also from committing breach of AOA or MOA. Then maybe you have passed a resolution and altered your articles or memorandum, but you have given wrong information to the shareholders, and thus they have passed the resolution for alteration, right? Now NCLT will declare that this particular alteration is void. Okay. Or NCLT will also say that you can't work and you can't act on this particular resolution because this resolution is void, right? Okay. Also stop the company from doing any unlawful activity, stop the company from doing something which they're not permitted to because a resolution has been passed by the members. Also help in claiming damages or compensation from the company, from the directors, from the auditor, from expert, from consultant, if they are involved in any fraudulent conduct, unlawful conduct, or they have given any misleading statement, right? And other remedies as may be obtained. Okay, fine. Okay, this section is undoubtedly not applicable to a banking company. Fine. Okay.